I personally live in a FEMA-designated AE flood zone. I understand what that means, just as someone who lives along the Gulf Coast does. My property, like many others, was reclassified as part of a floodway on August 10th, 2021. Before that, it changed in 2014. Before that, 1997. My home was built in 91 on ag land. It remains on ag zoned land today. It was permitted and constructed 6 years before the 1997 floodway changes came into place, long before restrictions. At that time, it exceeded base flood elevations required under NFIP rules. It exceeds that elevation even with today's flood maps. Having a home built like this or at this time is not unique to my home in this county. There are legacy homes and post-revision permitted properties along this and other natural systems that have been gradually impacted by FEMA flood map changes caused by rezoning and subsequent changes to the topography. Development alters water flow and stormwater behavior, and we're seeing that reflected more frequently and with larger zone reclassifications. We continue to see development projects get approved even when they push or reshape the flood boundaries. How is that okay? How is it okay to suggest that property owners like me are at fault for buying, inheriting, or remaining on our land? SwiftMud reports clearly attribute the increased to increased flooding and urban development. I know I'm running out of time, so I'll just read from you that Gamble Creek Watershed report that covers 55 miles, reflects a rapid growth. Can I finish this statement? It reflects that rapid growth, especially after Hurricane Ian, showing how urban development has significantly altered flood behavior. That is right from SwiftMud. So they're clearly saying urban development has heavily altered stormwater runoff and floodwater behaviors.
All right,
Thank you.
thank you. Any other public comment on future agenda items?
Good morning, my name is Mark Hopkins. I'd just like to, on the same topic, reiterate that I live in Parrish at 15051 County Road 675. My son-in-law and my daughter live in a house that was built in 1909. It was flooded last year for the first time with 22 inches of water in it. And that just speaks to, it's above the flood zone by 5.5 inches, but 22 inches of water. They've made plans on how to evacuate should this happen the next time. And my daughter wasn't here today to help represent this because my granddaughter's sick, and I'm not as prepared as the gentleman who just spoke. But on a personal note, that more building and less room for water runoff, and again, they have contingency plans to help take the 3 horses off the property. And they only had like 45 minutes the last time this happened last year. And there's a great fear that this will just happen again. And that's all I have to say.
Thank you. Is there any other public comment on future agenda items? Seeing none and nobody's on the phone, I will close future agenda items. We'll move on to consent. Commissioners, are there any items you wish to pull from consent?
Yes. Like to pull number 6.
I just need a clarification before I pull. What does the word deferred mean in front of 4?
Deferred means it will be rescheduled for a different date.
Okay, so they're asking for a continuance now.
It's not technically a continuance because it's not an advertised public hearing, but it's similar in nature. So,
Okay,
yeah.
so we won't be voting or taking any action?
Correct.
Okay, thank you. I don't need to pull it.
All right, so. Were you saying something?
I can't put myself on the board, so I don't know how you want to do this.
Yeah, no, you just have to, we're just gonna have to shout out, I guess.
Okay, I'll pull 5 and 7, just so I can vote.
All right,
No need to have a discussion on it, so.
so we're pulling 5, 6, and 7. Are these strictly for votes, or should people be, so people can be on the record before the state disallows this to happen? Or do we want full presentations, just so I can be aware for staff purposes? Because Commissioner Bearden asked, just because he wants to have a separate vote for them. So Commissioner Feltz, I'm asking you, do you actually want a presentation on this plat? Or are you just pulling it so you can vote differently than the rest of the consent? I'm okay either way, I'm just asking for clarification for staff and for the applicant.
I have some questions
Okay.
on the development.
Okay,
I'd like to
so
make
we're
some
pulling
statements
items
on.
5, 6, and 7 with the anticipation of opening up 6 for discussion. I will.
Can we respond to future agenda comments for a moment?
Oh, sure, go ahead.
Thank you. I just wanted to respond to some of the items that were brought up under the future agenda items. As you may be aware, a few years ago, I proposed a Rural Lands and Citizens Advisory Committee. And these are some of the reasons why, exactly what we've brought up under the future agenda items that could have been addressed. And I would like that to still be a consideration. And some of those things are that just the issues that we're having now with the flooding, with the quality of the roadways out there. I would hope that the board and the public has had an opportunity to review the traffic studies. We had a wonderful report the other day on Tuesday. We didn't get into much detail with it on the board, but if you read that report, even as our board said, it was a really great report on our traffic issues. And most of those traffic issues that we're having are on the same stretches of highway that we are going to be discussing and working on some of those proposed projects. So I want that to be correlated. Otherwise, we spend a lot of money on a traffic study that we're not paying any attention to. There's a lot of things that are handled that have a different way of being handled in a rural area that I believe this could be addressed. We have different issues under hurricane conditions. We have different issues with our garbage conditions. We have a diversity out there in District 1, which is larger than the rest of Manatee County combined. So our resources will be stretched if we're doubling the size of the county services. So I just wanted to mention that and promote it again. And the people who live out there are also in need of this so that we can address the issues that are unique to the rural area. Changing agricultural land to Res 9 is very different than infill. And we're going to be talking later on about some ways that we could get involved and how our builders will also be getting involved with this, so we have a better plan for the development in District 1 than we've had in the past. Thank you.
I'm being told that OnBase may be up and running, so as we're continuing on, you can check that out, see if it works. Okay, I am opening up citizen comment for consent agenda items only, and that is strictly items 1, 2, and 3 on the consent. If you have comments on items, 4 is being deferred. 5 was pulled. 5, 6, 7 were pulled. 4 is being deferred. It's 1, 2, and 3. I'm opening up citizen comments on consent items 1, 2, and 3 only. Are there any comments? See, no. This is on items 1, 2, and 3 of the consent only.
Okay, let me Teams them.
Good morning, Dalton Nelson, Manatee County. Like I said, I'll make this quick, but I just wanted to comment specifically on item number 1,
He's out of the office.
which should be the denial of the Oaks at Rutland Ranch, if I'm not mistaken.
Mr. Chair, excuse me.
I'm sorry. These are quasi-judicial because we didn't expect comment. If you're going to speak about anything today that's just for the sake of argument, anything today, please stand up and get sworn in, and that's inclusive of this item.
Anyone plans on speaking today? Do you swear or affirm that the factual statements and representations you're about to make to the Board of County Commissioners are truthful and accurate?
Let me start over. Dalton Nelson, Manatee County. Yes, I have been sworn, and talking about item 1 specifically. I just want to let you guys know that I think you guys made the right decision for denying this one. You guys are definitely looking at the data by your discussion topics and things that you talked about up here for various different projects, and keep up the good work. Definitely keep looking at what you're looking at because you're going in the right direction. Thank you, guys.
Thank you. I also have Tina Hopkins on, but again, this is strictly 1, 2, and 3, so if Tina's here and wanted to speak, then,
Well, I'm Tina's father, and I spoke a minute ago on that.
okay.
So thank you.
Seeing no one else, no one's on the phone, I will close public comment on consent, and I think on base is open, but this is simple enough. I will accept motions for approval of consent items 1, 2, and 3.
Second?
I have a motion by Commissioner McCann, seconded by Commissioner Ballard. All in favor, please say aye. Aye. All opposed, as approved unanimously. Moving on to consent items that have been removed. Item number 5, Commissioner Bearden, you pulled it. Okay, is everyone okay with just doing straight votes on 5 and 7? Okay, I will accept a motion on item number 5. Okay, motions are coming. I have a motion to approve by Commissioner Ballard, seconded by Commissioner Sadiq. Now it's up, so you just cast your votes on the computer. As approved 6-1 with Commissioner Bearden in opposition, I will jump ahead just for convenience here to item number 7. That's also you, Commissioner Bearden. Did you just want that as a vote? Yep. All right, I'm accepting motions, item number 7.
Motion to approve. Second.
I have a motion by Commissioner Sadiq, seconded by Commissioner Ron. You can cast your votes now. As approved 6-1 with Commissioner Bearden in opposition. And now I'll open up item number 6, and I do apologize, I did not do public comment because there shouldn't be any on 5 or 7, but when I open up public comment for item number 6, which does require some level of presentation, I will allow public comment on 5 and 7 as well. Commissioner Felch, you pulled that.
I have some questions for the applicant. I believe that their representative is here.
Good morning, Ed Vogler, Manatee County. I have been sworn.
Thank you. What I wanted to bring to the attention of the public, this is a project that has been one of, what is our terminology? No, you're not. What? That has had some contentiousness. But I wanted to bring to the reason I pulled this is because it has been a contentious project, but this is the final plat. And I would like for our chairman to pipe in here and give us again the same explanation that you've given us before on the final plat. Hold on a moment, for the benefit of the public. Because 2 things I want to point out about this project. It was one of the first golf courses proposed in our area. But I want to commend this project because they held a community meeting. They had a neighborhood meeting, not because they had to, but because they wanted to. And we had a very good turnout there. And we have concerns because the property, that we all know it very well, was 5 feet underwater. And I'm forgetting my hurricanes, but I think that was Irma, was the first time that it went 5 feet underwater. It also borders our Mayaca River. So there was a lot of contention about it. But I want to give some kudos to these people that I represent you too. I have 78,000 constituents that requires that I represent them all. So we've had some contentious issues, but it's been done in such a manner to keep the community aware. I would like to know, we do have some issues still that I have questions on, is One is the condition of Singletary Road. There were concurrency concerns because this is a single two-lane road that has no lighting on it, and we don't want any, by the way. And we are concerned because it wasn't just the condition. And I believe, George, wasn't this approved prior to the FDAV move or even outside of the 2.1.2.8 amendment?
No, it was approved after 2128 became
Right, but
policy.
it
However,
wasn't
it wasn't approved based upon it because
Right.
2128 required contiguous and coterminous
Right.
space, which this did not. This was 1 unit per 5 acres that was just clustered. It was a cluster proposal
right.
with the open space.
Right, so it was past the FDAB. It wasn't even applicable to the 2.1.2.8. The process was, because it was a cluster of homes, it's basically does come to 1 per 5. It's just clustered, and the rest of the area is taken up by the golf course itself. But some of the concerns were the condition of the road at the time. Now, we have concerns because of the condition of the road after construction. What we forget is that's a lot of trucks and a lot of dirt and a lot of traffic on that two-lane road. So have we made any changes? I noticed there is like a right turn lane, things like that. Have any of those things been completed?
Well, everything that was required.
And I
by-
apologize because I haven't had a chance to do a ride-by for a while, but I usually do.
Well, and I have to say that I haven't driven by either.
Oh, you live in town, it's a long way
I
out
do.
there.
It is a ways. I confirmed with our engineering team, which is Morris Engineering, that all of the requirements of the final site plan have been completed. And so one cannot,
But the road work wasn't part,
I don't think extraordinary improvements to the road were required.
I thought there was a right turn lane.
Well, I'll have to say,
Yeah, I'd like some details on that.
Charles Duff, Manatee County. So we have put in a right and a left turn lane, and we bonded as part of this plat, the final asphalt lift, and we're remilling out the road there and replacing the asphalt.
Okay, so if I ride there today, I'm going to have a right turn lane going into your establishment,
Right and left coming.
right and left coming
west.
in. Okay. Are there any plans or whatever for, what I'm worried, it's very dark at night out there. So is there any signage that's being provided along that? For when you have people turning in, or I don't know how much nighttime, unless you're doing nighttime golf, that
No.
there's going to be out there, but
We
that
don't-
is a concern.
We don't anticipate much
Traffic
nighttime
during the
activity.
night?
Correct, yes. And we, based on conversations with the neighbors, we didn't plan on putting any signage, especially lighted.
Not going to be any night golf?
No,
No, all right.
Reflectors on the road?
yes. Not in now. We have to wait until the final asphalt lift comes in for that.
Is there lighting at the gate, at the entranceway? Are you doing some lighting at the entranceway?
Soft lighting, yes.
Okay.
It's uplighting onto a sign.
Okay. And the next question was, what is a resort cottage?
So the cottages are part, I believe we did.
well, yeah.
It was redefined specifically for our project, I believe.
Resort cottages are not counted as units, and so their use is limited, and they're usable only in connection with the amenities. And it's been redefined several times in our land development code.
I believe it was a special definition that was,
We had a
bestowed.
definition in the general development plan approval that allowed for the creation and
didn't you
use-
start off calling them casitas?
Well, we have used that word because those were made.
I
those-
like that one better.
Those were the words used in another project,
I see.
and then the zoning ordinance was changed a little and came into being as a formal part of our code. and it was renamed, I think, Resort Cottage.
Now, that wasn't, you did not put in an application or anything like that. Wasn't that something that was a county-initiated text amendment?
My recollection is.
My recollection is,
My
too.
recollection is that these amenities, these casitas were approved at the concession, but there was not a specific code provision. So as we came through the process, we wanted to replicate the
You're
experiences.
saying the concession was first proposed this type of dwelling,
Yes, it's built. And so when we.
but it
came-
wasn't defined as a resort cottage.
Not at that time. So when we came forward, at some point in the process, the county formalized the land development code treatment of this concept, and we proposed it as part of our project, and of course, the board approved it.
So the sequence of events was that we had, and we have definitions for a lot of things. We have ADUs, we have, what's some of the other ones? I don't know if they call a certain thing, like a mother-in-law suite or something like that. And what was so different about your proposal for resort cottages? And if it was your first unique need, how did this become a county-initiated text amendment versus one, that was tailored for your development?
I believe the planning staff wanted to formalize it so that there were standards and conditions that could be applied when it was applied for. So the concession was more ad hoc, and then our project was regulatory because of the ordinance.
So this does establish an opportunity for other people in the area to also build resort cottages, correct?
As long as it remains in your land development code as an authorized use, someone can apply for it and ask for the discretion of this board to approve it.
Okay. And what was the difference? So you're saying that and how many square feet are these resort cottages? I believe they were at 1,900, maybe.
1,800 to 2,000.
So they're about the size of a house.
They're very nice.
I'm sure they are. But they're basically it's a small house. We're not talking about a 750 square foot ADU or something like that. It's basically kind of a house. Any difference?
Yes, because the kitchen facilities are
That's what I
highly
thought.
limited.
Limiting kitchen.
So it doesn't function as a house.
So no stove,
Functions
right?
as a comfortable hotel room,
Okay.
essentially,
All righty.
for extended stay.
Well, as we spoke, I don't know if this counts as ex parte communication because I wasn't a commissioner then, but as you know, I attended your neighborhood meeting. We were treated to a conceptual drawing about this big, and we met at the church, which is your neighbor, and we want to have good neighbors. So I would encourage you to be involved with the community. There's many needs out there that I could see you guys maybe throwing a few benefits every once in a while. Protecting our river, I think that's a big concern. I just wanted to make note that you have taken those steps. And as I've said, we would like for you to be successful. We do not need an abandoned golf course for somebody to come along and want to put 5,000 houses on. So as long as you practice being a good neighbor, I think you'll be welcomed in the community. And I just wanted to pull this item because there are people in Mayaca who are concerned, who don't want to hear the word yes to everything out there without understanding where we're at. And this is why I appreciate Commissioner Cruz reiterating what a final plat is and why we vote for it, but there's reasons why we really can't not vote for it. And I want to wish you luck, and I want you to be a viable part of our community, because we will be pushing for agritourism out there, and like it or not, golf courses are about as green space and agricultural as we're probably going to get for a while. And can't wait to see those cracker cattle roaming the golf course. Y'all ready for that? No, you advertised that there are going to be cracker cattle roaming that golf course, and I want to see that happen.
That's across
There-
the river.
There's another golf course, there's two other golf courses.
They're all going to have cracker cattle roaming
We-
their
we don't-
golf courses, and I can't wait to see that.
We have a protocol to manage our cracker cattle, so we'll do it well. But thank you for those comments. I hope you vote for our plat, because we should.
Well, I really don't
And,
have a choice, do
I want
I?
to tell anyone from Maka that's watching is there will never be.
That's why I pulled it. I want you to be good neighbors, and we should be a little bit more welcoming, because it's better than a sharp stick in the eye.
And there won't be an abandoned golf course, I assure you that.
Well, we'll help you help that out, okay?
Good.
But I want to see those cows out there, okay?
Thank you.
The whole time, you got to start over.
Well, I did ask George for you to chime in to
Sure.
please
Well,
reiterate to the
this-
public why we vote for this the way we do.
Well, because it's the law. But this is a moot point at this point, because I don't want to belabor this any further, because Senate Bill 784, which was otherwise known as the Manatee County Plating Bill, because it was literally put in for Manatee County, has now made all final plats administrative in nature and removed from our agendas effective July 1st, assuming the governor signs the bill. So it's neither here nor there at this point in time after today and this particular vote. But the concept is final plats are just a drawing of what was previously approved. It's not a time to stop development. Final plats, as long as they adhere to the development code and the plan that was laid out upon the approval of this governing body and adheres to statute 177, which if you actually read it, has more to do with what kind of paper it's drawn on than any actual specifics, then they're required to be approved. And so the state, while I don't agree with their preemption practices, has preempted local authorities from voting up or down on final plats as long as they adhere to those two key elements, which every plat, as far as I'm aware, that has come in front of us has adhered to, because our staff wouldn't let it come in front of us if it did not. So that said, I will open up public comment for item 6 relative to the plat. I did not open comment for 1 and 7, which were also the final plats that were already voted on. So if there's any public comment on those 3 items, 5 and 6 and 7. 5 and 7, which I did not open for, and 6, which we just discussed. Seeing no one, and no one's on the phone, I will close public comment, and I will entertain motions for approval of item number 6.
A motion for that, please.
I have a motion by Commissioner Feltz, seconded by Commissioner Sadiq. All right, now it's up. Maybe, sort of. All right, you can vote. It is approved 7-0. Moving on to advertised public hearings. The first one is a presentation scheduled, however, it is being requested to continue-ish. I don't even know why it's continued. Okay. Well, I'll open it. It's quasi, so Ms. Knapp, do you want to open that?
Item number 8, PDR 2431ZG, North River Charter School and Townhomes. It's a rezone of approximately 21.8 acres from A1 agricultural suburban to planned development residential zoning district, unifying the zoning designation for the entire site, approving a general development plan for 46 acres, allowing for 236 multifamily unit townhome styles with at least 25% affordable housing, and subject to a land use restriction agreement, as well as a K-8 charter school and child care center. And this is a request for the applicant, from the applicant, to be continued to no date set and re-advertise.
I'll make a motion.
I just want to clarify something with the applicant. Is there an intent, is this being continued no date certain with the intention of really not coming back, or?
Mark Barnaby for the record, I have been sworn. There are 2 parts to this project. Obviously, the school will be, can be approved administratively, and it's supposed to be processed that way under the new state law. similar to the.
Okay, so you're effectively continuing the concept of the residential portion of it?
Correct.
Okay, I just wanted to clarify, because this is for public knowledge, because I know this and you know this. The legislature this year in 2025 passed, was it Senate bill or House bill? 1105.
I think it was Senate bill.
Senate bill, 1105, which allows for charter schools to be approved as of right administratively without rezone changes. And that got signed by the governor already.
Yes.
About 30 days ago, less than 30 days ago. So that's law now, effective July 1st. You'll be able to build the charter school administratively
Correct.
without
We have
coming
to
in
wait.
front of this board. So your continuation is whether or not you elect to come back for another bite at the apple on the residential portion of it at a later date.
We have not had a bite at the apple technically, but yes.
Understood.
given the comments
You started with planning.
commission
My
and
point was, I just want to make
public.
sure everyone was clear that this is unique because it's effectively two projects in one. One project is not really being continued. It's going to proceed based upon state law now.
That's
And the
correct.
other portion of it's what's being continued to no date, sir.
That's correct.
Okay, just wanted to clarify. Thank you. Commissioner Feltz?
Isn't that state law effective July 1st?
Different ones say different things. Some say October 1st, some say July 1st, some
I
say
believe
upon
the letter
signing. I don't
was
recall
from
the
Mr.
date.
Barnaby said that it was effective
Okay,
July 1st.
then I have no reason to believe him, to not believe him.
It's effective July 1st, correct.
So would that be the reasoning for the continuance?
That, we're moving forward with the final site plan,
But
which
that's
is actually in
basically the
process.
reason for the continuance.
That's-
So
that's
that you could
part of
fall
it.
under the July 1st versus the current code.
Well, there's no reason to bring the school portion of this forward to the commission at this time because of the July 1st.
No,
effective date.
right, I
Correct.
absolutely understand.
Right.
Wise move on your part. However, technically, it doesn't go into effect until July 1st, and you were scheduled to present today.
Well, there were more parts to that project than just the school.
I understand.
Okay, and yes, we're reevaluating that part of the project. We'll move forward with the school part.
So you're
on the
basically
second.
asking for a continuation so that you could take advantage of a law that isn't in effect yet, but is in effect on July 1st, that favors your position.
Commissioner, I think, under any scenario.
Which is not, there's nothing wrong
No,
with that,
no,
very
that-
wise.
Commissioner
lawyer.
Feltz, I'll point out, even if you deny it today, he could still come back on July 2nd and get it approved regardless. So all we're doing is wasting the time and money. By the time you brought the actual denial back at the next land use meeting in August, he'll have already moved forward with it before we can formally deny it at the next land use meeting. This is a non-issue. You denying it would be solely for the sake of showing the public
As
you
people
denied
who
something. It's still going to get
expected to be able
built.
to be heard today on this item, who, we just had a discussion the other day on who gets to ask for a continuance and how. And let's go with the why. We've had continuances when there wasn't a full board, or maybe when somebody wasn't going to be here that might have voted favorably or unfavorably for it. We don't get to get many answers as far as who gets the right to pull a continuance. As you could ask some of, the people who have been in this for a while, we do, when we have it's supposed to be a quasi-judicial, fair playing field, but you don't see continuances being granted to the citizens, or even what we have to do is hire a lawyer to pay just for an hour to get up and ask for a continuance on our part. And this is clearly a contentious issue that is only being asked for a continuance. It's already been reviewed by the Planning Commission. It's already had neighborhood meetings. It's already had a lot. And we've got, may I remind everyone again about our fancy little traffic report, which is the whole reason that we have a problem with it, not because it's a charter school, not because it's an apartment building. We've got an issue with 675, which is probably showing a lot of water in ditches right now. And now we're asking a continuance, and the continuance is basically, if they want to come back after July 1st, but we still have to operate under what is in effect right now. And now is not July 1st. So if they want to come back, that's fine, but we're still going to face the same issues. And asking for a continuance, we had to even just get on the agenda that it's a vote for a continuance versus it's stating on there, oh, it's going to be a continuance, so all the people who want to show up and speak about it think, oh, it's going to be continued, so I'm not going to show up. No, we had to get the verbiage changed so that it actually said we are voting on a continuance. We are voting on the merits of a continuance, not willy-nilly because somebody's not going to be here or somebody's not going to vote our way or see things another way. We have so much to process that when these continuances are asked for, we rush things onto the agenda, and then we ask for continuances. And you know the basis for this continuance, and it's truth. It's being a good business person. It's being a good lawyer. But in being a good commissioner, I question it, and we have a right to we actually have a vote, and we can vote for or against a continuance based on its merits, and I am voting against a continuance. Thank you.
Okay, thank you. And I will just clarify, because you've mentioned multiple, okay, I'm on the board. I let you speak a lot so far this morning. I'm responding to you about the merits of the request for continuance. You were sitting here, you kept saying we, as if you're some public activist now. You are not. You are a commissioner on this board now, whether you like it or not. You adhere to the rules of this board and of the state and of the oath you took. And this is a quasi-judicial hearing, which the merits of which are not discretionary when it comes to fact. And you are sitting here now with full,
I know, but I don't
I'm
need your
speaking.
lecture right now, okay?
I
Just
am
move it on.
lecturing because you want to tell the
Oh,
public. I'm trying to explain to the public why I am going to
trying to
vote for
explain
this
to the-
continuance.
I have a
Please,
right
please
to
let me
vote.
talk. Please, you,
My
you,
vote, end of story.
you now have full knowledge that a bill has been approved
July 1st.
at the state. Can we have some level of professionalism up here?
I'm going to be lectured, George.
I'm not lecturing you. I'm speaking to Mr. Barnaby and the public. We now have full knowledge that there is a bill that has been approved. It's going to be effective July 1st before we can ever conceivably finalize a denial of this project. That bill allows for the requested school to be built as of right administratively without this board's approval. Meaning if we do not continue this and we insist on going through a dog and pony show for the sake of standing on a soapbox and pandering, all we're doing is wasting taxpayer money and staff time to go through something that we knowingly have no effect on whatsoever in life, because regardless of a final vote at the end of the day, the conceptual proposal is going to be done with or without us. If we're saying we have a quote-unquote right to deny continuances, then the threshold of what that is needs to be fairly high based on past procedure up here on this board. I cannot see how anyone on this board could say, knowing that this presentation has absolutely no bearing in life, that this somehow hits a threshold that will deny a continuance and force a presentation, which if I was Mr. Barnaby, I would literally just waive my presentation because this entire vote has absolutely no bearing legally whatsoever to what goes on. I would also have the state question, what is a county commission doing, ignoring a law we've already passed, knowing it's passed? Like, it makes no sense. He would waive his, the staff would waive his. This entire thing is just so people can scream at people about traffic studies and then go about our way. We have another project on this road later today. Scream about the traffic study there. They're only a couple of miles apart from each other. But this is a waste of our time. This would have been a very good presentation, very interesting presentation, a very interesting dialogue, both for the public and this board, if that bill hadn't passed, but it has. So I am 100% in favor of voting for this continuance. I cannot make that motion, and I'm positive it's going to pass because legally it needs to pass. Thank you.
Good, I'll make a motion to approve.
Yep.
Actually, someone else is on the board. It's not time for the motion yet.
No. Commissioner Feltz had put herself on the board. I clicked her name. She's down there, and she made a motion. Okay.
Commissioner
Bearden.
Bearden's trying to be on the board.
Okay.
Thank you, Mr. Chair. I just want to make a statement. I guess, there's a lot of just issues with things being continued and things of that nature. I want to just say that I'm a very reasonable man, and I hope that applicants are reasonable too. moving forward of the future of Manatee County when we're talking about future development. So I'm going to vote in favor of this continuance because I'd like to hear exactly what's going to be, what they come back with, because we all need to be reasonable up here. So that's all I have to say, Mr. Chair. Thank you.
All right, thank you. I have no one else on the board, but I will open up public comment. The public comments are specific to the request for continuance. I have Dalton and Stacy on the board. Either one of you can come down. Technically, Dalton's first, but it's discussion on the continuance.
Good morning. My name is Stacy Jesse. I live in Manatee County, and I have been sworn in. I'm just talking about the continuance. I guess I just have two questions in general about how this played out. For those of us that planned our days today around coming to find out, I don't think it was like 5 o'clock, we were all texting each other last night to see it changed. It messes up our days. Mr. Barnaby's memo stated that May 30th, Governor DeSantis signed this law, or this bill. So we knew it was coming, yet we've gone through all this process. Why couldn't there have been the courtesy of 3 days? There are people in this room who rearranged vacation and travel plans to be here. So it wasn't a lot of consideration for neighbors. And I just wanted to know, how we could, in the future, do better about the timing of the continuance. My second question also had to do with the memo that's in the agenda requesting the continuance. On the second page of that memo from Mr. Barnaby, he cites this law. I looked up the legislative analysis, and that doesn't seem to agree with how Mr. Barnaby has interpreted the law. And I guess my question is, when you decide whether you can administratively approve something, how does the county verify another attorney's interpretation of a new law? Thank you.
Good morning, Commissioners. My name is Bradley Anderson. I'm a Manatee County resident. I have been sworn in. A slightly different voice, both literally and figuratively today on this continuance. As mentioned, my name is Bradley Anderson. I do live in District 1. I live directly across from the proposed North River Charter School and former townhome project. I understand that the applicant has requested a continuance with no set date and is now exploring an administrative path for school approval based on SB 1255. I'm here today not to relitigate the past, but to speak on what's ahead. First, our concerns have not gone away. The road is still dangerous. The sidewalks are still non-existent. The flooding still happens.
Bradley, this needs to be on the continuance itself, not on the project.
Correct.
Okay, but you're not speaking on the continuance, you're speaking on the project.
I believe it is, because I just wanted to reference with respect to the law that, we can't shortcut safety, through the continuance. But if you need me to reserve this for a future date, I can do so.
We do, because you could have the rest of your time to speak on the continuance, but if your discussion is about the merits of the law, that would be a discussion for your state representatives when it comes up or when this project comes back at a future date. Talking about the traffic studies on a road, that has nothing to do with the continuance of this.
I understand. I guess the foundation of the ask at the end of the day is that the way that we look at how we on a county level work with statutes, it's going to come in significance. This is going to be setting a precedent for the future, and I just want us to be very cognizant of that moving forward. So
Do not
I
disagree.
appreciate the time.
All right, thank you. Dalton, were you coming up?
Dalton Nelson, Manatee County, and I have been sworn. And trying to stick with the continuance side of it. Like they said, this has been something that we've known has been signed for at least a month or so now. They went before the Planning Commission, what was it, last week, if I'm not mistaken. There was a lot of things in the Planning Commission meeting that was kind of identified as an issue that I feel like the applicant could have asked for a continuance a lot sooner and saved a lot of us the heartache and trouble of coming up here, because some of the statements and things that were made, not trying to focus on that too much, but they were very glaringly I believe, ill-prepared, and they should have asked for a continuance, I believe even before then, to get all their ducks in a row, because there was a lot of things that was very obvious that was not addressed. And it's super disappointing that we have all of this time and energy and everything, put into researching this and picking apart everything to try and make sure that everything's safe for everybody, and now we're not even allowed to speak about it. So even though it doesn't mean anything, I would somewhat like you guys to somewhat stand on that soapbox, because it does mean a difference in certain ways. Even though it doesn't mean anything to you, it does mean something to us.
All right, fair enough. Thank you, Dalton.
Morning, Chris Whitaker, Manatee County, and I have been sworn. My question in regards to the continuance, because of the letter that's stated in the public, I guess, sector there you can look at. With them in regards to getting it approved administratively, how can we approve something like that administratively when it, on record at the Planning Commission, failed compatibility with the area, concurrency? There was a lot of public outcry, and support against this. We're not against schools. My grandmother was a teacher at Southeast High. Ironically, my mother taught at Ballard, just a few blocks away from here. And so we're not against schools. We know what education can bring and the positive impact it can bring. It was just this one was not going to be brought in a positive way. And I think we pointed out a lot of negative ways it could impact the area. And so how can we administratively approve this project when on record there's expert traffic studies and everything that don't work with this project? There was a lot of inconsistencies with their presentation, if you guys watched the Planning Commission. So I would really ask yourselves, how can we administratively get that approved with those problems? So, thank you.
All right, thank you. Anyone else on the continuance?
Good morning again, Mr. Chair. Anthony Shulo. I'm a Manatee County resident. I have been sworn. A lot of folks did come out here just to talk about that. And so clearly, that's the law. That's where you're going with, right? You have a continuance. Understand that. But altogether, what are we going to keep doing here? Keep approving more intensified development?
It's not on the continuance, Anthony.
Well, we can't keep acting like this.
It's not on the continuance, Anthony.
You just think this is a natural course of things? We cannot just keep acting like this is a natural course of events that's happening out here. These conditions are being created.
Anthony, please
Work
stick with
together and
continuance.
find fair, forward-thinking solutions that don't treat residents as acceptable collateral damage. Don't flood us out of our homes, or worse, drown us into submission.
Are there any other comments specifically on the continuance? Seeing none, I will close public comments. I'm on the board for two things. One, there's two parts to this project. The statute only has one of them. So if the applicant was debating whether or not to come forward today, I know the Planning Commission declined it, but I can point to Fort Hammer Commons, where I lost that vote, and that got approved. The Planning Commission denied that one unanimously, too, and a different board, admittedly, voted in favor of it. So there's always a chance that the Planning Commission's decisions can be overturned here. This project includes residential units, so, and based on the staff reports, the residential units were part of the economic driver to justify the school portion of it. So they could have been coming forward with the best intention of presenting the entire project, as they did with Planning Commission, and then decided to pivot at the last minute and take advantage of the school and figured out some way of doing it. I can't speak to that, nor is it my job to read into their minds about their timing of pivoting their business plan. As for the state statute and what qualifies as administrative, good. Stick with me when I'm banging this drum. Nobody seems to ever, I've asked our delegates, none of you ever reach out to our delegates. Sometimes you tag them on Facebook, but that doesn't do any good. Reach out to them. I've been banging a drum about home rule and preemption for years, screaming about these bills, the ag enclave bills and the impact fee bills. Nobody ever reaches out to our state senators and our state representatives and other people up in Tallahassee. You yell at us for having to adhere to the laws that they pass, but none of you reach out to them. This isn't our law. This is their law. They passed this bill that's going to go into statute. That bill dictates what constitutes administrative approval and whether or not it has to conform to concurrency or has to conform to compatibility. Not us. And our staff has to go by statute. And so that's why this is a continuance and not a removal. Because if the determination of our staff upon having time to review the statute, once it becomes effective, determines that this request being made by Mr. Barnaby does not conform on an administrative level, he can still come back here and ask for us to override staff in a traditional rezone manner, which is what he's doing, which is why it's a continuance. It keeps it on the shelf. He's hoping to get it administratively approved, but he's not guaranteed to get it administratively approved if it doesn't qualify for it, which is why this is continued and not just removed in its entirety. So we can't dictate what administrative is, the state does. But talk to the state. They had a lot of bills that almost got through this year that would have been terrible bills for all of you and take a lot of stuff. That's why we're stuck with things like 2128 when that comes up later and wetland buffer. So not because of us, not because we don't want to do it. We're all voting unanimously to do these things. It's the state that's preempting our ability to do it. This is another thing that the state is preempting against us. So until more people start yelling at the people in Tallahassee to stop doing what they're doing, instead of just yelling at us for having to adhere to what they're doing, then we're not going to do anything because they're clearly using their power up there to dictate our development rights down here. Commissioner Bearden.
Thank you, Mr. Chair. It sounds like to me when it does come with continuances, we're going to have to set a certain standard across the board so that we're fair with everybody. Talking about future things in regards to these developments and things of that nature, we have an opportunity as the board to represent the people. So if we represent the people in a way to where we take a stand on certain issues, that'll wake up our state legislators possibly to fight for the people in the direction that we want this county to go, right? Instead of them. But see, we don't have enough people up here with enough courage to do that because everybody's so worried about their next position or their next donation or their next campaign. That's the truth. You can laugh about it all you want, Mr. Chairman, but you know it's true. You know it's true. All I'm asking this board to do is to have a little bit of courage because we're dealing with people's livelihoods. Do you live in those do you live near a lot of these proposed developments? I live a lot closer. Okay, but were you affected like them? Probably not. So I need you to start thinking, and I need this board to start thinking in a way as if you were them. Because at the end of the day, you think it's a joking matter, but I don't, Mr. Chairman. You're laughing about this, but they're not. Do you see them laughing? They're not laughing, Mr. Chairman. These people were strained. These people were hurt. So I don't think this is a joking matter. This is reality. And so we need, as a board, I'm going to ask this board that we start taking a stand and not worrying about our personal benefits for the future. Please, that's all I'm asking. Thank you, Mr. Chair.
Commissioner Feltz.
I think that it would behoove our chair to show we are all sitting up here. You are running the meeting, Mr. Chair, but we are all in equal positions on this board. And I would also caution you on how you treat our citizens that come to the dais. I can recall a situation, yes, you tell them to keep it to the continuance, but I find their comments pertinent to the continuance. You making the decision on what is pertinent to the continuance reminds me of a former chairman that had me escorted out of this room because he didn't feel that what I was saying up there was pertinent. And you know what? It sure turned out to be pretty pertinent. It wasn't you. We all know who it was.
This time.
This time. But if you recall what my words were that got me thrown out of the room by a former chair who didn't think my comments were pertinent, was how you vote on this will determine how we vote later. And I was right. Please maintain some decorum as the chair. You are running the meeting. You are not here to lecture. You are here to educate. We appreciate that, and we appreciate your knowledge. But everybody on this board is sitting in the same size chair right now. Your job right now is to run the meeting, not to treat our constituents or us in a demeaning manner.
All I would request is, all I would request is if you're going to lecture me about not lecturing people, then don't do it in the form of a lecture, pointing at me and calling me out by name on the dais, Commissioner Feltz. There's a, okay, there's.
When this happened last meeting, you called for a recess. I
there's-
think we need one now.
I am calling this, let's have this vote.
Let's have a recess.
I am not calling a recess.
I guess you're in charge.
I literally am. That's actually what my position is, Commissioner Feltz. Commissioner Feltz, please. We have closed public comment. There's no one else on the board. I am entertaining motions. I have a motion by Commissioner Sadiq to continue, seconded by Commissioner Ron. Once it comes up, you can cast your votes now. And it is approved 5-2 with Commissioners Feltz and McCann in opposition. We'll move on to item number 9. Ms. Knapp.
Item number 9 is LDCT 2503, ordinance number 2519. This is a county-initiated Land Development Code text amendment regarding neighborhood workshops, amending Land Development Code Chapter 3, Review and Procedure, Section 312.6, Neighborhood Workshops, and 312.7, Notice of Public Hearings, is being amended to revise the neighborhood workshop guidelines. In essence, to establish the development applications requiring mandatory meetings and those that may require meetings at the discretion of the Board of County Commissioners and/or the Department Director. And 2, to revise formatting requirements, timing of notice, procedures, and then also for providing for other amendments as may be necessary for internal consistencies. Your staff presenter is Laura Gonzalez.
Good morning, Commissioners. Laura Gonzalez with the staff.
Can you pull the microphone closer to your mouth? Thank you.
Okay. So in January, the board, you directed staff to propose an amendment to Section 312.6 to make neighborhood workshops a requirement in the development review process. Currently, the Section 312.6 states that applicants are strongly encouraged to hold a neighborhood workshop, and they can be requested by the department director or the board for any application that could have potential neighborhood impacts. So it's important to highlight that it says any application, so it's not exclusive for public hearing applications. Then Section 312.6 continues with the purpose of the neighborhood meetings to ensure early citizen participation, provide an applicant the opportunity to understand the impacts on communities, ensure the citizens and property owners have the opportunity to learn about applications that may affect them, and it is not intended to produce complete consensus, but to provide information. We are not proposing changes to the purpose. Then we continue with a list of applications that we are proposing to have mandatory neighborhood workshops. And they basically include the most common public hearing application, comprehensive plan amendment to change the future land use category, rezoning, general development plans, preliminary site plan when it has to be decided by the board, affordable housing projects, live manatee and mixed-use projects, public use facility, any applications east of the FDAT, applications in areas where community plans has been approved, and these plans are listed in policy 2.9.3.1 in the comprehensive plan and includes Bayshore area, Cortez Village, the urban infill redevelopment area in Palmero, and special permits. Then we are proposing a second group of applications for which the neighborhood workshops may be required at the discretion of the department director when uses, density, or intensity create potential compatibility issues and neighborhood impacts and/or affect environmentally sensitive area. Typically, the type of application, but not limited, would be final site plan in a standard and limited standard zoning district where rezoning occurs without a site plan, limiting the ability to understand the impacts of the proposal on the surrounding area. And also preliminary site plan, final site plan for a planned development project that has been approved with a general development plan for similar reasons. The current Section 312.6 doesn't specifies the timing for the neighborhood workshop. So we are proposing that it has to be held during the completeness review cycles prior to sufficiency. Here we have a comparison in what the code says about workshop times and location and our proposal. We propose to maintain the language and emphasize preference for in-person meetings. Virtual meetings will be, according to this proposal, allowed when special circumstances prevent the in-person meeting. I want to note that at the Planning Commission meeting, hybrid workshops were suggested as a more inclusive and convenient alternative. Also, in regards to additional meetings, we retain the correct language that requires additional meetings when there are important changes or are notice issues, technology issues, but also we are including applications where for some reason are withdrawn or are on hold, and they are submitted after 12 months of the previous neighborhood workshop. They would require an additional neighborhood. In terms of the summary, we maintain the language, but we added potential project improvement that could be identified during the process with the neighbors, and the affidavit of notices for and signs that this is a requirement for the public hearing, and we are adding it to the neighborhood workshop, and lately we are receiving this affidavit of notices too. But we are included in the language of the Land Development Code. Then we have additional proposals related to the way we advertise the neighborhood workshop. First, we are even if we are asking the applicant to put signs, this is not a requirement right now in the Land Development Code. So we are proposing to update table 3.2 and add this requirement of posted signs for neighborhood workshop. When we are also adding that notice will comply with section 312.7.e that refers to the content of the notice. The mailing list, according to the Land Development Code right now, says that will be provided by the department director, but in reality, the mailing list is prepared by the applicant, and they are using the property appraiser website and Manatee County GIS. We are proposing to update this to the current practice. Also, we are proposing to increase the size of the radius for the invite. Right now, we are using the same standard as the public hearing, that is 500 feet, and we are proposing increase the radius to 800 feet or 1,500 feet in case of, depending on the characteristic of the area. If it's a rural area, for example, it's logical that the radius be larger. And we are also changing the timing. We say notice will be sent at least 15 business days prior to neighborhood workshop. And finally, we are included in the section 312.7.d, the timing for the location of the signs. That is to be not less than 15 days and no more than 40 days in advance of the neighborhood workshop. This concludes my presentation, and I'm willing to hear your comments and suggestions.
As you might know, this has been a pet project of mine for many, many years. We've worked long and hard on this, close but no banana, okay? There's still a few things in here that I think we need to discuss and tweak a little bit. I hate using that word. This might be something that those of you who are in other districts, I know our commissioners at large have some familiarity with the subject, but I don't think our commissioner in District 2 or even District 3 or even District 4 are really familiar with what this means and what this means to the residents in the most affected area. What you probably don't see little yellow signs in your district as much as we see the little yellow signs in our district. And I will tell you that there has been a subtle change in the process and procedures over years before many of you even have lived in this county of how it used to be done and how it came to be done. Back when we were a smaller county, when people were not really aware of the process of moving out east, we had little yellow signs this big, okay? And maybe walking around your neighborhood or going to your dog park, you might notice a little yellow sign like this. But when you're out there in the boonies, in the middle of acres and acres of land, and that little yellow sign was not visible. And it's kind of what started me on this. You know, I'd be riding around Parrish on a horse, and I'd see a little yellow sign in the woods that nobody could even get to this except by horseback, and I know there weren't a lot of people running around on horseback then, and it would say, public hearing notice. Who in the public was ever going to see that sign? Another thing that changed over the years is back in the day when we had those little yellow signs, the little yellow sign said on it in plain English what they were going to do with this property. I'm going to build a house here. I'm going to build 5,000 houses here. Plain English, where anybody could understand it if you saw the sign. As we streamlined or fast-tracked development in this county, little subtle changes came through that made it more difficult for us to know what's going on right next door to us. The signs changed to look something like Egyptian hieroglyphics. They didn't tell us what was going on. They said, PDR, PLN, scan this QR code. And may I also mention that there are many places out there that don't even have cell phone coverage, that you can't scan a QR code. So we worked at this. We worked at this. Every meeting that we went to, everything that we did, the letters that are sent within 500 feet. Many times when you're looking at a rezoning change or something like that, you know who owns the property surrounding it? The same person that's putting in for the rezoning change. So they send a letter to themselves. there are still some things to tweak about this. If you look at the process for how we notify, okay, there's no proof that letters were actually sent to people within 500 feet. How many times have we gone for a quasi-judicial public hearing and people are told, oh, well, you should have gotten a letter? They don't. There's no way to verify that. Even with our larger signs, which we introduced and you approved, and we appreciate that, even with our larger signs, the applicant is given the directive to put the sign out. They send an affidavit and a picture of the sign, but we don't have a clause in there about visibility of that sign. For all of the good that we did with those larger signs, if you look where they're being placed, there's no visibility for them. Very clever. And when you send in an affidavit of a picture of a sign, they're not giving they're just giving an affidavit that they put the sign on the property. We need to work into that clause about the visibility of the sign counts too. What good does it, I mean, you could have the biggest sign in the world, but if you don't put it where anybody is going to see it, it's kind of a waste of everybody's time and money, okay? So I'd like something for the amendment of that with visibility. Yes, we give them the sign as instructed by the director, and I'm pretty certain that our director wouldn't know, a section of Moccasin Wallow Road that's got high weeds growing out of the ditch, that if you put a sign on the fence line, nobody's going to see it. How would she know that? But we do. So we also have a problem with, so the placement of the signage is a problem. It has to have a clause in there for visibility, proof of visibility, okay? And the other issue is that the signs are being put parallel to the roadway, so you can't read them. There's also no way for people to pull off the road, especially on 675, to scan that QR code. So visibility and access to the information on the sign is something, yes, we've got to specify it so that it is effective. Otherwise, doesn't matter what size sign you make, okay? The other thing is the letters that go out to the property owners in the vicinity. We've expanded it to 800 to 1,500 feet? 800, 1,500 feet.
800 feet is the proposal.
I would rather have a specific standard without a standard operating procedure of decide 1,500 feet. Because I don't think that we should be leaving things to the discretion of anyone, because that just is, it's harder to enforce, it's harder to instill those standard operating procedures. Decide 1,500 feet. In a lot of cases, we're not affecting 1,500 feet around us if we're talking about on a major thoroughfare or things like that. But I would like that to be a solid 1,500 feet, no matter what. I would like to have some amendment to the letter process. You have no way of proving that those letters are actually sent by the applicant unless they're sent certified mail. I would actually rather the county take over that portion of the notice. Maybe the county needs to be the ones to place the signs. No. I understand, but you have, then what's your way of guaranteeing, because I could prove time and time again, these letters do not get sent. You have a listing that they prepare on who is within 1,800 feet, but you have no proof that you have an affidavit saying they did it. But how many times, and I'm sure my citizens that will come up and speak will tell you, those letters do not get sent. And you have no way of proving that they do.
Commissioner, I have seen affidavit accompanied with a certified note from the service provider that the mail was sent.
And I probably could give you a lot of instances. That's an affidavit. That's not a proof of a certified letter. Do you have that?
I have seen
Right.
this.
You have seen.
Yeah,
Yeah, I have
have
also
my-
been
the
told that
record
we
in
have
my
some
hand.
projects that we put out 6 signs, but I've never seen a project with 6 signs around it. So I would like to have that adjusted. Unless you want to do an audit and so I could prove to you those letters do not get out. The signage, there is signage, we're going over that, there is signage for the neighborhood meetings, right? This is going to be the white on, the red writing on the white signs, I think that's how you're designing it.
white, yeah.
And it says basically everything, the requirements on the sign, it's going to be basically everything that's on the yellow sign, right?
I think the yellow sign is for public.
For public hearing, but
public
the
hearing, and
neighborhood
the-
meeting will
is white.
reference the same,
Mhm.
the PLN number, the
We have to include this in the sign.
same legal description? Can we have a description on those neighborhood signs of
In
what
the
it is?
signs?
Usually, here's what we've got before. There's a neighborhood meeting on this date.
We have to check and prepare a new version of the signs, because I have seen that there is no space to put the name, and it was one of the
I thought they're the
comments.
same size as the yellow signs now.
Yeah,
Right.
but doesn't have a space to put the name of the project, and we have to change that.
Okay, right, because here's what you get.
Mhm.
You have the same thing. The neighborhood meeting signs are not placed in an area, you gotta be specific. So it's in there, placed in an area of visibility, in a certain amount of distance from the project, and with an explanation on, what they're doing is they put the neighborhood meeting sign out whenever, once, and all it says on it is neighborhood meeting. I don't think anybody's gonna go to that. You need to be a little bit more specific with it.
Well, okay, right now, the code says, location of signs, notice shall be posted no more than 15 feet from the front lot line, so as to be clearly visible from the public way.
Yeah. Well, I want to, back off on this
We can
because
review it.
I'm so proud of us for getting this far after 8 years.
Mhm.
And it seems like it's been that long. We're doing great. And I just want to back off a little bit and give our opportunity for public comment
Mhm.
so that you could listen to other people, not
Of
just
course.
me, on how we could get this going. Because I think it's a great advantage. And I also want to say, I think this could work to the advantage of our applicants too.
Yeah.
I would even back it up some more to the pre-application before it's even assigned anything, because we don't want to create an undue burden on someone who puts a lot of work into a project, only to find that, how do they know that their neighbors have exception to it? And we'd like to open that up for their opportunity. So I think that if they speak more about their projects in a preliminary fashion, that it will save them time and money in the end too. So this is not just to benefit one side or the other. It's a move towards the transparency that we've promised our citizens.
Commissioner Sadiq.
Thank you, Mr. Chair. And thank you and staff for a very thoughtful approach to establish a standard for community workshops. Contrary to personal opinions, I do know what the yellow signs are. I've seen them around town, and I drive the whole county. Did that recently on 675. I wasn't originally in favor because I was concerned for the loopholes, not for the principle. I think having the community workshops is important, and I value seeing them pop up on the projects that I see. But a couple of questions. One good comment. I do like when you're placing these, because before I think you said sufficiency, but right after the completeness review makes sense, because we're not we're not adding overhead for a project that might not even make it through most of the steps with development services. Just makes a lot of sense to me. I think doing it there where staff have had adequate time to review the application, go back and forth with the applicant, and make sure adhering to LDC and comp plan and a million other things. So I think the timing is good. I'm curious why the option for final site plan and preliminary site plan. And I only bring that up because that's typically when you have the clearest idea of a project. Do we say may instead of shall because applicants will have a community workshop already at that point? Or how are we avoiding a duplication of a workshop, I guess?
Well, in this case, it's very specific that we are giving the opportunity of the development and the department director to decide if a neighborhood workshop is required or not. But basically, it refers to final site plan when you have a site that is within a zoning district that is a standard zoning district or limited standard zoning district, when the rezoning is approved without a site plan. So it will be the first site plan linked to this zoning district. Because we don't approve, or you don't approve, a standard zoning district with site plans. So this is the reason we are proposing, because probably there are circumstances in which at that time of the rezoning, we don't know the complete situation or how the site plan will be and the impacts on the surrounding area. So I think this is the case. And the same with the GDP that is approved with many details. So we will have this detail at time of the preliminary site plan or final site plan for plan development projects.
Understood. I think that makes sense. Thank you. I don't necessarily have a strong opinion about, we're kind of haggling numbers when it comes to 800, 1,500 feet. I mean, I don't have a problem. The more the merrier. I think if in the urban districts, I think the concern is in our more, keeping in mind, good is, perfect is the enemy of the good here, but 800 feet, 1,500 feet, what really defines a neighborhood? What are some thoughts that were put into the development of this policy when it comes to some of our more rural areas? So, for example, not just property owners that might have adjacent parcels, but I'm not saying you send out a notice to an entire corridor, but there's a bit of a different conversation, an evaluation process that has to be had.
We keep in the language that the neighborhood workshop will be in coordination with the department director. And in this case, we have to check the characteristic of the surrounding area. If it's in an urban area, probably 800 feet will be okay. But if it's in Mayaca, for example, or in District 1, we need an additional distance to cover more neighbors, or probably the same number of neighbors that in the urban area with only 800 feet.
Okay, and have you looked at, perhaps past, maybe existing, applications to identify if if that distance makes sense? I assume you have. Okay, all right. Other than that, I don't think we should be required to pay for mailings and signage. I think if you're sending an affidavit, that's a binding legal document. That's better than a he said, she said type situation. And plus, I don't think taxpayers should be on the hook for what an applicant should be paying for there. But other than that, I appreciate the thoughtfulness and the closing of quite a few of what I would have thought would be loopholes, so appreciate it.
Thank you.
Thank you, Mr. Chair. Good morning,
Good
Ms.
morning.
Gonzalez. How are you? Real quick, is there any opt-out of this is mandatory across no matter what a rezone is or anything. It's mandatory no matter what. So my question is, if I'm in a high commercial, light industrial area, I'm surrounded by it, and I want to come in for a rezone, and all my neighbors are light industrial, I want a light industrial rezone, I'm going to have to do a neighborhood meeting with my light industrial neighbors to do my rezone, if it's all commercial, 100% commercial.
This is a
Well, that's just, so there's no opt-out for something of that nature or anything like that?
This is a good question, and right now I don't have the answer, but
Okay.
according to
No, I
this,
mean, we do have, in my district, we have situations like that where I have
Okay.
no residential close to me. It's all IL or heavy industrial. And somebody wants to rezone 5 acres, we're gonna make that individual hold a neighborhood meeting with his neighbors that are all the same process, or the same zoning. So I understand, I'm glad we're to this point. I think we need it definitely for residential. Commissioner Feltz, I've talked about since even I was on the planning commission about doing this. So, but I think it's a great idea, but I'm just concerned about if I'm just surrounded by what I'm surrounded by, it's not like I'm going ag to PDR or anything like that or whatever, but I'm just concerned about if do I really need to have a neighborhood meeting if I don't really need to have a neighborhood meeting?
Yeah, I see.
Yeah, that's my question. If you could find out for me, I'd
will-
appreciate it.
Let's
Thank you, ma'am.
discuss about it and
Thank you, Mr. Chair.
make a determination. Thank you.
If I can address that as
No.
as the author a moment. We discussed those kind of things. The problem, what we're going for here is a uniformity and if, I guess we're a little gun shy about any putting decisions into place or putting people in a position where they may, just trying to get a standard operating procedure first, and then I think there's still room to remove certain issues or we may decide if in case that it's a rezoning, but it is, as you said, I thought about this with our commercial and especially in our smaller districts. These might be things that only are, I think that we need to have established some consistency because it's easier to manage that and it is easier to monitor that than if we start having all kinds of exceptions. I mean, I could make up a whole different set of rules for neighborhood meetings just applicable to District 1. But that's not the way we do things. So we're really trying to relieve the burden of the decision-making process on anyone who may not be as familiar with the area. We judge things, our judgment on whether or not a neighborhood meeting was suggested or required was based on, is this subject contentious? Well, I wouldn't know if something in Commissioner Ron's district was contentious or not. He might be a better judge of that than I would be. So we just wanted to remove that error that we could have in discretion because of lack of knowledge of the area. And again, we're throwing this out there, and that doesn't mean that we can't change it for later. We may say, if it's ag to Res 9, 1,800 feet. We may say if it's on a road that's been identified as a high-traffic issue road, that we expand it to a mile for those reasons. But right now, we're just trying to tweak, we're trying to correct and get to where we have the perfect system, and there's nothing perfect. And just a correction is, we don't pay, the applicant pays for all of this. The applicant pays for the signs, the applicant pays for the mailing. It's not that the taxpayers are gonna pay for this. We just want those mailings to be certified and proven, and I'm telling you, affidavits are not the proof. It's saying that I did something, but it's not proving that you did it. And we just have more situations than not that we've experienced over the last couple of years that no, the letters don't get to people. The signs don't get out there where people can see them. The summary of the meeting is also written by the applicant. And you're never gonna see a summary of a neighborhood meeting that is not a bit biased, because who's reporting on it? And that was another question I had for our attorney, Ms. Shank.
Okay, don't forget, Commissioner Felch, you were answering Commissioner,
Okay.
Commissioner Ballard was
Yeah,
on the
let me-
board
let
ahead
me-
of you,
let me-
so.
I'll save that one for later.
I
Sorry.
gave you
Yeah,
I gave you the floor, but she has the floor.
Yep,
Go ahead.
yeah, I've been waiting for about five extra minutes there. So I disagree with Commissioner Ron on the potential, what I'd call loopholes, exemptions. I think it just opens up too many potential problems. I don't think it's that high a bar just to have the neighborhood meeting, even if you're surrounded by industrial or whatever it is. I'm not opposed to requiring certified letters. We don't currently require certified letters. Is that high a burden for our applicants? I mean.
I'll let the public speak to that because I think they could testify what we've learned.
So, and then the other thing I would ask is, some of the things, Commissioner Feltz, that you said about, requiring visibility, requiring access to the sign, you'd have to be very careful about the way that you wrote something like that, because it's that would be just a very slippery slope. I can't imagine all the trouble that you could get into by saying that it has to be visible. You know, what is visible? What constitutes visibility? Is it you know, visibility for someone who's legally blind? Is it? I just feel like it has to be written. It would have to be written in a very specific way. I think that this is a really good start. I think it's thoughtful. I think it'll be very helpful. That's it. Thank you.
Thank you. I want to mention that right now the code, establishes that such affidavits shall be accompanied by a complete list of the names and last known addresses of the persons entitled to notice and the method by which notice was provided.
All right, thank you. Yeah, just two quick things, because I tried to make these mandatory a couple of years ago. Nobody on my board wanted to do anything 2 years ago. My only two concerns with this, not really concerns, I'll vote for if this is the discretion of the board, is, one, it sounds like there's a lot of open-ended items here. We're voting on an ordinance, but it sounds like there's still a lot of back and forth of maybe this should be this, maybe this, is this maybe premature to vote on? Because it doesn't sound like we finalized anything.
Yes.
This maybe should have been more of a work session type thing, as part of maybe another work session where we all could have collectively spoke, maybe had some of the applicants come in, some of the neighbors come in, give their opinion. So if we do this, we do it thoughtfully, as opposed to, this sounds like even Commissioner Feltz, who's the biggest advocate for it, has some druthers about the language, or maybe it's like, I'll take it for now, but we could tweak it. I'd rather be right, because I think the board's on the side of doing this, but I'd rather do it properly. My second thing was, I believe, barring extraordinary circumstances, which I believe were defined as things like natural disasters and stuff, that these were intended to be solely in person. If that's the discretion of the board, it's fine. Again, I'll vote for it. It was explained to me why that's a terrible idea previously when I brought this up. Again, if this is what the board wants, I'm not fighting it, but even most of the public prefers virtual, because if you say it has to be in person, unless you dig down that deep, they can have in person at 9 p.m. at night. They can have in person at 2 o'clock in the afternoon on a Tuesday when you're at work. A lot of the land, especially in District 1, does not have a place for in person. What do you do about inclement weather? Are you going to meet out in a field? Like the closest place you can go to like 675 is what, Mayaca Community Center? I mean, people are going to argue that's way too far away from that project, or Lake Ranch Library. That's way too far away. It's not even in the same district as the project. You're going to start restricting yourself on locations for in-person. You're going to start restricting yourself on people saying that they don't have babysitting, they have to work, it has to be after 5, it has to be before 5, it has to be on a weekend, it has to be on a weekday. Whereas if it's virtual, people can log into a Zoom and listen in while they're driving down a road. We can make it virtual and require that that has to be recorded, and that the recording of the virtual can be made accessible to the public. But I think if you make it live, you're going to end up with more problems. This is what I was told when I try to push for mandatory in person. That mandatory in person was less productive, and once it went virtual because of COVID back in the day, there was more attendance associated with it. But again, if that's the discretion of the board, that's okay with me. I just want people to understand that we may end up with more problems than we create solutions. I understand people say they get dropped or they don't get called on when their hands are up. There's never a perfect thing. But the perfect thing of being a neighborhood meeting 10 miles away from the site in the middle of the afternoon during work is going to get an equal number of people complaining as people who get dropped off of Zoom because of bad connections. I truly think the virtual, you can't make it be, it has to be both, because then you're really restricting the locations, because now it has to be a location in close proximity to a site and has full internet access to be able to set up to do that. Now you're really pigeonholing in the problem. Not to mention you have to have someone monitoring Zoom and having AV set up so people can hear it through the computer and be able to answer and record it. But again, if that's the discretion, that's fine. I'm relaying information I was told by staff and by people in the public the last time I tried this, that the mandatory live was not the best solution. I'm going to let Commissioner Bearden go first because he hasn't spoken yet.
I think it's a great idea to have like a library of videos in regards to if somebody wants to look up the actual neighborhood meeting that's been pre-recorded. they would have that ability. I think that's a great idea. I think they could go to the website, type in the number, and then it would pull up the recorded video and whatever, and people could put their comments within that particular video. It could be on YouTube, actually, if we just had a certain section, categorize it in a certain section, and then they could look it up there as well and make it really easy for them to just type in the number if they subscribe to the channel, and then figure out where that video's at.
Can
So,
I
yeah.
dialogue for just a second on that, on the YouTube idea? Because I like the idea, but then my question is, do the comments on the YouTube video, you couldn't do comments on the YouTube video because then they'd become public comment, and then you'd actually have to pull those into the record somehow, so that would make it very complicated. Yeah, I just don't think you could do the comments on a YouTube video, but I love the idea of making those videos
Or you can put
accessible.
Vimeo has a section where you can just.
Sure, Vimeo is great. I'm just
Yeah.
saying, if you make them electronic, then you can require them to be recorded, and then people can look at them anytime they want. to
And
get-
I think that's a great idea. I'm in favor of that. I like that idea. Just was pointing out a potential issue with the comments.
Commissioner Beard, you still have the floor. Are you good?
Sorry about
All right, Commissioner Phelps.
Let me give an explanation of what the problem was with virtual meetings. And again, and I'll leave it to the public to testify to support this, because I think most of the people who are here now have been through this, probably more frequently than, as I've said, people in other districts. One of the problems we had was the letter would go out regarding a Zoom meeting, and you know how it has the long address and everything in it? Typographical error. And then what happens? Nobody gets into the meeting. Or the way if we have to set some rules for how, I agree that there's great reasons to do virtual on a lot of things. The problem is that it tended to be controlled by the applicant. They would not accept, all the questions had to be submitted in advance. They picked some questions and not other questions. People got dropped from calls, not recognized. They get letters that, oh, I'm sorry, your letter had a typographical error in it, and you can't get into the Zoom meeting. So you have to, we want to make it easy for people to do the right thing and hard for people to do the wrong thing. And the only way to do that is to have, and I'm not a big government control person, but we've got to have some standard operating procedures. And we've got to work those out based on what hasn't worked in the past. So I do appreciate, I don't recall when we've discussed this prior, Commissioner Cruz, but I do appreciate that I know in your heart you've had my back on this for a few years, and now it's our opportunity to do it. I agree that this is, I kind of wanted to let staff run with this. And to get other commissioners' comments and to get public comment on it. So I would not at all be opposed to deferring this for a vote at later time where we could take the things into consideration that we've discussed. I also had a question for Ms. Schenk. This would be considered ex parte communication if a commissioner attended a neighborhood meeting on the subject, even though if there were no other commissioners there, and it was both the applicant and the neighborhood presenting, and no conversation,
Yeah.
nothing, just observing.
Well, it's a good question.
Because later on, if it's public record, I could watch the video anyway, right?
Yes, excuse me. There's no issue with you watching plan commission meetings or neighborhood meetings electronically. The issue is the time of when they're holding these neighborhood meetings. They've moved them into the pending project after the application's been filed and going through review. And yes, it would be ex parte communications. And it just puts a burden on you to disclose who you talked to and what you heard. And
So I could say I attended the neighborhood meeting on the subject, and that would be disclosing ex parte communication.
well, you have to also disclose who you spoke with or who spoke and the subject matter. It's kind of detailed. Watching it after the fact would be better rather than being
Right.
live.
Or watching virtually without
Sure.
participating.
Yeah,
The-
yeah,
The
that would be the
likelihood of you
best
showing up at a neighborhood meeting live and nobody speaking to you is zero.
Probably pretty
Zero.
slim, yeah.
I did-
But I could bring the duct tape.
I did, just follow up on some of these comments. Sometimes a picture's worth 1,000 words, and you do have a Development Review Administrative Procedures Manual. It has a copy of every application under the sun, 50, 60 pages of applications. You could also refer to the manual in here and have a picture of some signs. You could say, do this, not that, as examples. So anyone coming new to the jurisdiction, every jurisdiction's different. They would
Right.
see, oh, that's what you want, to avoid misunderstandings
Well,
later.
I had an example of some pictures.
And that's better in a manual rather than put it in the LDC.
Yeah, I had an example of some pictures. I just didn't, get a chance to put them out there. So you guys really have to understand this placement of signs. It's very important. Again, you may not be able to relate when you're dealing with a more dense neighborhood or whatever, but we really have a problem with seeing those signs. And the affidavit always shows the sign, but, weeds grow up around it. The wind knocks it down. There's a lot of things that go into real public notification. So I would like to ask the commissioners if you would like, it would not bother me at all to defer a vote on this as is right now. If we could maybe go in and look at some of the areas that you've expressed concerns about, and I'm sure when we open this up to public comment, there may be some good suggestions out there that we might want to consider too, and whenever we want to get to that. Thank you.
All right, I have no one else on the board. Is your do you want to make a motion while you're sitting here to defer this?
Open it up to public comments.
Okay.
Ready to do that first?
Sure, but I also, way past, I didn't expect this to last as long as it did, because I also need, I need to give a recess, and I anticipated this one and the next one to be done before 10:30. So before I open it up to public comment, how many people are going to public comment? We will take a 10-minute recess until 11:55, and then when we come back, we will open up public comment on this item. 10:55. Wishful thinking, wishful thinking. All right, everyone. We are back, and we are still on item number 9 regarding neighborhood workshops, and we are up to the public comment portion of it. Nobody signed up for public comment, but we'll just open it up, first come, first serve. Anyone who would like to come speak on item number 9 relative to neighborhood workshops and signage. Mr. Vandry, you're up first. And this is legislative, so you do not have to let us know if you've been sworn.
Mark Vandery, Manatee County. Good morning, Commissioners. And yeah, I'm glad that you're finally taking a long, hard look at improving how the neighborhood workshops and meetings are done for development and rezones, that sort of thing. I also agree that this particular ordinance is probably not ready yet for a vote on. Needs to be tweaked, actually needs to be worked on quite a bit, I think. It's lacking quite a bit. I think you're overthinking it. Just need to simplify it. Just say, all rezones, all development, mandatory in-person workshops, and a discussion. You don't need a department director's overview. Right now, you have that power as commissioners. You can, right now, require every application, every development to have a mandatory in-person meeting. As far as the timing of the meeting, time of day, whether it's convenient, not convenient, I can tell you, these commission meetings are not convenient for 100% of the people out, and 99% of the people out in my neighborhood off Waterline Road in East County. Fighting traffic to get downtown during the day when you have to work and take care of your animals is really, really hard to come down here and do this. But the meeting's recorded, so people that want to get up to date on what happened or can call in on the meetings, they can do that virtually. Now, my experience with the meetings that were held virtually were totally inadequate because you never really knew if the person making comments was even a real person. There's no accountability there. It's hard to point and discuss matters on drawings and have a dialogue back and forth and see, just read the body language of the applicant, the developers, the people in the room, what's going on. It's way more productive. And I think even many applicants now will agree with me that it's more productive to have an in-person meeting. So you just have to figure out how to make that work. Now, you got libraries you can use, you got churches you can use, you got town halls, maybe fire halls. You got to be a little more creative. If you have to have it outside in a covered tent somewhere, then, do the big top, do that if you're out in such a remote area. But it doesn't have to be that remote. You can have something within 5-10 miles of a development site. There's got to be some dry area with air conditioning that you can have these meetings in. Now, I have a concern that this particular type of ordinance is still going to run afoul of SB 250, SB 180, okay? And so that puts you out to not being able to do anything like this until 2027. But you do have the power now, today, with what's already written in the law. The county commission can make mandatory in-person meetings for all developments, and you could do that right now. In fact, you should do that at the beginning of every land use meeting. Look through the roster, say, okay, we're just declaring by vote, all these are going to be mandatory in-person meetings. End of discussion. Keep it simple. Now, Commissioner Cruz, I agree with your position on Tallahassee preempting local guidance and home rule. I don't understand. I don't know where all of the small government Republicans went, but they're not in Tallahassee. And we're hammering them. We're talking with them. We're not getting very far with it. I'm a registered Republican. I don't know what happened to small government Republicans in this state. Home rule is taking a beating, and that's just not right. I don't think it's constitutional. It stinks. Now, getting back to the details of an in-person meeting, again, you know, out in East County, when we tried it during COVID, it didn't work out well. We were dropping calls, internet was not reliable, or a nearby construction was digging up the fiber optics, and we were out of internet for a long time. Even now, since COVID, we're hit and miss with the virtual attendance. So in person is the way to go with this. But don't overthink it. Keep it simple, and do now what you already have the power to do with home rule. Thank you very much.
Hey, good morning again, Commissioners. Anthony Shulo, Manatee County resident. You know, some of us come down here, and, you know, I don't want to just come down here for one particular issue, right? Like, you're asking for public comment, right? You want to hear from the public, all of you, whether you're my representative or not. So I try to thoughtfully think about, or thoughtfully look at every one of these agenda items that you have and give you some valid public comment. You can take it or leave it. It's just public comment. You asked for it. I'm going to give it to you. I'm here all day, taking my time out of my day to come down here. It's not always convenient, but I'm trying to advocate for my neighbors that can't be here. So please respect the public comments that we share when we can come down here. As far as this, I definitely don't think you should move forward with it at the moment, just because I don't think the language is right. You're absolutely correct. You have to get the language right. A glaring thing in this language that I saw in there, I'll get to in a second, but also please leverage electronic means as much as possible. Teams, whatever that may happen to be, you just have to do it. There's just no way that you know, the in-person meeting is going to fly just by itself. Please leverage electronics. You know, it's the way of the world. It just has to be that way. So please try to do as much as you can. The specific language, though, that I saw on the slide, it said, affect environmentally sensitive areas. In their presentation, it said this is where they want to make sure this signage is in places where it affects environmentally sensitive areas. That's dangerous, ambiguous language. I mean, just doing NEPA permitting for a good portion of my career, the whole entire state of Florida is an environmentally sensitive area when you look at some of the federal codes and so forth. So I think you really should be clear on what that means to the state of Florida, right? And perhaps everywhere else in the country, right? In your backyard, it's environmentally sensitive. If your dog's going to eat, you know, rat poison, right? It's environmentally sensitive to you. So don't put things in everybody's backyard. So just be careful there. I would suggest perhaps using that recently identified watershed areas that are identified by your stormwater managers as problematic. That could be a specifically designated environmentally sensitive area. Again, you have staff that are putting some of these areas together for you, asking for millions of dollars for emergency funding to mitigate things in those areas. That's one area that I just thought of off the top of my head that said, yeah, well, you could really define that. It's not that ambiguous, right? I also wanted to ask you, why can't we use the why can't we electronically opt into the notification systems we already have as an optional box within my radius? So I know it's not an emergency notification and we don't want to burden that system, but Everbridge or Alert Manatee or Manatee Ready, those are just a couple of examples that I think of that I'm signed up for. I define my radius, right? What worries me? Where's my sort of area that I need to be focused on? And one of those examples in there, you can choose if you have mobility or medical challenges or special needs, right? You can opt into that. So you're going to get notifications of things that I might need another 2 hours of notification versus, you know, somebody with a strong back and a weak mind that can run out of there in 10 minutes. I might need an hour, or I have elderly in-laws that reside with me, so I need to move them out. So I don't want to burden that system. I don't know all of the details of how that system operates. But if you want people to possibly get notifications of permitting, can you choose that? Is it going to overburden it? I kind of see it as using a system like that in non-emergency system, or in non-emergency situations proves its worth. It also proves that it's not gonna fail in the emergency system, right? If people are constantly in and out of it and getting familiar with it, then you're not just trying to turn it on, turn that generator on that one time a year whenever you don't have power. We're sort of using it throughout the year perhaps. So those are just some suggestions that I have for you, and, you know, it's a great initiative. I hope you continue with it. Thank you.
Dalton Nelson, Manatee County. Kind of split on the whole in-person versus electronic meetings. I can tell you my experience from the electronic meetings is that they really don't. In one way, they do provide some useful information, but you run into a lot of very interesting situations where whoever's putting on the meeting for whatever developer, a lot of times it's very non-answers to your questions, and when you're a person that's very well educated on what they want to ask and want very pointed, you know, answers to your questions, they try and give you a non-answer answer. I mean, that's just the best way that I can explain it. In-person meetings, like Mr. Vandry said, would be my preference, but it's not just up to me, right? So I would definitely, you know, weigh those options when you guys talk about it. The other thing is too, and I wish he would have stayed, Mr. Whitaker, Chris Whitaker, that's surrounded by another project that we won't talk about. He's literally engulfed by that project, and the applicant literally said, I have never talked to this dude a day in my life, and he's right there. These notification processes do not work. For whatever reason, I feel like if you're at least 1,500 feet from this development, okay, in District 1, for example, with some other projects that are in works, I mean, we're more than 1,500 feet from our closest neighbor, much less the project that's going in right across the road or right down the street from us that, you know, is going to affect how our roads our drive-in, if we have to wait longer to get out of our driveway, the safety of our kids trying to wait for the bus, stuff like that. You know, there's a lot of different things that you guys really need to tweak on this, I think, and bring it back and put it into effect. And it may be, you know, a situation where you have to wait till 2026, but leverage what you have now, try and make it, you know, the best out of a bad situation, and hopefully we can make it better for everybody. But that's my public comment as far as the situation. The public workshops and meetings and stuff, they have to be something with substance for the community to get anything out of it, or not. It's just the same presentation that they give you with non-answers and, well, this is where we think this stuff's going to be, but we don't know. So anybody can come up with anything and say it's the best idea in the world, but until it works, it's just talk. Thank you.
Hi again, Stacy Jesse, Manatee County. I love this conversation that we're having. I do think it's important. I represent East Manatee Preservation Association, and one of the big things that we try to do is to promote community engagement. And so a lot of what we get is people see these yellow signs, and then I get a Facebook message to our page, hey, there's a yellow sign on such and such road. What does it mean? And to the county's credit, there are two maps that we send the links to everyone. It is the project map and the land development map. And all I've got to do is, okay, what road is it on? And you go to the map and we click it together. And then it will tell you, you know, what the meeting, what's going in there, the number of houses. It says the planning commission date, the land use meeting date. There's even a link to its Acela stuff in there. But what's not there is the neighborhood meeting date. And for a lot of people, you know, I'm walking them through this, explaining it to them. The first time they will see the maps for these projects is at the planning commission or something like that. They don't know how to navigate Acela. So the neighborhood meetings for a lot of people are a way for them to go and be like, oh, I knew that was coming, right? I don't care. And I think a lot of us forget, like 80% of these meetings, like people are like, oh, that's what it is? Okay. You know, we're not, Commissioner Cruz all militant, NIMBYist, trying to get rid of everything. I have so many people like, oh, okay, that's what it is. And so that's what a lot of people just need, is that reassurance. Oh, okay, that's all. That neighborhood meeting, like, check, I don't care, and they can move on. And so, I really do like the idea of having those neighborhood meetings for a lot of people to see it in person. I hate going to them personally, so please record them because I don't want to sit there. But no, so I think you guys have some great ideas. I live in a community development district. I didn't know that when I moved in, but now I do. And we've had a bunch of development projects come in across from us. And one of the things I saw with the failings with the mailings was like 3 neighbors right off of Rye Road would get the mail, but our CDD never received it. And it took back and forth with Bobby a number of times to figure out, hey, why isn't our governing district receiving that? So there are definitely, I think, some kinks in the system that should be worked out, but I'm really appreciative that you guys are here trying to keep us informed. So thank you.
Everyone who was talking was behind you, and I kept seeing you start to get up, and then Stacy would get up, and Dalton would get up.
They all beat me. They're impressive, and I'm old. What can I say? Elizabeth Arnold, Manatee County. I really want to thank you all for taking on this topic. I know it's a tough one on a lot of levels, and I can see some of us that are getting up here don't even agree, so I can imagine how hard it is. The first thing I think that would be wonderful is when they send out letters that they be certified. Because I got a letter recently, and actually it's happened a couple of times, and it looked like junk mail to me, but I recognized the name at the left-hand corner of the envelope, and I recognized it was somebody that I'd seen before the BOCC presenting things, so I opened it, and I realized, oh, it's something that's going to affect me and happen in my neighborhood. So that's really important. I think in person is my preference. I struggle sometimes because sometimes it's Zoom, sometimes it's Team. On Team, I had a computer that was getting the picture and my phone was getting the voice but no picture. So that's kind of one of those, I guess if you're older, maybe you're not as technically savvy, I don't know. And I also have seen where the neighborhood meeting sign said the neighborhood meeting is going to start at 6 and here's the phone number and all the stuff. And then somebody put out the letter on Facebook, and the letter said 6:30. So if I had called in, because I'd only seen the sign, and had somebody not put the letter on Facebook, I would have called in at 6, and there would have been just nothing. So there's some discrepancies going on. I don't really know how you fix that. I also personally believe that 1,500 feet should be the minimum, because I went to a neighborhood meeting recently. Only 2 people showed up. The neighborhood has 42 houses in it, and some of these houses are on little tiny lots. You have houses stacked around each other, and the majority of people in that neighborhood didn't even know what was happening until the sign went up a couple of days ago, whatever, that there's going to be a change in the neighborhood, and they didn't even know what it was about. So the letter should go out further, and there definitely needs to be a sign for neighborhood meetings so that the neighbors can actually come if they accidentally threw the letter away. So, and personally, I agree with Mark. I think we need to start this sooner somehow, I don't know how, than later, and, work out the details later, but I think we should start pushing the idea of sending out letters for 1,500 feet and at least causing them to put up signs for the neighborhood meetings, because right now, that's not required. And let me tell you, there are people that, when asked, why didn't you put up a sign? We weren't required. And they actually sent me the information proving they were right. Google told me they were. They had the proof. They weren't. I called staff and even verified it. They weren't required. And that's sad, because I have a whole neighborhood that's brokenhearted, really. So it's important to put up signs and important to go further out. And thank you very much.
Are there any other public comments on this topic?
Go ahead. I got a straw.
Good morning, Dave Dean, Manatee County. Having worked for the post office for 33 years, I have to disagree about the certified letters. I don't think they're necessary. Perhaps what we need is to have a standard notice on the envelope of what it is inside, in bold letters, neighborhood meeting notice, or something like that, a format that they have to use for the envelope for those letters. Certified mail, in my experience, is my poor rural carrier has to drop me off a note. I have to initial that. He has to bring it back. I have to sign that stub. And then who's going to do the follow-up of, okay, show me all your stubs and all of that. I think you just, again, you're complicating things here. I think I laud your goal, better public notice. I can see both sides of whether you want it in person or virtual. And I agree with the other commenters there. If you have it in person, it should be available as a recording for people to look up online. Thanks.
Hello, my name is Bob Gosling. I had no intention of getting up and speaking here on this item today. But as a guy that's been dealing with the public notices on the private side for the last 40 years, I thought it might be helpful for you guys to actually hear what we do. Now, Ms. Layton and Ms. Greer have also worked on the private side and probably can tell you if they've dealt with it differently. But I thought it would be helpful for you to kind of know. First of all, I do think you need to push this and defer it for a little while, for the simple reason that right now, if you go to the property appraiser's website too, and you'll see a picture of it when I do my presentation on my project, you can only go out 750 feet. Now, it may be an easy change for the property appraiser to make, but that's where we go for our labels. And right now, we can only go 750 feet. So if you require more than that, we will not be able to produce it until that is changed. So you need to get that done first. Secondly, just to kind of let you know, in-person versus virtual, I've done both. It's usually driven by, do we have a reasonable place to do it in person, or, you know, COVID's when we all started doing a lot of virtual. I've done both. They both have pluses and minuses. Ms. Phelps, you know, I facilitated the meeting on Salita. And the main thing you're doing as the facilitator, whether it's virtual or in person, is you're trying to make sure that you get the information out, that you get the questions in, that you try and answer the questions you get, and you try to avoid having anybody hijack the meeting by just talking over you. So, you know, that's what you're doing, and hopefully it all works. Staff, we do a sign-in sheet. So we try to get everybody to sign in to show who showed up. Sign posting is not something that's ever been required in a neighborhood meeting. The commenter that was up here commented, I'm the guy that said that. It was in response to a statement made to me by her saying, you have to post a sign that this meeting doesn't count. And I said, that is not what the code calls for. It's not a requirement. So that was actually the discussion, not, we didn't do it because we didn't have to. We didn't do it because we didn't have to, but the actual comment was in response to, this meeting doesn't count because you didn't post a sign, and me saying, the code doesn't require that. And I think staff ended up confirming that as well. Letters, right now, 500 feet. I've sent out literally close to 300 letters within 500 feet. On the project I'll be about today, I think it was 28 or 29. I will tell you that on the bigger numbers, we oftentimes get letters returned to us by the post office. There's a reason for that. And the common thread seems to be that people change their address and don't notify the property appraiser. On Salita, that happened. Somebody knew, and I was like, I know her, and I went back and checked a couple times. They never changed their PO box, and so every time I sent her a letter, neighborhood workshop and for the hearing, I got it back. I can't fix that, and quite frankly, you can't fix that either. You still have that problem. The other thing is the letter goes to the property owner. Does not go to a tenant, does not go to a renter, it goes to the property owner. The property owner may live here, the property owner may live in Canada, that property owner may live in Germany. Certified letters do become a problem. Also, the postal guy that made the comment, the other problem with certified letters is there's no requirement that if I send you a certified letter that you sign it. The post office doesn't require their mail carriers to get them signed because, quite frankly, of COVID. They don't want to put their mail carriers at risk. So now, how do we even prove that somebody got it? Because I've sent certified letters to people before and had them say, I didn't get it. We're sure they did, but can't prove it. We send minutes of the meetings to staff. So staff gets from us an affidavit, which, by the way, as a registered professional, if I'm going to sign an affidavit and have it notarized, do you really think I'm going to lie about it? Probably not. I don't think that an attorney would either. And so, to suggest that we would is offensive. We send minutes to staff, we send them an affidavit, we send them the list of who we sent the letters to. And I have been known to come in here with all of the ones that came back to me, just so I've got the proof. I don't have it with me today. I don't think I got one this last time. So those are just some of the things. The videotaping, the things, I think one of the things you're going to have to deal with, I don't really, quite frankly, know how to deal with it. Videos are huge file sizes. I don't know how you email a file size that may be 40 to 100 megabytes in size. I don't know. And I don't think that you're going to want to store those on your server either. But nonetheless, think about that before you require it. Again, I think that there's things that we can do, but I think, honestly, the problems that are being represented are more in theory than in reality, because from what I've seen, the system works pretty good. Staff, I've had Bobby Roy call me after a storm saying, I just drove by and your sign's down. Well, we go out and post it. In fact, now we go out and try and take a look every now and then just to see if it's still up. We do try to make sure that it's posted where you can see it. So anyway, I do think you need to delay it, but just want to let you know some of what we do. Thanks.
Thank you. Any other public comment on?
Like Mr. Gauss, I actually hadn't intended on commenting on this, but at this point, I feel compelled to make a couple of comments. Oh, I'm sorry. Larry Arnold, Manatee County resident of the neighborhood that Mr. Gauss was just referring to. So sometimes his theory is our neighborhood's reality. So I'll start with that, and we'll talk about that more on the agenda item that's intended for. I would suggest that today is a wonderful step, because what you're doing is taking steps to basically improve a system that has been biased towards development forever since I can remember in the state of Florida. And given my age, that's a long time. And I'm going to skip a few things that have already been well covered. The longer the notice, the better. The sign visibility is absolutely an issue. Can't show it to you because I guess it's against rules, but I can show you a photo of one sign that has been posted over on Rutland Ranch Road that you would need either binoculars or some sort of vision aid to even be able to read it. Only the fact that it's bright yellow gives you any idea that it's a sign at all. So that longer notice, when you have a large project, say you had a project of 1,000, 1,200 acres, 3,000 units, the notice right now is not adequate for the community and the neighborhood to address that. And just a couple more comments and I'll be out of your way. Meetings are, I think, in-person meetings. I think the idea about supplementing that with the new technology is a great idea. Both, that you can't over-inform the community and the public. And what I would suggest to you is the in-person meetings. Commissioner Chairman Cruz, the Baptist Church at the corner of Verna Bethany and 64 has hosted meetings and does a really good job on those kind of meetings. And it's fairly close to the areas, at least, that we're talking about now. And the remote meetings did not work. I watched my wife, we're here on our 49th anniversary, by the way, just really get frustrated with those meetings, a lot of which, unfortunately, the developers weren't involved at all. It was some design folks or some engineering folks, and it was whoever had to work past 7 or 6:30 and was in the office giggling away in the background. Heard that a couple of times. That was really wonderful. But my real reason for coming up is the comment about the timing on this. You know, and I'm going to make this comment again in a later item. Do not let what was clearly another end around at the legislature and having information pertaining to development tagged onto a meeting, onto legislation that was designed to address post-hurricane emergencies end up intimidating you from acting on the things that you need to act on. The facts that you have for you, and I'm not an attorney, so please don't be offended, but the facts that you have going for you on that in terms of you're going back to standards and a couple of major standards that existed before Hurricane Ian and were only changed briefly. And probably more importantly, at least on one of those, the wetlands, it actually is important and improves your likelihood of a favorable hurricane recovery. So don't let what big money did in the legislature, and by the way, Chairman Cruz, I'm familiar with the process, and I think you'll find a lot of people in this community responded to your call and other calls and contacted the legislature. That's why some of that really terrible legislature died. It only dies or gets passed two ways: a huge public outcry or an absolute solid, from day one to the end of session, lobbying effort. That's how they get stopped, and that's how they get passed. And yes, so we called, and I know of dozens of other people that called or emailed our local representatives because that was the right thing to do. Thank you.
That's why we don't have ag enclaves in that final bill.
For the record, Glenn Giblin, I have not been sworn. Just got it.
It's legislative.
Oh, okay, we're good. All right, so I want to address some of the issues, some of the comments by Mr. Gauze. First of all, the certified mail, right? It's called return receipt requested. They sign it. Everything I send out certified, return receipt requested. I get it back. Somebody from the AG's office signed for it, and I have a record of that. So there may be a lot of out-of-town owners. Does it matter? It affects the tenants who drive every day. Could be that nurse, that firefighter, that police officer. That's who you're affecting. So you can just do a general mail to that house and let the tenants know, because they have a vested interest as well, and they should. And I got to tell you, I've been watching the meeting this morning. It's no laughing matter. I'm disgusted on some of the commissioners laughing. I just don't get it. As far as the files too big, I iPhone my meetings and I throw it on YouTube, and it doesn't cost anything, and it can run for hours. So I don't buy this, how are we going to send it in the file? That's ridiculous. I just don't buy it. Again, these meetings, they're good as long as they're done properly. Just because the owner's not there, the tenant, it affects the tenant who rents that place, who has to travel the roads every day. And these developers should be bending over backwards to make sure these are done in a timely manner. Everybody is respected, whether they own the property or not. And it should be video recorded. It's not a big deal. Jason can tell you it's not a big deal. You could download a file. You could put it on YouTube. You could put it in MPT. There's a lot of, so this, well, you don't want to keep it as a file. There's every YouTube ever done at this commission on YouTube, right? Let them hold it and have it accessible. For the record, Glenn Gibolino.
Any other public comments on signs? Dalton already spoke. No one? And there's nobody with their hand raised on the phone. So I will close. I was waiting for that. All right, this is legislative, so we are on the phones, and they did put their hand up. Caller 868.
Hi, this is Carol Clark from Manatee County. And kind of like Bob Goss, I have dealt with this on both sides for a very long time. A couple of things that I'd like to share somewhat logistically. The certified mail thought made me twitch here. It is much more expensive. And I've had experience previously in another county where, specifically with code enforcement, we would always send a notice that didn't have a return receipt requested and didn't say that it was from Haskell County, because people don't necessarily will go to the post office to pick up something or sign something if it's from the government. So just a thought, I think that's, it's $4.85 for certified mail. It's $78 as of July 13th for first class. So it's expensive, and it's logistically more difficult because you have to put those cards on and so forth. So that may end up being actually both costing more money and getting less result. On the visibility issue, I have struggled with that in the past. And part of my problem was the requirements are that it be behind the property line in areas where there is extensive public right-of-way. It's very hard to find a spot that is on the property and the right-of-way might be overgrown. So it may be something to think about adding the ability to post on the right-of-way so you're as close to the road as possible. I think one of the ideas might be to sort of get together with the public folks and property appraiser and Bobby Roy and applicants to come up with a set of best practices, because there is range of things from a property that may have 6 neighbors to one that's going to have 1,000. And what's being proposed will be different, and the requirements might be different. I understand coming up with a standard set of practices, but you can always do more. I would always send out a letter with a notice giving people my cell phone number. And sometimes that was for notifying 10 people. Sometimes it was 1,000. So anyway, thank you very much.
Thank you, Carol. All right, that was the only caller, and everyone in the room has spoken. I will close public comment. Sounds like we're continuing this, deferring this, wherever it is, but I do have 4 commissioners on the board. Commissioner Ballard.
So just briefly, I wanted to address just a couple of comments from people in the room. Mr. Shulo, the Everbridge idea, I actually love the idea. And about a year ago, we were trying to explore the possibility of sending out messages from the county that were not related to emergencies. Unfortunately, we're not able to do that. So that geofencing technology, it is subject to regulation through the Code of Federal Regulations, and they're only allowed to do wireless emergency alerts, and it's regulated by the FCC. So it is something that we've thought about. I think it could potentially be very helpful, but I just don't think we have the ability. Mr. Jean, my mother was a rural mail carrier for 35 years, and now that you mention it, I think that she would kill me for saying that that we should do certified mail for all of those. I think the suggestion for the standard envelope, what it should look like, I think that that's a great kind of middle ground to give people the ability to know, hey, this is important. This is a neighborhood meeting that you're going to want to go to, but not putting such a high burden of the certified mail. So I really like that suggestion. And Mr. Gauze, thank you very much for the information about the property appraiser not currently providing the information that we would need for applicants to actually send out that notice. So that's, we'll have to work collaboratively with them as we do this to make sure that applicants can actually effectively get that word out there. So thank you. Those were all very helpful comments, and I look forward to further discussion on it.
Thank you, Mr. Chair. I'd like to thank everyone for their public comment. I think you all gave us quite a bit to ruminate on. Walked away with a couple of thoughts and maybe some suggestions to this board and staff to consider. We talk a lot I'll start with notifications. We talk a lot about wanting to see better engagement, but I don't think I've seen as much information outreach from our county and staff on ordinances as much as I've seen on, by way of an example, trash bins. I think that got a fancy social media post, but when we're passing ordinance, we're passing a fairly, I would say, a substantial piece of legislation, and I think it warrants putting out enough information to the public so they can at least participate. I'm not going to use the attendance today as a gauge. That can vary day by day, weather, traffic, what have you. But I think we have a couple of outlets that we can leverage to better inform the public. The first is the news flash. I don't think I've ever seen any ordinance proposals come through, but if there was anything worthy of an addition, I think effectively a new law or local ordinance should be an addition to the news flash. Second, I think this does need a little bit of work. I think we should, well, I'm not going to suggest, there's a couple of different ways to skin the cat, but I think there's something interesting that Mr. Gauze's comment raised, and it's, I think when we're passing an ordinance, we should ensure that we're factoring in, we're building consensus. We're getting feedback and information from everyone who is affected, getting the consent of the governed, if you will. So I think there's really a message to staff, and I didn't quite hear that anyone actually reached out to any applicants, current or former, but we got a lot of feedback, and I could tell from expressions on this board that there are some pieces of information we didn't quite know, and I can tell you we certainly didn't either. So I think, by way of an example, when I was working on the short-term vacation rental ordinance, I proactively reached out to some of the special interest groups and residents, folks for and against, to get feedback. I was still firm in what I wanted to see done, but I at least reached out to them to get feedback on ways to make this better. So I think for this and really any other ordinance, I think if there's staff involvement, I think there should be outreach to the affected or individuals, in this case applicants. Whether we like it or not, it's only fair that we get their feedback, and so that we can ensure this is a fair process. We do a weekly projects list as far as notifications are concerned. That's fairly hidden on the website. You have to kind of look for it, but it only covers a small percentage of the projects that tend to happen, and it can be everything. I was just looking from something about an animal shelter to a project showing up before a board. We talk a lot about public-private partnerships, so if we want to make some things easy, perhaps we can, as a county, stand up a website or leverage the GIS maps and just put a layer on there that says, hey, here's all the PDRZs and developments and so on that are going to pop up. It's not quite visible today. It's spread out in a couple of different locations. I was looking, there's GIS layer, there's which is actually a little bit challenging to get out to learn about, or to leverage and access. And then there's the weekly projects list. So the span is quite far. And so I think if nothing else, then the solution needs to be we kind of consolidate some of the different data sources and just tell people, hey, go to this website if you want notice, while we also work out the kinks in this, some of the next steps here as well. So yeah, I think we just need to work a little bit more on the notifications. I think we have a couple of different mechanisms to use. The news flash is one of them for all ordinances, not just this particular one. Consolidating some of our different data sources, and of course, building consensus by reaching out to, in this case, applicants, but in the future, anyone that can be affected by any ordinance. Thank you.
Thank you, Mr. Chair. Currently today, Nicole, do we have an FAQ sheet that's attached to that when we send it out, those notices?
We don't send the notices.
I'm sorry, do we require them to have an FAQ sheet?
No, they
Okay.
send a letter that describes the project in summary and the date of the meeting.
Okay. I'd like to make a recommendation as far as what we require them to send out as well, is an FAQ sheet, meaning, will this increase traffic? That could be a question. And then, so that, because a lot of residents that may get these may not even understand what they're getting in the mail, right? How will stormwater be managed? Question and answer. What hours will construction occur? Question and answer. That's kind of a recommendation that I would go. That way, if somebody sees that, they can say, oh, wow, this is going to increase traffic. Now I have public comment on this. I want to attend the actual meeting itself and see, how that's going to be managed, right? I think an FAQ sheet would be very helpful to the residents that get these letters. And if we make that a requirement, we could bypass a lot of these issues that people are having if these questions are already answered. I'm good.
FAQs. No. It just, it ends up being like a walking, I mean, I've been doing this for a pretty long time. And I wanted to put it up here to get this kind of feedback, not just from our citizens, but I very much appreciate hearing the other side of it. My recommendation, okay, here's where we could go with this, and we really do need to move on because there's so many details about this we could talk about forever. I am, you know, as with Commissioner Ballard, it would be great if we could do a broadcast of, oh, look at this week's project list. Do you know how long it took us to get the project list actually in the public's hands? Do you know, I believe, Commissioner Sadiq, I think I sent you your first project list, and you didn't even know what that was, did you? Commissioner Bearden, when you took office, did you know what a project list was? Well, there's where we have to start, people. We have to understand we're making decisions on land use, and we don't even know our own process and procedure, do we? So where I'm telling you, these people know, and this commissioner knows. So I have appreciated everything you've said. I believe that we have some dealings to do with our applicants to make sure their needs are. So I'm fine with deferring this as long as we do it upon the condition that, okay, here's where we could go. We could take the skeleton, we could take it as it is right now, and we'll be back after recess to maybe give you a little bit different tweaking version of it, or we could wait and tweak the whole thing based on the information that we've gathered. On one sense, I think we have too much going on to let it go. It's taken 8 years or more to get this to this point. And we've got this signs thing going on. We've got to bring up examples so that we could show you the difference between I put up a sign and I put up a visible sign. We need to work on, like we suggested, about the website, getting the project list out there, You know what we just accomplished with our new website? Now, when you get the project list, which is posted on the website, okay, it has the PLN number that you could go and find more details about it. But our government communication hasn't been too strong in that area to teach people Land Use 101. I commend you on our Citizens Academy. We're actually saying those things about the project list. Anybody been to a Development Review Committee meeting or know what they do, who they are? No, but we're making decisions every day, but we don't even know the process and procedure of our own county. So I ask you this. Let's take what we've got so far, and I'd like to, you know, nod your heads or whatever, but we've come so far with doing this. Can we just accept it for how it is right now to have something to work with? And then maybe we'll be back, we'll work on a little bit more with staff over our recess and come back, because what I'm afraid of, if we don't put something in place right now, we're going to lose those opportunities to have the neighborhood meetings that we do need to have right now. And then maybe we could come back August, September, whatever, with a more super refined version. So which of those two do you think would be in the best interest of the public?
Motion to approve. The ordinance as it stands right now.
You don't approve the ordinance without bringing it back?
Yes, and then I think that what Commissioner Feltz would like to do is have a workshop later and maybe make changes to the
I
ordinance.
don't think, I mean, you can make whatever motion you want. So there is a motion on the floor. I currently did, Commissioner Feltz, did you second it? Yes. I mean, I think we all just admitted that A, we meaningfully want to do something, which is the intent of the ordinance. But B, we don't even know what this ordinance means or the impact for it. We're being told factual information that doesn't align with it. My only concern is you're going to pass a random ordinance and now we're going to direct staff to go through and change all of our codes and policies and directions and relay that to everybody for a few weeks and then come back for a work session and change it all again, have staff go back and change everything over again and alert everybody a second time. That seems a little silly. That seems like we're just arbitrarily passing an ordinance that we've all agreed has tweaks necessary
Can
just to
I-
do it again.
Can I ask, how much work is it to actually implement the ordinance and then pull it back? Or make changes? Is it a huge burden on staff to do it this way, truthfully?
Commissioner, if I could, I would say it would be more effective and efficient if we could get it right, or at least closer to right, after the recess and come back to you with another draft. Because once we start applying this, once it becomes effective 30 days from now, we can't apply it till it becomes effective, first of all. And we're going to change procedures internally in our department to then possibly 30 to 45 days later change them again.
So I will withdraw my motion. I don't want to put everyone in that situation.
Can we make a different motion?
Sure. Can I recommend a motion as an interim, because I can't make one? Can you just make a motion to change the word shall or may to shall and require all work sessions in the current confines of what we already have to be mandatory from this point forward? To at least that's a stopgap to require neighborhood meetings, based upon the current rules about how the notification periods and everything else the same, but make them mandatory now, and then we can go back and clean this up later. That's a
I like
simple
that.
fix.
So we would change so the motion would be to, instead of this, to just change, make it very simple motion to change neighborhood meetings, the verbiage to be
Yeah, from May
shall,
till shall, just make them required.
and across the board,
Yes.
all land use issues.
Yep, make it simple.
I think Ms. Shank needs to weigh in on that, because the ordinance
Yeah,
presented
Mr.
to
Chair,
you.
at the very least, we need to rewrite the ordinance during lunch hour, bring it back. You have to have in front of you what you're adopting, at the very least.
I can't make a motion, but Commissioner Feltz, I mean, I think that's a good stopgap. At least we're making these mandatory for now, and we can clean up what the mandatory looks like and how the notices is with more thoughtful, but at least we're not allowing people to skirt the opportunity to do neighborhood meetings right now.
Would you allow me at lunchtime to work with staff to refashion the motion?
Knock yourself out.
object to
Yes. Make a motion to, I guess we don't have to make a motion, right? We could just, yeah, just bring it back. Go, you
So we
work
don't-
with,
they
you
don't
work.
get a lunch?
What?
So the staff doesn't get a lunch break when we have a really long meeting today? I'm sorry. I'm just trying to, it's not a 5-second fix, so I need better direction than that. And again, we would be changing our procedures to bring it right back to you. It doesn't end with a different result.
Just bring it back after recess. I don't care.
Okay.
And,
So that's the motion.
excuse me, if I could just point out the existing code section. So the existing code section, 312.6 says, it does begin, applicants are strongly encouraged to hold a neighborhood meeting during the application process. It says the department director or the board may require an applicant to hold a neighborhood workshop for any application that, in the view of the department director or board, has potential neighborhood impacts. So, my question being to Nicole Knapp, do you feel comfortable requiring neighbor workshops on certain items, and rather than saying they're encouraged at your pre-app meetings and stuff as a temporary stopgap measure till they amend the code? I mean, you have the authority here now.
Yes, and we've had enough testimony or comments today that I understand what the concerns are from the board and what direction of what items they're most concerned with.
So it'd be, I'm a little bit uncomfortable with changing the language as much as Commissioner Crew suggested without having it in front of you, and it is.
Well, we just had that,
Yeah.
we just had that discussion though, Sarah.
So-
We decided not to because of, the
Okay,
decision was
okay.
to bring it back after recess, so that's not relevant anyway. But what you're saying is the language already in there that doesn't require changes or votes or anything already effectively allows for some indication of mandatory allowance at the discretion of Development Services, and Development Services has heard the concerns of this board, and we use their discretion to make those meetings mandatory to the fullest extent of the existing language. And when we see a project in late July and early August and so forth, just like we've been doing with wetland buffers, and it does not conform to having met the threshold this board is requesting of the applicants to have neighborhood meetings, that will be taken into consideration by this board when determinations are made.
Or, if I may object, or you could continue the application and say, applicant, how hold your neighborhood meeting, because you haven't
Okay,
done it.
I think we're way overthinking this, okay.
Well, I'm just saying.
Do I need to
Okay.
make a motion to bring it back after recess, or what?
No. Do we need a motion to bring this back?
We don't need to do that, right?
We need a motion to at least continue because it's advertised to be adopted today.
Okay, we do, okay. Go ahead, Commissioner Beard.
I make a motion to continue LDCT -25-03, ordinance number 25-19, County Initiated Land Development Code Text Amendment, Neighborhood Workshops PLN 2502-007 to
Say time, no time certain.
No
We-
time certain.
We don't know the exact time. I'll second that. I have a motion by Commissioner Bearden to continue this item to no time certain, seconded by myself. You can vote now. And that is approved 5-2 with Commissioners Phelps and McCann in opposition. Okay, I know we're getting up on lunch. Real quick, item number 13, I'm jumping ahead here because this is not even a discussion for continuation. This is just a vote, because they never even finished planning commission. Is anyone here for item number 13 who's sitting around for the purpose of item number 13? No? Okay, so that doesn't matter then. I just wanted to get people out of here. Item number 10, it's 11:53. Item number 10, is this just an update on what's going on? So why don't you make sure we get that out of here? No, because nobody was here anyway, so I'll just do it in order. Just in case somebody was figuring it was gonna be after lunch and they're sitting over a bridge or something. I was gonna watch it.
Do we need to read it into the record first?
Yes, I do.
Okay.
Item number 10 is ordinance number 2517, Plan Amendment 2502, which is a county initiative comprehensive plan text amendment. This is the repeal of ordinance 2112, which amends your comp plan to preserve land east of the future development boundary area for primarily agricultural uses and to contain urban sprawl, providing for county-initiated text amendments, amending element 2, future land use element, and amending and restating several policies and objectives to delete an exception of eligible new development proposed for lands east of and coterminous and contiguous to the future development area boundary, meeting specified criteria, providing for amendments as necessary to maintain internal consistency, repealing ordinance in conflict, including without limitation, ordinance number 2112. And your staff presenter is Rachel Layton.
Now, my question to you before we get into this, because that's why I asked when you were sitting down, is this a quick little, here's a three-sentence update, now let's all go to lunch, or is this going to be a long thing? Because I'm taking lunch around noon because one commissioner has to step out. So if this is going to become a thing, we're just going to hold this off till after lunch. If this is just, hey, I just wanted to give you a quick update on a letter we got from the governor, then you can do that.
It is just a quick update.
Okay.
Rachel Layton, Manatee County, resident and Manatee County staff. Sorry, I have a bug flying around.
You know you're on video, right?
I have been sworn. Yes, I know. Florida Department of Commerce did send Manatee County a letter on June 6th claiming that the proposed comprehensive plan amendment is burdensome and asked us to reach out to them for technical assistance. I have that meeting scheduled for Thursday, June 26th at 10 a.m. With that, we will go through policy by policy to identify what is burdensome and what is not so that staff may prepare a response back to the state. No other agencies gave us comments on this one. We did receive one letter from the Department of Florida Fish and Wildlife with no objections.
Yeah.
That's the brief.
And to be fair, that commerce letter wasn't like, hey, this may not be a good idea. They were pretty specific. They were basically saying this letter can constitute an exhibit in your lawsuit if you attempt to do something. I mean, they had some pretty stern language at the tail end of that.
But they also offer the technical assistance.
Understood, but my point is they basically said, do not do anything until you talk to us. So
Correct.
this is basically just
This is the
effectively
next
a
step.
continuation pending staff's discussion with Florida Commerce.
Correct.
To figure out next steps, similar to what's going on with the wetlands.
Absolutely.
So heading into lunch, I'll open this up for anyone who wants to make a motion to continue this.
Motion to continue.
Second.
I have a motion by Commissioner Siddiq, seconded by Commissioner Ballard. I will open this up to public comments. Seeing none, I will close public comment, and we could just do a voice vote. All in favor, please say aye.
Aye.
All opposed?
No.
As approved 6-1 with Commissioner McCann in opposition. Okay, we are taking lunch. It is just about noon. We're going to take lunch till 1:30. And when we come back, we will continue on with item number 11, Seagrass Point.
The 25 meeting. I'd like to call this meeting to order. We do have a quorum, and I thank you for that. Right now, as we do at all of our meetings, we always start our meetings by honoring God and honoring our great nation. This morning, we have Chaplain Jeff Holton of the Anchor House that will do our invocation, and we have Marine Combat Veteran and County Commissioner and Port Authority member Jason Bearden will do our pledge this morning. If you could please rise if you can. Thank you.
Please join with me in prayer. Lord, thank you for this day that you've given to us. The beautiful sunshine, the beautiful weather. Lord, we have so much to be grateful for and to be thankful for. And Lord, that you are the one that we can thank. And Lord, this morning I pray for this meeting, Lord, that your presence would be present and that everything that would be done for your glory, for your honor, and for the good for this port altogether and for the community. So Lord, we just pray your blessings upon this time. We pray your blessings upon our commissioners, upon our Port Authority staff and businesses, everyone who is working here in the port, and we just ask that you would be present and blessing us as we continue to do the work that you've called us to do. We love you, we praise you, we thank you. In the name of Jesus we pray. Amen.
Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, gentlemen, and thank you for your service. Right now is what we normally do is we go through the audience and do introductions. So does someone have the mic, and where would you like to start it? It's not karaoke, just say who you are and what you do. No, I don't think it's on. Oh, there you go.
Troy Layton, Seaport Manatee.
Virginia Zimmerman, Seaport Manatee.
Denise Stuffelbeam, Port Staff.
Jennifer Cowan, Port Council.
Jeff Holton, Executive Director, Anchor House.
Dan Fitzpatrick, Port Staff.
David St. Pierre, Port Staff.
Billy Savage, AR Savage and Son.
Arthur Savage, A.R. Savage and Son.
Denise Tuck, Del Monte Fresh.
Selena Cunningham, District 1 Commissioner Aide.
Malcolm Edwards, Port Staff.
Carlo Barbieri, Oxford Group.
Denise Hagee, Manatee County Clerk's Office.
Dustin Peebles, Manatee County Clerk's Office.
Stephen Hesterberg, Gulf Shellfish Institute.
Pam Wingo, Port Staff.
John Glass, Port Staff.
Andre Dubois, Logistec USA.
Joao Sanogueira, AME Salt.
Robert Howard, Port Staff.
They did it. Yeah, they did it, Carlos.
Okay.
Thank you very much for the introductions. What I'd like to do now is open up, if there's anyone in the public that would like to give public comment, this is the time to do that. Seeing no one give public, I'll close public comment, and I'll turn it over to our port director.
Thank you, commissioners, Port Authority members, for being here today. I know it's not an easy drive, but I think this is the economic engine that, is running a significant part of the county in terms of impact and jobs. And your service here is truly appreciated. I know that the community, the business community here really, really loves to see you here. Not necessarily every month, which is what we're not doing, but every quarter, when you can be, I think, unique importance to make them realize that, there is a board that is not the county board, that's the Port Authority board, and that board is really focused on the port. So really appreciate that. Today we have two very, I think, unique and important speakers. First, we have Arthur Savage and Company and Sons, and we both have Senior Savage and Junior Savage here, Billy and Arthur, who have been around, and if you want to come up now, Arthur, for your presentation, literally almost a century or two, Arthur? Century and a half, right? So I'm trying to turn this on here, I think. To talk about, what they do, how they do it. It's a very well-known company. It is now also affiliated with another company called by the name of Vagunsa Terminals, which we brought in from Chile about a year and a half ago. And so they've joined forces, right, with AGS. And so as a result, Arthur Savage is going to provide a brief presentation of what's happening with AGS and Arthur Savage and what's happening in Tampa Bay.
Thanks so much, Carlos. I appreciate it. Actually, I haven't seen you since we were down in Santiago together, right?
Yeah, indeed. That's right. We travel the world and we see each other 4,000 miles away, but not locally. So.
Thank you for having me. I appreciate it. Are we on here?
Okay.
Are we on here?
No,
Is that
so-
better?
No. Oh, no, it seems to be going off. Do we have another microphone, please?
This is, if y'all can hear me, I can do it without it too.
Well, we need the microphone.
Yeah, you need it for the
Need to
record.
call that video.
Right.
Record. Make a motion to approve audio visual stuff.
Tell them to try to pull it.
I already got it.
Thank you. Thank you for coming.
Hello, is that better?
Yes, sir.
There we go. Thank you.
Thank you.
Chairman. So I thought I'd spend a little bit of time with this slide. I wrote a book about, 2016 on the waterfront history of Tampa Bay. And in that research, we found some great images. So I thought I'd share some of those and use that as a place to start. As Carlos said, we've been here a while. Our great-great-grandfather sailed into Tampa Bay in 1845 from Scotland and started regular shipments between Tampa and Cuba, carrying cattle and lumber. And that went on to carrying cattle over to Galveston and Mobile and other areas like that. So we've been here a while, and in the 1920s, my grandfather Savage came here with the Atlantic Coastline Railroad to run our only deep water port at the time, which was Port Tampa, over on the Inner Bay Peninsula. And he went off to the war, ran Port of Plymouth, England, and then Antwerp, and came back in 1945 and started our company. My father joined, and it became A.R. Savage and Son. I came in 1980 and Billy started 4 years ago. In looking at this slide here a little bit, we found the upper right image of Port Manatee being dredged by Tampa Dredging Company, Hendry and Company. That we think that image is about 1968. So you can see it taking shape. And I also put there the lower image, which is Piney Point, the ferry boat landing, which of course was the way that people crossed the bay before the Skyway Bridge. We subsequently bought Piney Point and sold it to the port in the 90s so you could get your seagrass credits to do the dredging that we see today. So that's a little bit about that. And to talk about what agents do, we are the guys that are involved with all the fixtures of the ships. From the beginning of someone looking to move a cargo to the end of that. And what does that mean? So I'm going to shift to the, I'm going to shift to the next slide. Now I tried to do this and it can be a little tedious, so I'll try and keep it easy. But we are involved, as you can see on that lower band, on a shipment for anywhere from 4 to 6 months. So if we take somebody like Ash Grove Cement, who's got a fly ash ship coming in a week or so, they'll go out to the market to buy ash, and then they will have to charter a ship. They'll have to pick up the cargo. They'll have to bring it here to discharge. When they get done, then we've got to close everything. We've got to bill everybody, collect the money, and then pay the Port Authority. And so that's that chain in the voyage of a ship. So we will work with primarily your operations department in looking at berth availability, making berth reservations, giving estimated port costs to the different brokers, ship owners and such, so they can figure out which is the best ship to charter or fix, and then go pick up the cargo and bring it here. And once that ship is ready to come in, the ship agent is the one that makes all the logistics and compliance arrangements. So let's talk about those a minute. So the Port Authority has their work rules, security rules. Dave is making sure that everybody that comes in this port is not a bad guy through their TWIC cards, through their different permissions and such. And then operations is making sure we're docking at a berth that's available, working with the stevedores. Then, and then of course we've got all the layered security out to U.S. Coast Guard, to Customs and such. And then once we get all those permissions and arrange all of that, then we're the guys that hire the tugboats, the pilots, the line handlers, work with the stevedores for the discharge, and then bring that ship in, get it discharged. On these cement or supplementary cementatious products like fly ash or slag or gypsum or bauxite or such, they can take 7 to 14 days to discharge, especially this time of year when you got rain, because we got to stop operations. Those are cargoes that can't get wet. Once we're done, we get that ship out of there, and then we start collecting all the bills. And those bills now, I'd say that the average port disbursement account for Port Manatee is about $80,000 to $100,000. So that's going to pay the pilots, the tugs, your dockage, your line handlers, and if we've got crew changes, medical, taxis, all that kind of stuff. So I'll move on and take that to, well, what does that really mean to you all? And before I get there, I just want to point out, these are some of our customers, and they all have different impacts. So starting with like Martin Marietta, we bring in a lot of their granite rock that is the large rock that you would see on a railroad track. It's the small rock that you'll see ground into asphalt to be laid on your roads, as that image suggests. Transmontane Partners, large public tank company. They have different suppliers bringing in fuel for different receivers. Racetrack is one of your big receivers here. World Fuels, who receives fuel to bunker ships, is here. We represent Marathon Petroleum, who is a supplier of those. Del Monte, Denise is over there, bringing in 400,000 tons a year of fresh produce to people, mainly bananas, a lot of melons, and other products, fresh from Central America. Ash Grove, I mentioned early, CRH, huge Irish cement company, and a lot of people look at cement and things like that and say, well, okay, it's cement. Well, Florida's consuming about 22 million tons of cement a year. We produce about 10. Where's that other 12 million come from? It's all imported through Manatee, through Tampa, through Port Everglades. No more in Canaveral, a little bit in Jacksonville. So between Manatee, Tampa, and Everglades, we're picking up 12 million tons of that, as well as the other input products that go into concrete, which is, we're consuming huge amounts of right now. And here's the area that I wanted to get to that, what does it mean to you? I'm going to try and do this. I think the bottom line is what you really need to look at. This port's gone from 2 million tons 10 years ago to 7 million tons. That is fantastic. That is growth that we haven't seen anywhere. I'm a Tampa boy, and our high in tonnage in Tampa was 52 million tons. We were the 7th largest port in the United States in terms of tons. We do 32 million today. That's the loss of phosphate chemicals. That's the loss of all of our power plants going from ship-delivered coal and oil to pipeline-delivered LNG that comes through Port Manatee under the ground. So, we've had a dramatic loss in tonnage that we're doing other things to diversify and build up. But at the same time, Manatee's tripled its tonnage, and that's fantastic. Good tribute to Carlos and his staff. They've done a lot of things to help the different private companies that are here to grow and to be able to solicit those customers. The supply chain will always find the most efficient and lowest cost to deliver a product. It's very sophisticated. It's one of the oldest businesses in the world, and they're going to find a way to deliver it as cheaply and efficiently as possible. So that's a tribute to Manatee helping everybody around here be efficient. Now let's look at dollars a minute. So those are products, and again, I'm going to go back, what I was saying about Tampa and some of the tons. I mean, you can see how fertilizer's gone down, but at the same time, the phosphate rock has gone up dramatically because we have less phosphate rock in Florida and we have lower quality phosphate rock. So it's now changed. Instead of being exported, it's now being imported from Peru, where Mosaic has phosphate mines. Look at, and this is Manatee County, a big agricultural county. Look at how we've been hurt so bad with our citrus. Whatever, freezes, bugs, mites, different things have hurt it, or developers that a lot of the groves are happy to sell to because it's a lot, better price to be able to sell your groves than grow oranges. Well, look at the increase in orange juice coming from Brazil now. Tropicana can't produce enough orange juice with Florida-grown oranges, so they're importing it. Those tankers used to be far and few between. Now you're doing 2 a month, I think. Yeah, and Tampa's actually bringing them in too. So, these markets are always changing, and the port's done a great job at working with private industry to help that change. Now, this is your list of top 10 customers, and as you'll see, number 1 up there is Norton Lilly, another agent. The reason that is they represent G2 Ocean, who has really high value, the wood products and such. So they are collecting $3.6 million in dockage, lines, and things like that are coming, and the Port Authority bills them. They collect it from the ship line, the charter, whoever the responsible party is, and then they pay it back to the Port Authority. We're number 2 in there at $3.1 million. And in that same 10-year span, we found that that has actually increased 7-fold. We're fortunate to represent the Del Montes, the Martin Mariettas, the Ash Groves of this world, and some of the salt producers and such. So we're doing the same thing. We're getting those bills. You know, Dave sends us a bill every time somebody shows up without a TWIC card and they've got to be escorted to the berth. You know, we're collecting all those and we're billing them out to the customers wherever they may be. We're collecting that money and we're paying it to the Port Authority. So there's a list of those, and those top 10 make up 73% of your revenue that supports the port, that has grown dramatically. So that's a little bit about what the agents do. One time Carlos described us as the concierge of the sea. I was a little bit offended by that at first, but actually it's a very good description because you know, you've got 20, 25 crew members on that ship. If they're going to some, you know, unholy destination on West Africa, and the whole crew has to get cholera shots, malaria shots, all these different things, we're the ones that have to arrange the doctors, the transportation, the repatriation when they leave, the joiners when they're coming in. We have to arrange the customs, the taxis, all those things. We work very closely with the Seamen's Ministry here. You know, these crew members may have been at sea for 30 days. They're away from their families. They don't have a phone. The ministry will take them in and give them the opportunity to call home, see how their family's doing. So we're here to help with the ship, the cargo, and the crew, whatever it may be. So that's a little brief on what the agents do and how we work with your port. And I'm here to answer any questions you may have.
Mr. Savage, thank you so much for your presentation. I mean, I kind of knew what you guys did. I didn't know you were concierge of the seas, though. But that is a great saying, though, for that. But thank you for what you do. Thank you for being a partner of the port. We appreciate it. And I believe Commissioner Feltz has a question. You're already on.
You know how I'm on.
You're
Okay.
already
I
on.
really appreciate that. As most people know, I'm a 8th generation Floridian. My family was extremely involved in the port industry.
That's great.
Lighthouse keepers, wreckers.
That's I recognize your name.
And it's I didn't realize how much I was innately knowledgeable of the things that you do, and I'm sure you're aware. I'm from Miami, where we created a great industry down there, between our, not just our industrial imports and exports, but our passenger lines too. And I really appreciate the presentation. Good to know what you do and how we operate here on the port in my district. Thank you.
Thank you.
I think Commissioner Feltz was on the boat when your great-grandfather sailed into Tampa Bay, but that's all right.
And ship them cows out of Manatee County.
Yeah. I mean, there's so many.
I wasn't there, George. I said my ancestors.
Does anybody else have any other questions of Mr. Savage or anything like that? See, no, thank you, sir. We appreciate you. Thank you for all you do for us.
Thank you for what you do for us.
Aren't you guys about the same age? I'm backing you up on it.
Very well. I think it's always interesting to hear, from the critical companies that run the Tampa Bay area, that run the port, that make it happen. Without the agents, as you just heard, it wouldn't be occurring. It's critical, critical, critical. And so as a result, we wanted to give you a little bit of an introduction, a sampler of what agents do. We'll bring other companies that are critical to the port, such as Del Monte in the future, and others who make all that happen. But to change this, I think one of the cooperative initiatives that we have is with USF's Shellfish.
Your mic's dead. I'm going to increase the budget to cover our new audio and visual.
That operation you're running around here, Mike.
I know. What kind of show we got going on here? Get bullhorns.
Use this for now? Okay, good. Okay. Thank you. All right. So Dr. Hestenberg, from the Gulf Shellfish Institute, who have a facility here on the port, critical, I think, function to provide us with the environmental, the opportunities in developing new industries, and in also mitigating the environmental impacts that the port could have on the bay. So as a result, right here, before you today.
Good morning.
Morning.
Thank you, commissioners, for the opportunity to speak. I just want to say thank you to Malcolm and to Dan for facilitating my presentation today. Really excited to be able to talk to you about a nonprofit organization that is small, but I think pretty mighty here in Southwest Florida. Again, Dr. Stephen Hesterberg, I'm the executive director of the nonprofit, Gulf Shellfish Institute. I completed my PhD in 2022 from the University of South Florida, just up the road. And really my focus area is marine ecology. So studying coastal ecosystems of Southwest Florida. And I never thought I'd be venturing into aquaculture, but actually the more that I've experienced this wonderful industry, it's amazing to me how linked shellfish aquaculture is with environmental stewardship. So I'll be talking a little bit today about that. All right, so a little bit about the Gulf Shellfish Institute. So we're a 501c3 nonprofit organization, and really we're a scientific research organization. So the bottom point there, we're kind of unique in a nonprofit is the majority of our funding actually comes from competitive awards or appropriations. So we don't do as much fundraising because we are looking for state, federal, and local funding to support applied research to better the industry. We were founded in 2015, and the port has been really an integral component of our growth since we have formed. We've been at the port premises since 2016. So the port has been our home, and we're very fortunate for that. And our mission is to expand shellfish aquaculture here in Southwest Florida. So there's two components of that. One is to increase the production of shellfish to benefit the direct monetary, expansion of the industry. But also, as I'll talk about a little bit further on, our vision is that this industry can support a lot of the environmental goals that we have here in Southwest Florida, mainly water quality improvement. So it's kind of twofold, help the industry and economically, but also environmentally. And we do that through applied research and restoration. So who are we? A large success of the Gulf Shellfish Institute first starts from its amazing board. So I just want to highlight, we have 10 board of directors. And they represent a very diverse set of expertise, ranging from, of course, we have our shellfish industry members on our board, folks who are well-versed in our business community, philanthropy, and our scientists. And so I just want to point out a few people. There's one up there that you probably recognize. We're very lucky to have Dan as our treasurer. But I want to point out Kurt Hemmel. He's our president. Kurt is the owner of Bay Shellfish Company, the largest shellfish hatchery in the southeastern United States, right here in Manatee County. And our two farmers that we have on our board, Joe Cannon and Heath Davis, They are active shellfish farmers up in Cedar Key, the main location for most of shellfish production here in the state. Joe's a Army veteran, and Heath was actually the former mayor of Cedar Key itself. And I'll also touch on Ed. Ed, of course, I'm sure you're all familiar. He's been a fantastic leader and visionary for our organization. And our two scientists on our board, Josh Patterson, right up the road here in the Ruskin facility, and Dr. Bill Arnold, who was the head of FWC's Shellfish division for the majority of his career. He's now retired. So who we are for our staff, we've got six full-time staff and one part-time staff member, and so we're really all scientists. We have Dr. Mallory C., a research scientist. She is kind of the VP to me, and we've got two wonderful staff scientists, Sarah Hutchins and Sarah Cole. We have three Sarahs. So we're often think of ourselves as the Gulf Sarah Institute. That's a joke that we have around the office. And then I just want to point out Olivia Blondheim. She is a current PhD student at the College of Marine Science at USF. She's part-time staff, but she, education and outreach is definitely a component. We want to make sure that we're training our next generation of scientists, and also trying to keep them that expertise here locally. So for our applied research, I'll talk about a small research component and then our restoration that we do. But for our research focus, these are kind of the driving research goals that we think that answering these questions will help benefit the shellfish aquaculture industry and the production. So the picture that you see here is an experiment that we did at Bay Shellfish Company. And what we're doing here is we're actually selectively breeding heat-tolerant shellfish. So we have a selective breeding program, and the idea here is, can we improve the industry even by increasing survivorship on commercial leases by, say 5%? That would be a huge monetary gain to our farmers. So I'll show you some data from that in a second. And then also we want to quantify the ecological services of shellfish on leases and also in the environment. So a big component of that is filtration rates of bivalves. So bivalves are filter feeding organisms, and that's really the main ecological value that they have, because they're consuming the phytoplankton in our waters that have contributing to a lot of the poor water quality that we have along the West Coast. Right, so we're trying to understand the science behind that, give numbers so that we can then say, hey, here's how much restoration would benefit our area if we, say build an oyster reef or put clams out, or a commercial lease. How much water does a commercial lease filter per year or something like that? The third point, seagrass and hard clam facilitation. This is, I'll get to our restoration project that we have. But really, we think that seagrass, which I'm sure you're all familiar with, and how important that habitat is to our fisheries and our water quality here in Southwest Florida, that hard clams, the main shellfish species here in Florida for aquaculture production, go hand in hand in the environment. And so we're looking at ways to use the two together to benefit one another. And of course, we're always looking for new species to develop for the commercial industry. I'm not going to go through the numbers, but this is an example of what, for instance, those tanks end up looking like when we go to produce our final product. So this is data showing basically the temperature and salinity tolerance of different shellfish species, right? And to us, we may not want to dive into that today, right? But to the farmers, right, this stuff really matters. Knowing a certain temperature and a certain salinity, when that happens, right, the expected mortality that they might have. So that's kind of a small project that we would do. So I want to talk about our major initiative that we have going on, which is All Claims on Deck, and that Manatee County is a partner on, and we thank you. So All Claims on Deck is an initiative of our nonprofit. It was really started by Ed and his vision back in 2021, following the Piney Point disaster. And Ed was, obviously grew up on Anna Maria his whole life, right? Restaurateur there. How can we link this wonderful industry that we have in Southwest Florida and along the west coast of Florida, shellfish aquaculture? Can that be part of the solution to our environmental problems that we have? And so his vision was to use shellfish aquaculture and improve water quality through that filtration, and recover lost seagrass. And also doing so, the economic component of if we grow the shellfish aquaculture industry through restoration, that means jobs. And so our vision for shellfish aquaculture is that merger of the two, and we call this restoration aquaculture. So the use of aquaculture to enhance or recover aquatic populations and ecosystems because of their function. I mentioned Dr. Josh Patterson at UF. He's kind of a pioneer in this concept. But examples of restoration aquaculture elsewhere would be up at the Florida Aquarium. They've successfully been able to spawn critically endangered elkhorn coral, and also bay scallops, and also some sea urchins that are important for coral reef health. All right, so producing these organisms in essentially the lab using aquaculture, and then putting them out into nature. So for All Claims on Deck, I'm going to focus on the co-planting aspect, just for brevity. But we think that there's this positive interaction between bivalve shellfish and seagrass. So shellfish filter our water. They then essentially deposit nutrients to the benthos, clear the water, which is important for seagrass photosynthesis, and then also fertilize that seagrass. All right. In turn, seagrass benefits shellfish by providing them protection from predators, and also there's some evidence to suggest that there's some food delivery to the shellfish themselves. So what we're going to do is we have a major $5 million project where we're going to be planting several acres of shellfish and hard clams together along Southwest Florida, from Tampa Bay all the way down to Estero Bay. The middle picture here is an example of what that areas would look like permitting-wise. You can see the red there. That is actually all seagrass that used to exist in 2016. All right, and this is right here in Manatee County in Sarasota Bay. So that's how much seagrass we have lost, to give you a perspective. So what we're going to be doing is within these areas creating plots and an actual test, experimental test of this novel restoration technique. So we're going to be planting plots with seagrass and plots with seagrass and hard clams. All right, and so we're going to monitor this over several years and evaluate the efficacy of improving seagrass restoration using aquaculture. And I'm not sure if this video will play. This is just an overall kind of All Clams on Deck, what the fun part is. So that was an eagle right there, if you caught that jump. It's pretty cool. And so this is us actually doing a hard clam release out at a pilot project out at Longbar Point, so in Manatee County. So we're putting out hard clams with plots of varying levels of seagrass. Okay. And this is an area that experienced that large die-off. So we're testing whether hard clam can help facilitate the recovery of seagrass naturally. So we free release the hard clams into plots, and they naturally will bury themselves, so we don't really even have to do anything. That's a bay scallop. That's our released hard clams. If anyone's a diver or snorkeler, this is very good visibility. It doesn't normally look like this underwater. You can barely see generally when we're working. And the boat that we're using there is actually a local shellfish farm. So a big part of our initiative is including the shellfish aquaculture industry as part of the solution. That includes using, local watermen and paying them to assist in our work because they know the waters best. So with that, thank you.
Doctor, thank you. Oh, thank you very much. I mean, I didn't even know half this was going on. So we appreciate your presentation today. You do work with the county on their bivalve program and all that stuff too. So you guys are working with our natural resources and we'll put another hat on for a second. With the county's natural resources, Charlie H. and that group over there.
Absolutely, yes.
Oh,
They've been incredible partners.
Well, thank you. Is there any questions of Dr. Hertzberger? Okay. Thank you, sir.
Thank you.
Thank you very much. That was really cool.
Thank you very much.
All right, continue on with the rest of the agenda this morning. We're going to move on to the consent agenda. Is there any items that any commissioner would like to pull from the consent agenda? Seeing none, I'll look for a motion to approve consent. Got a motion by Commissioner Beard and second by Commissioner Cruz. All those in favor say aye. Aye. Thank you very much. The motion carries 5-0 with Commissioner McCann and Commissioner Sadiq absent. Mr.
Thank
Director,
you, Mr.
you're
Chairman.
back up.
Thank you, Mr. Chairman, Commissioners, for that. Number 9 is really the third amendment to my employment agreement for an extension of it for an additional 2 years, subject to your concurrence and consideration. I have Jennifer Cowan, who drafted the extension agreement. It's in your packet, and also we have some remarks in terms of the revenue and expenses over the last few years, which look very, very good. But to do this, I'm going to have Jennifer present the contract extension.
Okay. Commissioner Cruz has a question real quick.
Oh, it's okay. If you're going to present.
Okay. If you want to go now or later. Whenever you're ready.
Yeah, no, you can present that.
There's not much to present with this. It's a very simple amendment. It's merely extending it 2 years. There are no other changes to the terms and conditions of the contract.
Yeah, now it works. Yeah, that's all I was saying. I don't have my agenda in front of me. I was just, for the public, I was just confirming with you that this is literally just a 24-month extension. The contract runs out December 31st of this year. We don't want to get into a position of having any disruption, so we're pre-extending it by 2 years. There's no adjustment to salary or benefits or any of this. Is literally just saying Carlos is here for at least 2 more years, hopefully longer than that, but that's the extent of what this is.
Correct.
Okay, I was just confirming that.
Yes.
Thank you. Are there any other questions of Board Attorney or the Chair? All right, or the Director? All right, we're going to need a motion on this. I'm looking for a motion
to approve.
Second.
The motion to approve the third amendment of the employment agreement for Director Vaqueras has been moved by Commissioner Cruz, seconded by Commissioner Ballard. All those in favor say aye. Well, sorry, I got to open this up for public comment. Seeing none, I'll close public comment. I didn't realize, most of it's all staff, so is anybody going to talk against it? Okay. There's a box ready on their desk. So again, we've had a motion by Commissioner Cruz, second by Commissioner Ballard to approve the third amendment of the employment agreement for Director Vaqueras. All those in favor say aye.
Aye.
Any opposed? None opposed. The chair votes aye. The motion carries 5-0 with Commissioner McCann and Commissioner Sadiq absent. Mr. Director, congratulations. You're around for a couple more years.
Thank you, Commissioners. I appreciate the confidence you have put on me. I think we continue to expand the port and way beyond my contract with future port directors that you would choose. I think the port is on good footing. We're going to capitalize on that. As you heard Mr. Savage mention, it's grown dramatically over the last few years without taking any business from any other port, really capitalizing on what we have in the assets, and with the Port Authority support and the almost unlimited land surrounding us, we're going to continue to do that and to create additional jobs. And that's what it's about, opportunities and jobs that are not taxpayer supported, they're not ad valorem supported. And the more people we bring here, the more people who buy homes here, the more people who work here and live here, and that's really what we want to do.
Thank you, sir. I have a couple comments. Real quick. One, if you, I know the director handed out basically a breakdown of highlights and accomplishments of the port. If you look, I'd just like to, if you haven't seen it, reference page 3 on the graph that's been prepared to look at the revenue and expenses. We're very fortunate to have our revenues going up and our expenses going down here at Seaport Manatee. So I congratulate you and your team on being able to do that. My second comment is that we're in the world of tariffs today, and tariffs are hiding under everybody's bed right now, and instead of a monster. And what I'd like to have you do is, if you could explain for the Port Authority, some members might know, some members might not know, the public might not understand how we can, the tariffs come in, but we have the opportunity here at Seaport Manatee, we have a foreign free trade zone. Correct. And how that helps us impact the tariffs with being able to bring for our clients and potential clients to be able to come in and use that trade zone, and how that trade zone impacts what we do. If you could just comment on that, I appreciate it.
Thank you, Mr. Chairman, Commissioners. Yes, the port is the grantee to FTZ number 169. And as such, we have all the benefits and rights to activate foreign trade zones for the purposes or any reason of a customer. And recently, because of the tariffs and all the attention given to tariffs, the level of interest in the FTZ has increased dramatically. This is really an economic development tool, and it's really almost a foreign direct investment tool, because now companies, and we have quite a few being discussed with our international trade hub and Mr. Carlo Barbieri and Joao de San Nogueira, that have demonstrated from overseas to want to build a facility and put an FTZ around it, or lease a current facility and put an FTZ around it. We can do that within 60 miles of our port. Okay. Now, Port of Tampa also has one, but of course, you know, that's really essentially the duty of an FTZ. What is an FTZ? It allows a manufacturer or an exporter or importer to bring in the product from overseas and not pay duty right away, or change the product or re-export the product in a way that minimizes or eliminates duties legally. The FTZ really was created by the U.S. government for the purposes of generating additional jobs. So rather than have those jobs, you know, go somewhere else, the FTZ brings in additional employment. And so right now today, when cargo is shipped from overseas, the minute the cargo hits the dock, the duty is owed to the U.S. government. And that could be 20, 30, 40%. With an FTZ, the product is moved into the foreign trade zone, which is technically outside of U.S. territory, and as such can defer the payment of that duty until they either re-export it, they pay no duty, they ship it, let's say, to Mexico, or they bring it into the U.S., which then is applicable to the duty. So they save the duty for that time using the cash flow to be able to bring in additional cargoes. So they pay as they go. If they bring in, for example, we bring in $500 million a year of aluminum. That is dutiable. Guess what? We have an FTZ around the aluminum. So as they draw it out, they pay the duty, but they don't have to pay right away. However, FTZ requires additional employment, additional people that then have to operate the FTZ. We're doing also with pulp, paper pulp from Brazil, aluminum from Argentina. It's a tremendous tool, and we have a lot of both public and private companies, and two, as mentioned to you before, two executives here, presidents of their company, already marketing this overseas. So we're marketing it not locally, overseas, for these companies to come, to start a business, and they get the benefit of an FTZ.
Mr. Director, does the FTZ also impact if someone outside of, we're in a 60-mile radius, so anybody within that 60-mile radius can benefit from the FTZ, even if they're buying a piece of property next door to the port, they can, and if it's domestic, if it's coming domestic, not coming, we love everything coming through the bridge. I don't want anything coming on the road. I want everything coming through the bridge. So if they're a domestic carrier or whatever, domestic product, can they still use our FTZ?
Yes.
Okay.
Yes, they can, because the FTZ is really for the benefit of cargo that's dutiable, but it can also, under the FTZ rules, accommodate domestic cargo. It's just you keep a separate account of what's domestic and what's international. And in fact, most FTZs have both domestic and international cargo, because when you make a shipment, exports or imports, you don't do it just with international. Often domestic is mixed in for the purposes of the purchasing of the customer that is buying the commodity.
Okay, great. Commissioner Ballard.
So how does a business take advantage of the FTZ? Do they have to, is there a process that they have to go through with the port in order to do that?
Yes, there is a process. So we can get an FTZ up and running in record time. So what happens if let's say an importer of, let's say, aluminum products for manufacturing of aluminum, let's say screens, aluminum porches, aluminum, brings it in, they request an FTZ, and we're going to be promoting this throughout Manatee County too. They request FTZ. We then, working with Customs and Border Protection and working with Treasury, put an FTZ around their facility, as we have done before, even in Sarasota County, around the facility, and they're up and running. It's a matter of about maybe a 2-month process, because it requires the approval of CBP. So as a federal entity that controls exports and imports and customs, they are involved in determining how that FTZ will operate. We grant it because we're the grantee. The company operates it, and CBP conducts the, let's say, the auditing and inspections that the FTZ is within the boundaries of the, let's say, Foreign Trade Zone Code.
Wonderful. Thank you.
Another quick question that brings back to, can we charge for using our FTZ?
We do.
If we have an you just mentioned Sarasota.
Yeah.
If a manufacturer down there is going to get within our FTZ, can we charge? And can we charge Sarasota County for their economic development for our FTZ?
We charge for that benefit. We should. Right now, we only charge the customer a very modest fee, sometimes $7,000. Until let's say once a year or so, if that. So for us, the big benefit is really to be able to create that opportunity because of the economic impact the FTZ has on the counties.
Okay. Well, I'm not picking on Sarasota, but it just brought me to a point of where if, this is a great economic development tool. There's no doubt about it. But if another county wants to use it because it's a 60-mile radius,
right?
It could be Hardy, DeSoto, whoever. And so they want to use it for economic development in their county. Would we get any benefit from them using our FTZ to bring economic development to their county? So it's not coming here for whatever reason, and they'd be crazy not to come here. But I mean, to Manatee County. But if it was going to Hardy County for some reason, is there any way for us, as the controller, as the owner of the FTZ, to get some type of income coming back to the port on that?
We do. And it's modest because we charge an activation fee from $14,000 down to $7,000, which is not that much because, again, it's really meant to incentivize economic opportunity as opposed to being a money generator. Because, of course, we cannot charge by law certain additional fees, like I would love to Sarasota County or to Henry County, or to be able to collect more, because they do have now the right with the Manatee FTZ 169 to really attract additional businesses that might not otherwise go to that county.
So would you say that for an activation fee for a business to activate within the FTC, if they're in Manatee County and they're going to be in port area, that we would be considered being more generous to them than they would be if they were Hardy County?
And we have been.
Okay.
We have been.
I just,
Yeah.
I just
We
want,
might
I want everybody
charge.
here at the port. I want everybody doing business with the port.
Yes. And we have done at the port, we've lowered the fees to attract companies, to activate their FTZ
Okay.
here at the port.
All right. Thank you. Thank you for that. Thank you for the explanation. Sorry. Real briefly, I know it's going to take more than 30 seconds, but can you discuss the foreign direct investment, what's coming into the port, and where you see it coming in, and in the world of tariffs and the world of the economy, what's going on? Can you just give a brief description of what's going on with our foreign direct investment here at the port, and where you see that going in the future?
So thank you. That's a good question because it's really something that the port does as a matter of routine. When we look to bring in a new shipping line or a new product, we also look at that FDI. And as an example, one of our current tenants, Agunsa, brought in under their lease essentially a $20 million capital investment of a Turkish company to build an additional facility to manufacture cement. So as a result of that, the capital investments for some of these entities is huge, directly or indirectly. They could have dealt with us. They wanted to deal with, with this company, and it's the same to us because the economic impact happens here in Manatee County.
So you see it as going forward, you don't see world economics or anything like that? I mean, right now, foreign direct investment across the United States is up.
Yes.
As we know, our trade deficit is the opposite direction. But do you see our opportunity to get more foreign direct investment here at Seaport Manatee?
Yes, in fact, yes. And I'll tell you, we'll explain why. We created the International Trade Hub. So the International Trade Hub, again, with several private companies, we don't pay those companies to do that, but they're attracting foreign direct investment through their contacts. So we have a multiplier effect by attracting these individuals, these companies, such as, the Oxford Group. We have Carlo Barbieri here. He left, I think. Okay, he has another meeting because he has a board of directors meeting of the Southwest Brazilian Chamber of Commerce that was started here just a few weeks ago. So what do? They have multiple, contacts, and they're bringing in Brazilian companies. They're bringing in Portuguese companies like Joao there to do FDI here. So we have the multiplier, and the International Trade Hub is directly responsible, or the lead, while the port supports that, the lead into focusing on FDI. And it's working very, very well. We have a roster of companies really ready to come, and the tariffs have further accelerated the interest of these companies to come in and do it now as opposed to later.
Well, I will tell you that whatever that Colombian or Brazilian coffee I had last time I was here, I'm still buzzing from it. That's been like 4 months ago. But thank you for that explanation, because foreign direct investment is very important to the port, and we want to make sure that we have the opportunity to continue to do that with our partners and our trade partners. And the hub is just a great magnet for that, to bring in all those different foreign entities. So we appreciate that. Does anybody else have any questions for the Director McCarris?
Okay.
Seeing none. Do you have any
Just
closing comments?
just a few brief comments.
Yes, sir.
That we have here. So again, as you heard from Arthur Savage and company there, things are looking up, really expanding the port, growing it. We continue to grow the port. I won't belabor, give you more details, but again, it's really, we're in an upward trend and have been for a few years. Of course, we're going into hurricane season. Okay, we're getting ready for that. And still going through, of course, some of the expensive repairs that we are handling without a significant impact to operating revenues. We had a very interesting, a sail ship full of orange juice. It's sails and, of course, power, engine power. But for the first time, one of these, 1.6 million gallons of orange juice with this unique vessel you see here. And I think next time they're in port, they're coming in from Brazil. LDC means Louis Dreyfus and Company, one of the major commodity traders in the world, docked here, already left. And I think next time be interesting if we could bring you back and have you tour that ship.
Cool. Yeah.
It is so unique, right?
Really cool.
And it demonstrates
the interest of these companies to be environmentally responsible by going into these technologies of sales on a cargo ship, almost going back, 500 years, right back to the future, so to speak, with these major sails that they deploy for the purposes of, propulsion to foreign countries.
Well, I mean, that's pretty cool because we know that the IMO is trying to put a carbon tax on all of our shipping. So that's pretty cool that they have their, that's like going back to sail days. That's pretty cool. It helps cut that carbon emission.
Very, very unique. Of course, we have a new engineer here. And so Johns has joined us from one of the private Moffat and Nichols, port advisors. You want to say a few words, John? Or you're...
You sing your college
yeah,
fight
being a consultant before, I think he's no lack. He doesn't lack. I want to say, introduce yourself a little bit, and
we do ask that you sing your college fight song.
No, thank you. Commissioners, it's a pleasure to join the group here. Really excited. I've worked in the industry now for about 13 years, as it says. I've been port logistics side, but marine structural. So really excited to help grow and head business in the right direction.
Well, thank you. Welcome. Thank you for being here. Thank you for being part of the team.
Thank you, John. Yep. Here we go. Of course, we also want to reach out to the future generations, and we do this constantly with schools and other institutions to really review with these schools and with these students future opportunities at the port, or in the industry as a whole.
And also let you know that Carlos does have a road show, so if anybody wants to send him on the road to an organization or whatever, Carlos and I did the Manatee Patriots, which was, they still talk about the pineapples, but we did the Manatee Patriots, which was, some of them didn't even understand what the port did. And it's just, getting out and getting that outreach out there about what the port is, who the port is, and what we do out here. People are amazed at what happens at the port. So we have a great road show. So if any of the commissioners are interested in putting something on somewhere or wherever we can go out in the public, we're interested.
And we'll bring the pineapples.
Yeah.
So I love the idea of going out to the schools. Do you have a lot of other school opportunities planned, particularly for, SCF, MTC, and our high schools?
Yes, we do. We have a speakers program, an outreach program. We have not turned down one invitation.
Wonderful.
And we even, of course, want to, in fact, I just spoke with our director of communications, Virginia Zimmerman, about doing more outreach just a few weeks ago, doing more, let them know we're here. And that outreach, I think, is very important.
Yeah, Carlos and I are pretty good Abbott and Costello, if you remember those days. So we put on a pretty good show. So, yes, ma'am.
As your commissioner for District 1, I don't think that we quite have the awareness in the entire district, because it is a very large district, of exactly what a gem we have with our port. It's always a joy to come to meetings here because don't have to face half the problems that we face with our regular commission meetings. But I would like to encourage you, not just with our schools, but with our general population, that people are really not aware of what our port does. And that's one of our major facets in District 1. And so I'd like for you also to get out to the adult community as much as the kids and educate the public, because we have a very new and growing population in my district that probably isn't aware of the value of our port that is part of our district. So thank you.
No, that's very true. And in fact, again, the outreach is not just for schools. It's really because we do want to educate. We want to bring the good news story about the port to everyone, because it's so important to Manatee County as a whole. And we'll never pass up an opportunity and encourage groups to either come in, or we'll go out to the group if it's inconvenient for them to come to the port, and then invite them back to the port. Yeah. So we have that follow-up. And it's critical, I think, as you pointed out, Commissioner, that we increase the awareness of the port's benefits and location and get them to see the port, because there's no better supporter of the port than those that come to see it and that they hear about it, and again, the pineapples become critical because they don't realize that. And thanks again to Denise Stock, by the way, who generously, if it weren't for the month, Denise Stock, thank you again, because we call on her and it leaves such a great impression, and it tells them about Del Monte, none of those other pineapples.
We tell them they're Del Monte pineapples too.
Exactly. So it really is a nice way to let them remember what they did, and when they take it home, then they tell the family, this came from the port, and the port gave us this, and thanks to Del Monte, we have a much better educated, let's say, residents and people living in Manatee County.
Commissioner Phelps, what I might ask you to do is, you have that the Parish Civic Association out there. I would invite, have their chairman or president reach out to Virginia and set up a, even when Carl says, let's go, we go. So that would be great to go out there and talk to them about who the port is, what the port does, and how cool the port is. So, right. Executive Director, is that it?
One last thing, I want to thank my staff again, the great team that we have here, had it over the years, because really, and this is no false praise, they make it happen. They make it happen. And moving out into the future, the idea is that, we prepare for a transition, okay? As we're not going to live forever, and leave a strong team here at the port and let them have, the opportunity to do more and do more leadership training, so they're ready to take over, based upon essentially the future, my future retirement. And that you all have an opportunity to both look inside and outside, but also leave you a very strong internal staff, internal
Yes, sir,
team.
thank you. You got a great team. You really
Carlos,
do.
you think you're going to retire?
When he started his job, he was like 6'5".
Yes.
And
Before
4,
I go
too.
to 2-3, I need to go. When I can reach the podium here, it's time to go.
Thank you, Mr. Director. You do a great job, and the port is just rocking and rolling. You can see by our financials, we have a great opportunity here. It's a gem here in Manatee County. This port is a port of significance. Carlos and I keep preaching this all over the place that, we are the closest port to Havana. We are the closest port to the Panama Canal. We are the right turn and when you go into the bridge, you don't need to make that left turn and go any further up. Come right here. The port, the staff here works tremendously hard to keep this port operational 24/7, 365. Even basically during a hurricane, they're still trying to keep the port operational. So you guys do a fantastic job. Commissioner comments. Commissioner Cruz.
I'm good. Thank you.
Commissioner Phelps. Commissioner Ballard.
I'm good.
Commissioner Bearden. Good. All right, thank you very much. With that, if there's no additional comments, we stand adjourned.
Okay.
Manatee County is a beautiful place located on the west coast of Florida at the south end of Tampa Bay. We're a community of 400,000, rapidly growing at 10 to 15,000 people a year. With that, our growing population has stressed our existing infrastructure, and we're working diligently to provide those expansions to the existing roadways to meet the needs of our new community. At the same time, we're trying to meet the same needs of maintenance of the existing county while growth happens. So we want everybody in the county to receive the same high level of services we provide, whether you're 2 years old or you're 80 years old.
We've got an amazing public works department that's working very diligently to provide what our citizens need, what our tourists need, what our future citizens need. So whether it be roads and bridges or it be improvements to our beaches and our recreational facilities, we're working very hard. We just opened up a new bridge on 44th Avenue. That was something that this community saw decades ago as a need, as a reliever for 2 other east-west thoroughfares. And once that crosses over Interstate 75, we're going to see the ability for a contiguous road going from the beaches where we're standing today all the way out to Lakewood Ranch and beyond, where the new growth center is in Manatee County. One of the things that we've lacked putting funding towards recently is our north-south thoroughfares. So Fort Hammer Road is our #1 priority both on the state level and federal level. Once complete, it's going to go all the way from Hillsborough County to the north of us, all the way down to Sarasota County to the south of us, and create a major reliever, not only for the local roads here in Manatee County, but for the interstate as a whole, if there's ever an accident. So that's a major priority of our public works team right now. The second thing is we're starting to see more sidewalk projects, more complete streets, roundabouts, things that traffic calming, to really make sure that Manatee County is providing efficient ways to get around, but providing safe ways to get around.
This is not sleepy old Manatee County from 20 years ago. There is an expectation that we provide a high level of service and people do it. We also do much more community outreach to try to have a true insight in a particular area on what the improvement is. Where can I do some extra sidewalk work? Where can I put some traffic calming amenities in? Where can I improve pedestrian safety? The vast majority of our employees live in Manatee County, and that is such a plus. They know the community. Sometimes they know the people that are requesting the work. We want people that take that pride into knowing that they are taking care of their own community.
And every groundbreaking I'm at, every ribbon cutting I'm at, Chad and his team are there. When we have our meetings, they're sitting in the audience. They're listening to our citizens. They're keeping in touch with what's needed in Manatee County and making sure it's adhered to the best of their abilities at all times.
Our summer is our big time to be prepared for emergency events, and that's to be prepared for a hurricane. Our last two fun events had been around Hurricane Irma in 2017, and most recently, just last year, a near miss for us with Hurricane Ian to the south in Fort Myers in 2022.
We work endless hours throughout the year, making sure we're prepared for a storm. Preparation through sandbags, the equipment. We had over 100,000 sandbags given out in a day and a half. If there's a blockage or a dirty pipe, all year round we're cleaning them, we're opening up the ditches, so when all that water comes, it's got a way to go out instead of flooding homes and roads. And after the storms, Public Works is one of the first ones to respond, to clear the roadways and to clean up. So I grew up in Manatee County, so seeing what we do every day, is awesome.
Endless opportunities are available here. We're looking for many new bright young faces to come join us and build a career as this community continues to grow.
I've lived here my whole life, so it would be 20 years now. When I learned about the internship in high school, I came and I started work here. My primary job is currently lift station rehabilitation projects. So going in, taking all the different parts of the lift station, taking the old parts out and replacing them with new parts. However, I also get to do fun projects like some 3D modeling and 3D design to be able to show to the public the projects that are going to be going in their local community. I've had great mentors and the management and everybody with just supporting me. And on top of that, the tuition reimbursement through Manatee County has been able to help me pay for my classes, go to college at the same time, and work and gain skills that I'd be able to use in the future.
Manatee County has a career ladder, so as you come in, you start off as a trainee, not knowing anything Public Works does. And the more you learn and achieve, you can move to a Tech 1, Tech 2, Tech 3, and then a Senior Tech, which opens up more opportunities for promotions.
Growing up here, almost 26 years, born and raised. I had wanted to work for the county for a while. I came in here not knowing anything about spraying or pesticide application and stuff like that. So I've learned the front end loader, which is really fun. I get to play in the dirt. I got to do the forklift, so that's pretty cool as well. The chemical trucks that we get to operate with the tank and the hose that we use, the backpacks. Sometimes we get to use the ATV to get to smaller areas that the truck won't fit. It's really fun being out there in the field, and I've learned a lot when I've come in here. So got my spray license and CDL, and I was glad to get in.
I chose Manatee County as my career. I was 19 years old, starting a family, so I needed something with great benefits, great hours, something I would enjoy for a long time coming. So Manatee County was the first option and last option. It worked out great.
we encourage anyone who works in Manatee County to really consider living here within Manatee County, because we are all collectively working to make this a great place to live, work, and play. And anyone working for Public Works or our county as a whole is going to help facilitate that.
It is a beyond exciting time. Manatee County will be the premier place where the Skyway lands on the south side of Tampa Bay.
Manatee Square Garden was founded in 2016 based on a survey conducted by the Department of Health that determined that there are 32 food desert communities in Manatee and Sarasota County. For those of you who don't know, food desert communities don't have access to nutritious food, and they don't have easy transportation to that. So part of the solution was the creation of my position and the creation of this model garden to serve this community, Washington Park. The county has been extremely generous in their delivery of the Community Gardens program. Not only do we work in this garden with UF and the Department of Health, we've also extended that same service to Elwood Park community through the construction of their garden. And then on the slab, or on the table, if you will, there are up to 4 more garden projects in the works. Community gardens are important to me because they provide educational opportunities and food access to the community. They improve food security, they improve community involvement, they improve community perception.
I like the outdoors, I like getting my hands dirty. I like growing, and it's a form of therapy. And if you look around, you see a variation of shrubs, flowers, vegetation, and it's just wonderful.
It's good for the heart, it's good for the mind, it's good for the body. You can't get a better situation.
How wetlands are protected in new developments. Development completed before the 1980s typically did not have adequate wetland protection or address stormwater concerns. Today, these protections come in the form of wet ponds and occasionally grassed areas. You might wonder why newer developments have stormwater ponds with control structures. That's because in 1985, the state of Florida placed regulations on stormwater requiring these protective measures. Stormwater ponds collect and manage stormwater runoff by providing water quality treatment and restricting the water flow before it enters our creeks, rivers, wetlands, and the Gulf of Mexico. In undeveloped areas, stormwater runoff is filtered via overland flow through vegetation and wetlands prior to flowing into our water bodies. A wetland buffer is an upland area adjacent to wetlands consisting of existing vegetation and/or planted native species, which is to remain undisturbed. When engineered stormwater treatment systems are integrated into development plans, they effectively filter and treat runoff closer to its source before it enters a wetland or stream. The stormwater system provides water quality treatment in addition to that provided by the wetland. The purpose of state-required wetland buffers in residential, commercial, or industrial projects is to provide a visual and physical separation between development and wetlands. Protected wetlands and wetland buffers are often identified by signs, which serve as a reminder for people to stay out of these areas, effectively reducing pollution and habitat disturbance. You can often find signs in our county parks that include information about the ecological significance of wetlands, their role in flood control, and the species they support. For more information on how you can help protect wetlands in your neighborhood, go to mymanatee.org/wetlands.
It's the dude. I'm happy and proud to say I've had her since September 20th of 2020. I adopted her out of the Palmetto Animal Shelter. It was a Saturday afternoon. Realized I needed a companion in my life. Emotional, yeah. So, some veterans have gone through some traumatic times, and how can you put a price on this? Right here. And so, dude was out on a walk by one of the volunteers. I waited on her for her to come back. Her tongue was dragging. I looked at her and I said, "That's the one." I have kind of a stressful job, and those days I come home, she's there at the door waiting on me. We have our routines. We go on golf cart rides. We go out in the backyard and go for walks, and she's just there for me. Of course, you can see the affection. If I stop, she wants more. But yeah, she's a perfect dog. If you know a vet or you are a vet, Pets for Patriots is a program that makes it easy for you to adopt any type of pet shelter, cat or dog. The program allows for waived fees for veterans, which includes the spaying and neutering, the chipping, and the pre-adoption counseling. Participants get a $200 pet gift card to get them food and supplies for that welcome home day. You know, participants also receive ongoing discounts for things like veterinarian care, food, pet insurance, treats, medications. On behalf of the dude, myself, I can't compliment the staff, Animal Services, Sarah Brown, Deputy Director of Community and Veteran Services, Jennifer Hum, our new Animal Services Manager, and all the volunteers and all the staff of Manatee County that every day put an effort out to get these animals adopted. You know, I cannot thank them enough from my heart and the dude, really thank them all. For more information, click on the Pets for Patriots logo at mymanatee.org/pets and tell them dude sent you.
Some cats, like Miss Whiskers here, prefer the comfort of indoor living, plenty of lap time, fresh food, and a spot next to her favorite window. Not all cats are like Miss Whiskers, though. As a matter of fact, some cats thrive in the great outdoors, preferring the role of a working cat. These cats, though they may seem like outsiders, play a vital role in our ecosystem. They're skilled hunters, helping to control pests like rodents and insects from invading your homes and gardens. Trap, neuter, return is the most humane and effective method for managing a feral cat population. It involves trapping cats, spaying and neutering them, and returning them to their colony. This not only prevents the birth of more kittens, but also improves the cat's health and reduces nuisance behaviors like spraying and fighting. By caring for colony cats and practicing TNR, we're not only helping cats, but also benefiting our community and environment. By dedicating just a few minutes of your day, you can contribute by supporting and caring for these cats while they perform invaluable pest control duties for the community. For some helpful do's and don'ts when caring for a cat colony, please visit mymanatee.org/cat.
Download the 311 app and get connected to Manatee County Services.
Know what your evacuation level is. If you don't know, try the 311 app.
Search for information like trash and recycling schedules, and find out who your commissioner is via the resident information tool. Report issues like potholes, uneven sidewalks, malfunctioning traffic lights, and down stop signs. You can even pay your utility bill and request a permit.
Manatee County 311, what department can I help you with?
Manatee 311 and the Manatee 311 app, connecting citizens to services.
This is not just a ribbon cutting. It is a kickoff to a family fun day at this magnificent new play place.
And it's an honor to stand before you today as we celebrate the grand opening of the newly renovated John H. Marble Park. This is more than just a place to exercise or cool off in the summer. It is the space where friendships are forged, where children take their first swim, where families gather for celebrations, and where our community finds strength and unity. Places like this serve as the heart of Manatee County, fostering a sense of belonging and shared purpose. They remind us that when we come together, we are stronger. And when we invest in our community spaces, we invest in each other.
All right, we are back from lunch, and just for the record, Commissioner Bearden is online, possibly for the remainder of the day, but he is online and is present and will be voting. Real quick, just because I dealt with this over lunch, this is not on the agenda, nor is it a voting thing, but I just want to clarify for staff. Tomorrow morning, we called a special meeting at 9 a.m. It's a 5-minute-ish meeting. We've been working on our $250 million of block grant funding, and we need to vote to submit that. It's a long process. If we do not vote tomorrow before recess, we can't vote until July 29th, and that's going to delay receipt and utilization of these funds for 6 weeks, which is we're already in a bad position in terms of getting it done. We need, by Florida statute, 4 physical people in this room to make quorum to vote on it tomorrow. I just want to confirm for staff who is and is not going to be here tomorrow to ensure that we're going to have head count.
I will be there.
I'll be here.
I'll be here.
I'll be here. Okay, good deal. I was told over lunch there was a question of whether or not we have quorum. I just wanted to confirm for staff and for the administrator that we are in fact going to have quorum. Thank you. That's all I needed. We can move on to item number 11, Ms. Knapp.
Item number 11, PDR 2424ZP, Seagrass Point. This is a rezone of approximately half an acre of a 2.5-acre site from residential duplex 4.5 and professional office small to planned development residential zoning district, approving a preliminary site plan for up to 18 multifamily units, generally located on the east side of 26th Street West, a half a mile north of Cortez and approximately third of a mile south of 30th Avenue West, and your staff presenter is CJ Mills.
All right. This is presentation upon request. Does anyone want a presentation on this item?
No.
Okay. But Commissioner Seek, you're on the board. Would you like to speak on this item?
I just had a quick question for the applicant. I think staff and I had a question about stormwater, the stormwater pond. That was it.
My name is Richard Claybrook. I'm a resident of Manatee County, and I was sworn in earlier. Yes, regarding the stormwater pond, you had a specific question. I'm here to represent the applicant.
Thank you, sir. So when staff and I were evaluating this, the only question I had was around the potential for a stormwater pond because this is a PSP. So we couldn't quite find a clear drain to the nearby stormwater pond that exists just east of this parcel. So I just wanted to clarify, there isn't a stormwater pond today on this parcel to the east, I think.
Existing?
Existing, yes.
No.
Okay.
The property is semi-rural residential. I wouldn't call it rural. I mean, it's in the middle of town, but there's 2 houses on the property now, and it just sheet flows to what would be the northeast of the property, and then on east to, I think that's Bayshore Lakes over there, so.
Yep, and your plan is to build one stormwater pond for runoff eventually?
That is correct.
Okay.
We have to provide a stormwater pond, of course, for our stormwater treatment, and then we have to attenuate for the improvements that we're putting on there. But the discharge point will be exactly the same, and the discharge rates will be at less than what discharges off the site today.
Understood. That's the indication we got as well. So that's all I have. Thank you. I generally like the project, so.
All right, good.
It's
Thank
good
you.
info.
Okay. And no one else is on the board, so I will open this, before I open this up for public comment, in case there is any. We're now back from lunch. There are some new faces out here. If anyone is intending to speak anytime for the remainder of the day and has not yet been sworn in, let's swear people in now.
Do you swear or affirm that the factual statements and representations you're about to make to the Board of County Commissioners are truthful and accurate? Thank you. When you step to the podium, please state your name, county of residence, and if you've been sworn.
All right, thank you. And has there been any ex parte communication on this one? No. All right. Okay, I will open this up to public comment. Is there any public comment on this item?
So the record for Glenn Gibolina. So am I to understand that this is 4.5?
Glenn, will you just say you've been sworn for the record? I saw you, but.
Yes, I've been sworn
Okay,
for the
thanks.
record, and I've been sworn at, so. So it's my understanding 4.5 units per acre, is that correct? You don't have to answer, I'm just doing the math. So 4.5 times 2.56 is 11 units, and they're asking for 18. So they're increasing the zoning And I was just wondering how we got to that number if they were 4.5 and they're doing times 2.53 is 11. So if you're going to increase it by almost 50%, then I'd like to know about it. Maybe I'm wrong. Maybe I'm doing the math wrong, but if I get some clarity on that, I'd appreciate it.
Any other public comment? Seeing none, I will close public comment. And there was no presentation on this, so I will not bring anybody else back up. And I will entertain a motion.
Mr. Chair, I'd like to make a motion to approve PDR-24-24 ZP Seagrass Point.
I got a motion by Commissioner Sadiq, seconded by Commissioner Ron. You can cast your votes now. Commissioner Bearden, you're going to have to vote verbally if you're on the phone.
Yay.
Commissioner Bearden's a yay. And that is approved 7-0. Moving on, well, let me just jump ahead real quick. Item number 13 is just a continuance. So let's just bang out item number 13. We don't need a it says presentation schedule, but it's just a continuance, right? So we don't need a presentation on this one, Sarah? All right. Ms. Knapp?
Correct. Item number 13, PDR 2403ZP, Erie Road Residential. This is a rezone of approximately 5 acres, generally located quarter mile east of 69th Street East and approximately quarter mile west of Harrison Ranch Boulevard on the south side of Erie Road, from general agricultural to planned development residential zoning district, and approving a preliminary site plan for up to 7 single-family detached units. And this is simply a request to continuance because this was advertised before the item appeared in front of the Planning Commission and was continued.
Yeah. All right. And just in case someone didn't catch that, this is being continued not because the applicant just wants to continue, but because it never got finished with the Planning Commission. We had already advertised it, so it had to be on the agenda. So we're continuing it so the Planning Commission can finish its review and its determination back to us for a future hearing. So I will open this up to public comment on the continuance. Seeing none, I will close public comment. And there was no, it's a continuance, but just, has there been any ex parte on this one?
No.
Okay. I will entertain motions for the continuance.
So moved.
Second.
Motion to continue by Commissioner Ron, seconded by Commissioner Sadiq. You can cast your votes now.
Yes.
And Commissioner Bearden is a yes. And that is approved for continuance by a vote of 7-0. We will now backtrack to presentation scheduled. Item number 12, Ms. Knapp.
Item number 12 is PDC 2422ZP Parish Storage Expansion. It's a rezone of approximately half an acre, part of a 3.5 acre site, generally located northeast of US 301 and Fort Hamer Road intersection, from Parish Village Commercial Overlay to Planned Development Commercial Parish Commercial Village Overlay Zoning District, approving a preliminary site plan to add an additional 18,000 square feet to an existing mini warehouse of 40,300 square feet and expanding the size to 58,300 square feet and retaining the existing restaurant, which is just over 2,000 square feet. And this is scheduled presentations. Your staff presenter is Alicia Henry.
All right. And has there been any ex parte communication on this one? No. All right. Mr. Gauss, you're up.
Thank you. Thank you, Mr. Chairman. Commissioners, can we go ahead and bring up the PowerPoint? Okay. While we're waiting, my name is Bob Gauss with Gauss & Associates. I have been sworn. I'm joined here today by the owner of the property, Mr. Todd Reed, Reed Properties, Heather Ancona, who is the general manager of the property. Shorter Pallet, Jason Coates from Shorter Pallet Engineering is here with me, as is Michael Yates from Palm Traffic. And, nope, I'll go up, item 12. They can't see where my finger's pointing, I know. I've also been told that they can't see my hands moving around when I'm talking to people on the phone, so try to be better about that too. We got it up yet? All right, I believe it did. I can see it. I can see it on here. All right, I've introduced the team to you. The property, as they've said, is located in Parish, basically at the intersection of US Highway 301 and the old Fort Hamer Road. And that's now Bella Road. The future land use is Res 6. The property is zoned PDC/Parish Commercial Village Overlay, and then the parcel that my client purchased more recently is zoned Village. The allowable floor area ratio is 1, the proposed floor area ratio is 4. And basically this request, and we've created this kind of graphic to help you see what we're doing. We're requesting that we rezone the 0.47 acre parcel from Village to PDC. We're also requesting a preliminary site plan, revised preliminary site plan be approved, and we're adding 8 parking spaces, and we're requesting specific approvals. The actual Paris storage facility was, and C&K restaurant was approved back in 2011. And it's an existing 40,300 square foot, 2-story mini storage facility. It's actually several buildings. There's a 2,016 square foot restaurant. There's currently 26 marked parking spaces. Most of the area behind the security gate for the storage is striped to allow customers to park wherever works best for them. Todd felt that worked better, and does seem to work better, because what happens is people just park in front of whatever unit that they're storing stuff in. This is the parcel that was purchased by Mr. Reed back in 2023, Zone Village. It is actually not located in the overlay district. And many warehouses allowable within the as a special permit, but that's a different process. It goes to a hearing officer instead of to you. There's other uses that are allowable on this property. There's some of them listed: veterinary hospital, repair service, medical labs, some others. The reason we're doing this process of the rezone and the revised PSP is because we're actually crossing the boundary between the two. There's a parcel, and the proposed 18,000 square foot building is actually on both sides of that property line, which requires us to revise the PSP anyway. So rather than go through 2 separate processes, we decided to work with staff to go through this. And like I said, the restaurant is the C&K Barbecue, one of my favorite places to get barbecue. Transportation, the access to the property is not changing. We access the property from US Highway 301. That's not changing. I know you've got some comments, public comments concerned about us accessing Bella Road. We're not. There's never been a proposal to access Bella Road. I can get that the yellow sign that we post is on Bella Road, because that's actually the address that was listed. So we put the sign at Bella Road, so people thought we were, but we're not. There is really no potential for traffic to use Bell Road, and the traffic impact study statement was approved in January 7th, 2025. As I said, it's an existing facility, so it's got existing stormwater, which has worked fine, it functioned fine during Hurricane Debbie. But what we're doing is we are creating some additional impervious, and with that you have to also create some additional stormwater. So we're creating additional stormwater on the west side of the building to address any additional stormwater needs from the additional impervious. And what are the odds that the first time I've used this graphic was today's meeting, or on project coming today's meeting? This is actually what we see when we order the labels from the property appraiser's office. If you look, that red rectangle in there that's the boundaries of the property. We draw a polygon around the parcel. Now, I made a solid red for the little piece that's zoned village that is part of this. And then you can kind of see a little light colored line that goes around it. That's 500 feet. So we say that's what we want. And then all of those areas that are shaded are the properties that were within 500 feet. Now, we had the neighborhood meeting on February 5th. We had it at this parish storage office, and basically it was an in-person meeting. We sent out 29 letters to people. We had 2 people show up, Mr. Randy Hicks, who owned the property behind us, which is the Green Star, and Miss Elizabeth Arnold, who lived, actually, her property barely touches the 500 foot. Her house is well outside of it, but because it touches the 500 foot, you get the notice, and she's in the Red Star. The 4 letters you got came from those houses that the blue stars are on. So that's where the people that that sent you the letter saying they don't want access on Bell Road, that's where they live. We looked it up and said, okay, that's them. And that's why they didn't get a notice, is because they're not within 500 feet. And quite frankly, the 700 foot, if I had maxed that out, we probably still would not have ended up sending a letter because they still wouldn't have touched that radius. So I'm just showing you that because it seems relevant to the conversations you had before lunch. Rules don't necessarily change, interpretations do. We're adding 18,000 square feet of mini storage. If you look at the Land Development Code, the Land Development Code says that we need 1 parking space for every 5,000 square feet of mini storage. 18,000 square feet, we need 4 new parking spaces. We're proposing 8 new parking spaces. We have 26 existing parking spaces. And I'm just going to, well, these are the specific rules. So we have 26 marked spaces. We're adding 8. 18,000 square foot needs 4. But because interpretations have adjusted, we were deemed that having 34 spaces was actually going to be 5 shy of what the code would now require. Basically, the project that's in place and approved is not okay anymore, and we needed to add more. So we're asking specific approval. Staff has been supportive of this, that we'd be allowed to have 5 less than what the code calls for. We provided a parking study that showed realistically we only need 30 or 31. And I think staff and I agree now that if we restripe all that loading area in the back, we can count that now as parking spaces, so we could probably do it that way if we had to. But we wanted to put the parking out there where people coming to the restaurant would have access to that extra parking too. So that's what that one is. The second one is because in the parish commercial overlay district, if you have a building footprint bigger than 20,000 square feet, you're supposed to get specific approval for fast tracking and stuff. Our building's actually partially in, partially out, but we're asking for specific approval. To the direct north of us at the Hideaway Storage, they've got a 25,000 square foot footprint, 3-story building. Ours is going to be 24,000 square foot, 2-story. But, you know, we're requesting specific approval to have that allowable. And then 3, 4, and 5 talked about sidewalks, adding sidewalks. Well, realistically, the people that are using the storage facility don't walk back and forth between the restaurant and the storage facility per se. And so we're asking for the specific approvals because nothing really functionally is changing on how this property is being used other than there's going to be more storage. The storage is primarily going to be accessed from the existing building, but we're asking for specific approval to waive those requirements for us to get that on this. So just in conclusion, we're expanding an existing use. And again, we colorized it just so you can see what the extra we're doing. And I can't show you with my hand, but you know, we're putting 8 extra parking spaces. We do comply with the Land Development Code. We comply with the Comprehensive Growth Management Plan. The traffic impact statement has been approved. We are utilizing existing access on 301. We are not taking any access off of Bella Road. In fact, the access off of 301 is right in, right out. So we couldn't even make a left turn and go to Bella Road. You'd have to go north on 301, do a U-turn, make a left on Fort Hammer, and then make a left on Bell Road. So there really is no real potential for us to be using Bell Road. The Planning Commission gave us a unanimous recommendation of approval, and we request approval of our request. And I'm here to answer any questions. Thank you.
I have no one on the board. If there are no questions for Bob, I will bring up Alicia. Staff.
All right, good afternoon. Alicia Henry here for staff, and I have been sworn. Okay, so I'm here to present for parish storage expansion. So the request is to rezone only 0.47 acres of a 3.44 acre site from village to PDC, which is also located in the parish commercial village overlay with a preliminary site plan. So if it's approved, it will permit a 2-story, 18,000 square feet addition to an existing mini warehouse of 40,300 square feet, expanding the size to 58,300 square feet and retaining the 1-story existing restaurant of 2,016 square feet. This will increase the number of parking from 26 to 34 spaces. Okay, so for the history, since the adoption of the comprehensive plan, the future land use category has been Res 6. And since the adoption of the Land Development Code, it has been Village. And in 2010, the larger portion of the subject site has been rezoned to PDC. Here is the aerial of the site. So it's located northeast of US 301 and 4 Hammer Road intersection within Parish. So here on the preliminary site plan, we do have the one access that's onto US 301. Again, site is of 3.44 acres, only rezoning 0.47 acres, existing two-story mini warehouse of 40,300 square feet, existing restaurant of 2,016 square feet, two-story, it also includes a two-story 18,000 square foot addition to the existing mini warehouse at a height of 25 feet. Site provides 25% of open space, which is actually over the required amount, which is 20%. So applicant is requesting a specific approval, which is a deviation from parts of our code. So it's a deviation from the required number of off-street parking spaces. It's a deviation from 20,000 square feet maximum building footprint within the Parish Commercial Village overlay. Requesting relief from a required pedestrian walkway from the building's main entrance to the street within the Parish Commercial Village overlay. Requesting relief from requirement that buildings shall be linked to one another by a secondary walkway system. Also requesting relief from a requirement that a public sidewalk is connected to an internal pedestrian walkway. Again, the future land use category is Res 6. So for our zoning district, to the north, we have PDC, west is Village, east is A1, south is A1 and Village. And for the uses to the north, we have a mini warehouse. To the west, we have a distribution warehouse. East is agriculture, south is single-family detached dwelling units. And the current zoning, again, is PDC, and this is located in the Parish Commercial Village overlay. So I'm going to give you a little bit of information in regards to this overlay. So this overlay promotes new and renovated commercial development that will be harmonious with the existing parish community. It allows for greater visibility of businesses by encouraging parking to be located away from US 301. Area focuses on standards for building placement, architecture, landscaping, and signs within the parish community. And to the left there, you can see the map that outlines where the Parish Commercial Village overlay is. Okay, so for the transportation link capacity analysis, below we have the chart that shows the adopted level of service and the future level of service for the nearest thoroughfare. So the current adopted level of service is D, and the future level of service with project will be F, but according to the art plan analysis, it will be a C. For our positive aspects, the proposed neighborhood serving commercial uses are consistent with the Res 6 future land use category. Site design provides 25% open space, exceeding the 20% open space for the project. There are no wetland impacts proposed with this project. No state or federal listed species were observed on site. Project is an addition to an already developed site. The project can provide storage services and reduce the need to travel long distances for this particular use. The applicant is requesting relief from LDC Section 100.3 to deviate from the required parking ratio for the proposed use. And for the mitigating measures for that, we have that the applicant has provided a parking study which supports his reasoning for deviating from the code for the required 39 spaces. Also, for mitigating measures, we will have adequate buffering, landscaping, and design that should provide a transition between future development of the site and adjacent residential areas. If improvements to public infrastructure are required, the applicant shall be required to construct or pay its proportionate share for such improvements. So staff does conclude that the request can be found to be consistent with the comprehensive plan and in compliance with the applicable provisions of the Land Development Code. Any questions?
No one on the board?
No? Okay.
Thank you very much. I will now open this up to public comment. Nobody submitted for public comment. I assume so, since you were named under a red star.
They gave me the red. I also snuck up and I have.
Just give it to the clerk.
Permission. Who do I give it to?
State your name and whether you've been sworn, and you have 10 minutes.
Yes, sir. Elizabeth Arnold. I've been sworn, Manatee County residents, live in the neighborhood. Would like to go over a little bit of history since I've got 10 minutes. Back in the day, I don't know if any of y'all were on the board at that time or not, the Parish Civic Association and I believe a retired commissioner and some of the county staff worked on how to get more parish downtown business, if you will. And they decided that the 50-foot north central overlay setbacks were a detriment to business because they wanted to have little boutiques and little coffee shops, and they wanted outdoor dining and all kinds of nice little things. And I can't say that I blame them, although I will have to admit I was opposed because I was worried what would happen if they went with the standard, because what Parish wanted when they created the north central overlay was to have a rural tone and have lots of shrubbery and trees and have it pastoral. And so this was they were hoping for a change for the better, and I don't think that's what happened, because as soon as the north central overlay went away, then we started having things like storage facilities, large two-story storage facilities, 7-Elevens, and let's see, Dunkin' Donuts, and various sundries of things that wasn't really in what they were looking for. They were looking for a rural version of Main Street in Lakewood Ranch, and what they got was nothing even close to that. In fact, I talked to both the previous PCA president and the current PCA president, and they both kind of agreed that this was not a really good plan or what they had envisioned. So I want to talk about the neighborhood. The neighborhood is what I would call, and what you all should be really concerned about, it's an affordable home community. If you look at, let me show you just a picture. This is the road. I don't know. This is working. Do we have the, yeah, okay. This is the road with the canopy oaks. It's a very old community. It's historic. A lot of these homes were built in the 50s and 60s. Many of them are probably two-bedroom, one-bath homes. They're probably 800, 900,000 square feet. They're on little tiny lots. And the people that gave me those letters, 6 of them, live in the community, and they were very concerned. They sent out a thing when the sign went up saying, hey, we're going to have a meeting. It's going to be before the BOCC. And they sent out a text message saying, what's going on? And they thought that the entrance would be off of Bella. And I said, no, they're going to have, as they told me, and then as I understand it, they told me there was going to be a quote, concrete pond, end quote. And they said, what are you talking about? And I said, well, and how do you know? And I said, well, they had a neighborhood meeting. And I went to the neighborhood meeting, and the gentleman there told us that, like the Clampetts had in front of the storage facility, they were going to have a concrete pond. And I said, well, couldn't you just have a pond with slope and it would be pretty, maybe something like that? And he said, no, the walls have to be too steep because we have to be able to handle so much water, and they would cave in, so we need to have concrete. And I called staff later on and found out that they couldn't tell me how deep it was going to be, but they could tell me that it was going to be 60 feet by 30 feet square, whatever, rectangle, and it was going to have an 8-foot fence around it. So the folks were pretty disturbed to hear that. And they asked me if I could speak, because most of them are young. These are their first homes. Some of them are renting, some of them bought. And they have kids and they work. And one of them actually, and we should pray for that person because they're at the hospital today with their mother in surgery. So, but to take it, to show you a little bit about what we're talking about here, when I tell you there are some storage facilities. Okay, the red ones are storage facilities. So this is the one that already exists. This is where they want to add more storage. This is a storage facility. And I was kind of sad that staff is working with old aerials. I guess they didn't have more current ones. But this is the storage facility next to the storage facility that they want to add more to. This one I think is either 2.5 or 3 stories high, and it's very large. And I think they had trouble getting a CO because it's actually, I think, too big, or there was some other problem with it. And then we move along, and my printer was dying. Okay, so right here, so here's the neighborhood. And right across the street, right across Fort Hamer, they're putting in another storage facility, and my printer was dying, but this one's going to be 3 stories high, and it's very large. So, and then over here, and I don't know if I got it exactly on the right spot, but over here, they have RV and boat storage and all that kind of stuff. So, and I believe the folks who want to build more storage facility in front of their already existing property also in this one. So from my house, I can literally walk to 4 storage facilities in 5 minutes. And, you know, I think the reason that the folks that I talked to with the Parish Civic Association, when they did what they did, when they helped eliminate the North Central overlay, they were really wanting to create a village atmosphere that focused on pedestrian-friendly environments and amenities in close proximity. They wanted walkable neighborhoods where residents could easily access shops, restaurants, and other amenities. I don't think this really was what they had in mind when they were moving forward with their ideas. And I think it's important to realize that this community only has 42 homes in it, and that most of those people don't have the money to hire anybody to come here as an attorney or help them. And the biggest concern that, one of the biggest concerns that they have is if you let this lot go, because the house was sitting in it, they demolished the house, then is it like dominoes, where it just kind of dominoes through the whole neighborhood? And by the way, the lot is not on 301, it's not on a node, it's on Bella in a residential neighborhood. So you're going to basically, if you approve this, you will be disrupting the community character. I believe that probably there will be increased traffic down Bella because people cut down Bella all the time from Fort Hammer anyway. And now that if they add more things to cut down the road for, they're going to do it. I believe that probably there will be a decline in property values. But I want to talk now about the concrete pond, as the Clampets used to call it, which really is a stormwater pond. And I didn't think that it was very humorous, but okay. So, all right. I had to get this from a text message from somebody. They didn't drop one off at my house because I guess they didn't want me to have it. But here's their addition. Here's their concrete pond. The folks living directly next door had no idea this was going on. And when the house was torn down here, they adopted a bunch of cats, and we gave them cat food so they could feed the stray cats that were left homeless. But this is the concrete pond, the 60 by 30 foot concrete pond. And let's see, This is the barbecue restaurant with this patio where everybody dines outside, which will be directly overlooking the concrete pond. And I asked during the meeting, I said, so, okay, you're going to have a stormwater facility out front. It's going to be directly on the road, basically. Might be set back, and there might, what I was told when I asked, well, what's going to be in front when you drive down the entrance to the neighborhood? What's going to be in front of this concrete pond? And they said a fence, but I didn't get an answer till I talked to staff that it was going to be chain link. Oh, so anyway, they told me at that point they weren't going to treat the pond with chlorine or anything, and I don't know how many of y'all have pools or have seen what happens when you don't treat your concrete ponds. But thank you very much, and please consider when you vote for this, how many employees are they going to hire, and how many people in the neighborhood are going to get any benefit from it?
All right.
I appreciate it.
Thank you, Liz. Is there any other? Oh, you showed a picture.
Sorry.
We like to keep that for a scrapbook.
Okay, let me get it for you.
Any other public comment? I'm not calling on people. If you're standing in front of the microphone, you get to talk. Larry, were you going to talk as well after Dalton? Okay.
Good morning, Dalton Nelson, Manatee County, and I have been sworn. I'm kind of surprised Norma's not here, to be honest, because this sounds like something that she'd really be advocating for with the Parish Civic Association, but I also know what she would say, and so I'm going to kind of advocate a little bit on her behalf because I have heard our arguments about this, and the whole reason for the village overlay, and she explained it very well, Miss Arnold did, but you know it was to kind of create the village that was once parish before it burned down. You know, we don't want a bunch of tall structures like is here in Bradenton and stuff right on the road. If it's set back off the road, we're fine with that. C&K Barbecue is a perfect example of a business that works as a buffer to where you don't necessarily see, you know, a 3- and 4-story building right off the side of the road. It's set back. The same goes for the other buildings that they have for the boat storage and RV storage. They have other businesses that are in front of that, which is the aquatic therapy, and then they also have the parish car wash that everybody knows and uses all the time, including myself. I frequent them all the time, give them our business. You know, there's been a lot of discussion from Norma about, you know, the kind of atmosphere that we would like to see in parish, and that was literally the whole point of the overlay, was just to kind of give us a little bit of a buffer and keep a little bit of parish. So I just wanted to add that piece in there. You know, other than that, I've seen these concrete ponds before where I came from in Lakeland. They are effective, but they do breed a lot of mosquitoes unless they're maintained. And there is a lot of concerns with if it's right next to a roadway. I've seen a lot of cars go in these ponds, and it's very, very, very expensive to clean up the environmental impacts and to recover them out of the pond because they're usually quite deep. And you do have problems with not only the mosquito population, but you also have problems with the aquatic vegetation like duckweed and stuff that will migrate from this site once it's established. So I just want to kind of point that out, and thank you for your time.
Thank you, Dalton. Larry?
Hello again.
Hello.
Larry Arnold, and I'm sworn. Have been sworn. Put that back down. Turn this over, whoever gets this. And I have 5 signatures. I promise not to use attendance.
They're different signatures, right?
Right, different,
And one of them's
different,
not Liz,
different,
correct?
yeah.
Okay, so I'm sure.
Yeah.
So I'm sure.
I collected them over at Tractor Supply. No, just kidding. Just a couple of comments to finish up where Liz left off. But Parish, in my opinion, and it's shared by a lot of folks, and they're growing, that number's growing every day, have paid a pretty heavy price over the last few years for the development that is really going crazy and has gone crazy in Parish. So from that perspective, this is just one more. It's really a microcosm of a lot of what has happened on the larger scale at the county level. A neighborhood can get crushed by this. It looks on the surface, looks good, sounds good, modest expansion, but it's actually a very aggressive expansion. That concrete pond could possibly be a actual retention pond if they weren't so aggressively expanding their square footage onto the property. But the bigger concern, and by the way, those signatures that we turned in, that goes back to the workshop where there was no sign and folks didn't really start to catch on to what was happening until the sign for the hearing got put up. And it takes a while for people to react and connect with each other and find out what's happening in their neighborhood. Those folks mostly all work, and that's why they're not here today. My personal opinion in walking the space, looking at the area, is what you've really got here with the changes in zoning and with the variances being requested. You're trying to put 10 pounds of shells in a 5-pound bag. It's a real squeeze, and pushing that retention pond and the nature of that pond up on that street. And this is not about access to Bella. This one is not. It really isn't. But it's about what can happen. And if you just look where I'm pointing here, that those next door neighbors, as Elizabeth said, they didn't know. They're renters. Those two little lots there are rentals. The ones that come down Bella, at least to the first corner, are rentals. The smaller ones in the back, most of those are rentals. There's 42 houses in the neighborhood, probably 37 or 38, we probably all agree, are affordable housing type units, either owned or rentals. And about 37 of them would probably be considered affordable. The neighborhood is going to feel pressure from the other end where the project is going in at the corner of Fort Hamer and 301. That's where another 3-story storage center is going in. The neighborhood is across Fort Hamer. There's an O'Reilly's that has tentatively been put on the corner, approved for the corner of basically Bella and Fort Hamer. And if that access question doesn't get cleared up, that will go through Bella. And between the two of these, you'll crush the neighborhood. But the real concern, and by the way, we were just at the edge of the notification, but I'm concerned about our actual property values. But I am also truly concerned about my neighbors and folks who have become friends that live in some of those smaller homes. They're folks that have lived there 20, 30 years. Some of the renters have even lived there 10, 15 years. And what can really happen is we're setting the stage for this next one to then get rezoned, then the next one gets rezoned. And because they're rentals, some of the ownerships, there's 2 owners, there's 2 folks in our community that own some of those rentals. And they'll probably sell for the right price if they can get rezoned to a higher density. The zoning that's on there now is basically a duplex type zoning, and it would be a great transition for that existing neighborhood and preserve those homes where those young families live, and not have them have to go off in search of more affordable housing. And stand to answer any questions. I promise you I'd keep it brief, but basically we're trying to preserve that neighborhood, and it's just too much, too fast, just like the note I sent you all last week. Thank you.
All right. Thank you, Larry.
I turn this into.
Good afternoon, Mark Van Der Manatee County. I have been sworn. And I have a couple of problems, issues with this particular application. I think you should too. And one has to do with this cement pond. Is it impervious bottom, pervious bottom? Is there any slope at all whatsoever to the sides? What type of maintenance is it going to require over the next 5, 10, 15, 20 years? Is it even going to work properly? It may, I don't know. You have no information about that. It's going to have a chain link fence around it. That's great. Animals still going to get in there. They're going to die. They're going to decay. They're going to, but if there's any water being held in there, especially during the rainy seasons, it's going to make a real nasty kind of a decaying stew for the area. Folks in that restaurant are not going to be very appreciative of that, but I think these are questions you need to ask. What's going to be going on in that cement pond? And is it even going to work from a stormwater maintenance and drainage standpoint? I don't know. Nobody said anything about it. There seems to be an awful lot of special approvals required here also. I mean, whatever happened to following the rules with the LDC? A special approval is breaking the rules, not following the rules, requesting to be allowed to break the rules. I'm not sure that's a nice trend. That's not a good trend for development going forward. Now, I spoke before this board back in March on storage warehouses, and I think I made my opinion clear on the trend in the community, in the county, on storage warehouses. I made a few comments about being a warehouse, why aren't they restricted to warehouse districts instead of sprinkled all over the place? And I know you made the same face last time, Commissioner Cruz. And there are a lot of communities that are in fact doing that and restricting them to certain areas, not allowing them to be everywhere and anywhere that they want to be plopping them down 2, 3, 4 stories. They are eyesores, and there's a need for them, but there's not a need on every corner. Some communities across the country now are actually spacing them out every 1 to 3 miles, not on every corner. Now in March, I made a couple of comments. They were a little snarky, I admit, having to do with the fact that we shouldn't be encouraging folks moving down here from up north to bring all their junk with them. All right? In fact, I said, and Commissioner Cruz is laughing again, and he knows where I'm going with this. I said that the warehouses should be built next to the landfill so that when the people die, they could just put all their junk and put it right in the landfill because that's where it's going anyway. You know that. And, Commissioner Cruz, I know I was being snarky. You said that my comments were asinine at the time. But let me clarify what I'm saying here. Nationwide, 10 to 15% of these storage lockers are abandoned. And all the junk that's in them, on average, is getting thrown in the landfill. So this is not something I think we should be encouraging on every corner, everywhere. I would ask you to go back to staff or go back to the applicant and ask them how this cement pond's going to work and if there's some alternative to what they're proposing here. Thank you.
For the record, Glenn Gadfly Jubilina, and I have been sworn. 5 exceptions. Not 1, not 2, not 3, 4, and 5. What I find disturbing is staff went along with it. Oh, it's all right. We'll just give them the exceptions. First of all, I think there should be a freeze on rezones. There really should be. You've heard it from a lot of people. They should handle storage lockers like liquor licenses. For every 100,000 new people come in, you get to put up a storage unit. This is crazy. This is going to devaluate the neighborhood. It's going to be an eyesore. And the concrete pond, how many more concrete ponds that we have had in existence in Manatee County that work? Do we have any gauge to look at it and say, this works or it doesn't work? Like you say, animals, cars in there, it's gonna be disaster. And no natural filtration, that is gonna be a problem. The exceptions, you know, when I look at these, 18,000 feet, they want to add on a half an acre, which is 21,708 square feet. That's less than 3% of the 97% total of what they're asking for. It's like the Borg. You go down there and say, we will assimilate. We're going to put one every block. The madness has got to stop. The exceptions, they're there for a reason. Sidewalks. You know why you put in sidewalks? Because if a business comes down the road that requires a sidewalk, it's already built in to this permit. If you allow them not to put the sidewalk in, then the business next door says, oh, we can't do it continuous because we never let the storage locker, we gave them a pass on that, so you don't need to put in a sidewalk. That's not what it's designed for. The parking spots, they need to put 5 more, simple as that. Why are we doing exceptions on parking? We shouldn't, absolutely not. This is just, this little community of those small houses, first of all, it's gonna be an eyesore to them, and people are gonna be using that side road. I don't care what you say. They're gonna be using that side road and disrupt that whole neighborhood. I know because I live on one. I live on 28th Street. We were very quiet at one time until they put a concrete plant on one side of my house and a brick manufacturing on the other. There is no peace and quiet when I originally bought that house 35 years ago. Those days are gone. This neighborhood's gonna be the same thing. You're gonna put a Starbucks in there, you can do another storage locker. You're disrupting the neighborhood, and they will bring the value down, unless, of course, they sell out to another storage locker facility. I don't know. I just, 5 exceptions is unacceptable. And for staff to go along with it, I don't think they did their homework. I don't think they can come up here and tell us yay or nay on the concrete pond. I don't even think the applicant can. I haven't seen any engineer reports. I haven't seen existing concrete ponds that have worked. So quite frankly, I think if it does go through and the mosquitoes are there, it's going to put the restaurant out of business. And they're going to come back and say, you know what? We want to add another 20,000 feet because the restaurant went out of business because there are too many mosquitoes and it's an eyesore. So I just see this as a real disaster. Enough is enough with these storage lockers. And then you should make them dual permits. If you're going to put in a storage locker, you got to put in a car wash, right? They go hand in hand. It's just crazy. We shouldn't do it, right? I urge you to vote no on this. It should have never come in here. Should have never come in here to begin with 5 exceptions. That's excessive. 1 or 2, maybe. 5, nope. Just say no for the record.
Good afternoon, Mr. Chair, Commissioners. Anthony Shulo, Manatee County, and I have been sworn. I actually like CK Barbecue as well. I may go there for dinner today because I don't know how long this is going to take. It's my daughter's 15th birthday today. I'm spending the day here, supposed to go have dinner with her. But I'll tell you, if we run super long like we did the last time, I'm eating by myself at CK's tonight, probably takeout. I might treat myself to some banana pudding. So if you look at this property, right, you look at where CK's is, and then you look at that storage unit, the next storage unit, the three lots down, was designed really for like the aquatic therapy. They actually sort of modeled it because they said, yeah, that works. So they put that buffer, that business buffer up front. It almost looks identical to the CK's. And they were like, yeah, this works. This looks good. Seems to be acceptable. It's been working. And then the one they just built next to Billy's place there, the next place over, the next storage place over, they designed their front building to mimic the historic home that they demolished to build the storage behind it. So like they used this particular property and the way it looked as a model for the next couple, right? That set the precedent for what they were trying to do. So then you go back and you look, now they want to take away that frontage area, that little open space in the front, slam in a black chain link fence and a concrete pond and make that mess, and then eliminate that parish community sort of front buffer. So like, think about the chain reaction there. Then, so if that's good there, the next lot over, which is there's a double lot there that will likely somebody will want to buy for storage. And so then can they rezone and do that now? Or can the aquatic place now take over that other front spot? I mean, if this was the model, and it seems like it was to me, I haven't been in parish for 30 years, but I did see all of those projects go together. I just don't understand how you can say it was acceptable and it was the model and then change the model again without expecting the same outcome. You're going to get a sort of a trickle down effect or a repeat offense. So thanks for your time.
Any other public comments? Seeing none, I will close public comments. There's no one on the board. I will go to any final comments from staff.
Okay. All right, so we have a few concerns from the public. So in regards to the retention pond, so I did inquire with other sections of our department about this pond. So at time of final site plan, that's when we are going to actually analyze the depth of the pond. At this point, we won't be able to see or analyze what the depth of the pond is because we don't do it at this part of the process, so it will be analyzed at time of final site plan. Depending on the slopes of the retention pond is if they're going to have a fence and how high that fence will be, that chain link fence would be. I did talk to a member of the public that inquired about that particular fence, and I informed the member of the public it would be a 6 to 8 foot fence. We did not have a discussion, though, in regards to if the pond would be treated, so there was no discussion in regards to if this pond will be treated. Also, with the type of use that is being placed there when the applications come in, of course, we know the applications are driven by the demand, and the comp plan nor the LDC can restrict the types of uses that are being implemented in certain areas, even if it is well saturated with a particular use. Someone from the public also mentioned that we're using a very old, can you put up my presentation, please? A member of the public mentioned that we're using GIS and not basically showing all of the uses that is in the surrounding area. So that's why it's listed here. Directly to the north of the site, there is a mini warehouse that is to the north of where the subject site is for where they will be expanding the mini warehouse. So there is a mini warehouse that will be placed, that is actually in the process of being completed, the development being completed to the north of where the subject site is. And of course, you know, if a development is approved, sometimes it does take a while for our GIS to catch up. With the specific approvals, so with the specific approvals, the majority of the specific approvals are in relation to the sidewalks. So the sidewalks that are on the site are really contained to the use itself. So for the mini warehouse, they do have sidewalks, and for the residential, for the restaurant, they also have sidewalks, and along US 301, they have sidewalks as well. I want to show another aerial. So if you look at this aerial here, so you see that, and you do see where they do have sidewalks for the buildings that are on the site. Now, they're not really a use where you would have a lot of patrons walking from the mini warehouse over to the restaurant. So with the specific approval where he's asking for him to have a deviation from that part of the code, that is the applicant's right to request a specific approval from that, because they are proposing plan development, and with the plan development zoning district, a applicant can actually request deviation from the code. Also, there is questions as to where this retention pond will be. So the retention pond is going to, so we have here the, if you see where it says, it has marked there the barbecue restaurant. So to the, let's go back to this other. Okay. So here on the site plan, you can actually see where the retention pond will be, where the expansion for the mini warehouse is going to be there in the blue, is where the retention pond is going to be right in front of the mini warehouse expansion. So it will not be blocking the restaurant that actually has the design that's in compliance with what is required within that particular overlay. So the Parish Commercial Village overlay has certain designs that you have to set forward for your development architecturally. Now, if we go back here, you see that it has the design that is under the requirement for that particular area. And the pond will not be in front of the restaurant. Some of the designs that are in the Parish Commercial Village overlay are the French Victorian design. They also have the crack design, and also a Florida type of design, which you see with the dental care office that is there. So I know that the public have some concerns, but staff has worked with the applicant to make sure that we do provide what it should be, adequate setbacks and bufferings and everything else that would be compatible to the surrounding area. Also, with the residential use that is to the south of the site, for the Parish Commercial Village overlay, the setback is 8 if you're not abutting residential, but the site is abutting residential use, so therefore the setback is then bumped up to 25. But the setback is going to actually be 39 feet between the development that's there and the residential use that's to the south. Any questions? No? Okay. Okay.
Denise Greer for staff. I'll expand on the stormwater some. What was said is correct. We haven't reviewed that yet. It will come in at final site plan. But anytime that you build a stormwater facility that you cannot build a 4-to-1 slope or shallower, and it's more of a even 3-to-1 or 2-to-1 or maybe just 1-to-1, they're probably going to design a retaining wall around it, because they don't have enough space. And when you do that, you do have to put a minimum of a 6-foot fence around it. And we do not like that to be a PVC fence. We want to be able to see in there in case anything happens. But the reason for the fence is so that no one can just fall in and not get out. So it usually has a locked gate on it. But otherwise, the stormwater will be designed just as if it was a standard stormwater design with 4-to-1 slopes. I don't know if they can expand on it more, what type of design they're going to do or not, but that's a little more detail. And then, staff, if you could bring up the document that I've labeled Swift Mud FEMA map. I know one of the items that Commissioner Sadiq has wanted from us is he would like to know about some of the maintenance that we have for ditches in the area. We do not have any ditches that we maintain directly adjacent to this site, but if you can, there's a little blue square, that's the site in question. Just south of that, the light green, that's the FEMA floodplain, and there is a ditch there. And as the staff report states, we will be asking for a maintenance and access drainage easement over that. We currently do not have that in this area right now.
Yeah, just a super quick question about the fence itself. It sounds like people in this village overlay care a lot about the aesthetic of where they're living. And you said that with the fence, you don't like PVC, you like something you can see into. Would you look at a certain type of fence for this because of that village overlay? Or is it just, whatever chain link they want to put up?
I'll let them speak to that, but typically they use a black chain link because that
Right.
kind of blends in. I know you can still see it, but I think black is one of the ones that they say to use if you don't want to notice the fence as much.
Okay.
But I'll let them speak to that if they've decided what type of fence.
Okay, I was just curious if some sort of other more aesthetic fence would be a consideration.
All right. Tal, were you there for deliberation, or did you have questions?
Question for staff. It's probably a,
Did have a question for staff section.
well, came up after she dropped off. So, thank you. I get this question a lot, and it's about overlay districts and our long-term maintenance review of them, but I'll focus on this one just to ask. Has anyone from staff ever checked in on this overlay to see if it's meeting its intended goals? This dates back to, the conversation dates back to the 90s, but it was approved in 2000. We all know how much change has happened in 25 years, the recession, COVID. Just a question.
There have been changes over since the overlay was put in 2008. There have been changes to this part of the code in regards to design. There has even been some leniency with signs as well. We used to have it to where the monument signs in front had to be 6 foot. Now you're allowed to have a 6-foot sign. They actually asked for a specific approval for a monument sign when they first came forward with this particular development, and now they don't have to have a specific approval from that because it's 9 feet. But we have been making rewrites to that part of the code in order to make sure that we're keeping up with the rural feel of the Parish Commercial Village overlay.
When was the last time anyone from this board or staff did a review of this overlay with the intent of meeting any policy goal in collaboration with the community? I think Rachel's got her hand up.
Okay, go right ahead.
Rachel Layton for staff again. We actually have a meeting coming up with them on Monday to revisit a lot of the work that I personally had done when I worked for ZNS Engineering in the early 2020s. I've actually personally worked with the Parish Civic Association on and off for the last 12 years, trying to help them get through some things that they wanted to privately initiated, as has Bob Schmidt in the audience. So we, on the private sector side, have been helping them navigate. Now it's time for the public sector. So on Monday, Commissioner Feltz and I are going to go meet with certain folks that represent, Miss Norma Kennedy is one of them, that represent the Parish Civic Association, so we can add that to the list of things to talk about. But I think that was the primary reason for them to request us to come out there, is it's time to revisit.
Okay.
Thank you.
Thank you, Rachel. That's all I have. Thank you.
Okay.
That was off. Applicant, do you have any final comments?
I'm not sure I can do it all in 5 minutes, but I'll try. Bob Gauze, and just going to try and touch on some of the comments. Ms. Greer's already addressed the stormwater facility. You get volume by going with the vertical walls, and as she pointed out, anytime you are steeper than 4 to 1, by rule, you have to put a 6-foot fence to secure it. Chain link is typically used. Black vinyl coated chain link is primarily used because it is a very secure type of fence that keeps most things out. So that's the idea. The proposed building is a 2-story addition. And if I can get my little PowerPoint up here real quick, I'm going to try and get to it real fast. this is the facility the house that was purchased. It was purchased by my client because, quite frankly, if you own a project, that is not what you want sitting right up against your project. But you do have to do something with it, and you want to try and keep traffic low. You want to not add an access point onto Bella Road. So you figure out what works, and what works is to expand your existing two-story storage structure. It's a 9,000 square foot footprint, 2 stories, 18,000 square feet, accessed from the inside of the existing structure, and the driveway is the same driveway you've been using, and which, quite frankly, we felt like that was a good solution to this situation. That proposed building, that 2-story, 9,000 square footprint, 18,000 square foot building, is going to be 52 feet off of the road right-of-way. So we're not squishing up against the road right-of-way at all. He's keeping the building 52 feet back. The stormwater pond is being placed between the facility and the right-of-way, and it will be screened from the right-of-way by landscaping. We'll work with staff to make sure that we have good screening between the two. And we would have run it on the north, between the CK restaurant and the building, except that that is where all the utilities come into the property. The water line, fire line, everything comes in through there, and we got to respect that. The CK restaurant is operated independently. However, that building is owned by my client. And the comment about, is the parish overlay working? Yeah, because if you look at CK's, you see they've got a front sitting area where people sit out there and eat, which is part of the goal. So my client has worked very hard to try and make sure that he fits in with the community, but at the same time, take out a situation that's not a good situation and use it in a way that will best work for the property. You can take that, well, let me just flip to this. So, you know, the facility's there. Yes, we're asking for a number of specific approvals. We found out that we needed to submit them about a week and a half ago, so it was pretty quick putting it on. Again, the parking, the 18,000 square foot needs 4 parking spaces. The additional parking is because staff's interpretation is that the old existing facility should have had more. And I think staff is in agreement now that we can count the parking that we could put back behind that gated area, because quite frankly, the majority of people that use the mini storage park back behind that gate. We just don't get to count but one of the parking spaces back there. The other 33 spaces are all out between it. As far as the sidewalks, I mean, we can make adjustments. We didn't have a lot of time to make any adjustments, but the reality is that the only traffic you get between buildings is if somebody working in the office at the storage facility walks across the parking lot to go to CK's for lunch. There's not really any drive aisles or crossing or anything like that, so we just said these don't really need to happen. The sidewalk between CK's and 301, right now what happens is their sidewalk exits onto their drive aisle and people walk out there when they do. Quite frankly, the majority of traffic into CK's and the storage facility, especially the storage facility, is you drive to them, because most people don't walk to a storage facility to drop off their stuff or walk away from it with their stuff. That's just not how it works. And that's what we're adding, 18,000 square feet of mini storage. So we worked with staff and just said, you know, can we agree on this? And they're willing to work with us. And again, the 20,000 square foot, the project to the north with a 25,000 square foot footprint, I don't think they had to do a specific approval, but we were asked to do it, so we agreed to do it. And that's why we're asking for it. But it's a 2-story facility. We're trying to work very well with staff. We're active with the Parish Civic Association. My client has actually gone to the people that sent you the letters. As soon as we got those sent to us, she took a copy of the site plan and her business card and took it to all 3 of those houses to say, if you have questions, feel free to go. So we've tried very hard to make sure we work with the community on this project. And again, I'll answer any questions that you have. If you want more information on the stormwater facility, it is going to be an open bottom. It's just the walls that are vertical, that are concrete. But I have Jason Coates here from Shore to Pallet. Thank you.
All right, thank you. And we are up to deliberation. Commissioner Feltz, did you want to put yourself on the board to talk first as the district commissioner? You want to wait and talk last? Okay. I am on the board first then. All right, here's my thoughts on this, and as well as some history on this. And we're talking about community character. We're talking about warehouse districts. Here's the thing. There's 4 of them within walking distance of someone's house. This is the warehouse district. Guess what? I mean, here's the problem. People want to talk about conforming, and then somebody wants to build something that conforms, and they're like, oh, but not that. we only mean conforming if we mean single-family homes next to single-family homes, not storage next to storage. Now there's a problem. This is existing storage, next to existing storage, in close proximity to existing storage, on a major thoroughfare that is a major road that we don't oversee. This is owned by owners that have been good stewards of their property. I mean, in fact, half the people who came up here talked about the thoughtful design of their existing properties, but we're not affording them any kind of other rights. We talk about these exceptions, 5 exceptions. First off, as they pointed out, half those exceptions are asinine. I mean, having walkways between buildings of self-storage, how many people have a self-storage unit over here and a self-storage unit over here, and like, I better have a sidewalk that's buffered so I can get from my one storage unit to my other storage unit? It's ridiculous. When you need to ask for 5 exemptions on self-storage, it means this government has over-regulation, and we need to consider what people need to exempt themselves from. And I'm a little surprised, Glenn, not to call you out, but for you of all people to complain about a request for parking, you're the biggest advocate of affordable housing in this entire community. I have advocated to eliminate all of our parking ratios in Manatee County, and you have waved a flag behind me. See, there it is. Everyone wants what they want as long as what they want conforms with what they want. Like, that's not the way the world works. I don't think, first off, if anything, commercial is the one that most people should agree is okay with less parking, because if they screw up and have too little parking, that's going to negatively affect their property. If commercial has too little parking, everyone parks on the side of the road and causes safety hazards. If anything, more people could argue that residential, like multifamily, needs to have adequate parking to avoid on-street parking and problems. If they don't have enough parking and someone shows up to go check their unit and all the parking spaces are full, they can't pull their U-Haul up to get their Christmas decorations out, they're going to move to a different self-storage facility. And believe me, there's plenty of them in the area. So it's in their best interest to provide adequate parking. So if they're asking for less, that's the risk that they're taking. That's the risk that C&K Barbecue says, we're moving down the street because our clients can't park here anymore because you didn't provide enough parking. That's their risk. And it's all internal. And here's my bigger problem with this particular, first off, and going back to the village and saying we want an atmosphere. Anything you want as an atmosphere in that village is going to cause more traffic inherently than self-storage, which is the least traffic you can possibly come up with for a commercial use. You put a coffee shop, you put a Starbucks there because it conforms to a village overlay and the intent of the downtown village area. Those cars are going to be lined down that side road waiting to pull in there. But at the end of the day, here's where I ultimately come out on this. 3 years ago? When was the property next to you proposed? About 3 years ago? I think I'm the only one who was on the board at the time. A different developer came in and asked to build self-storage next door, which has now been built based upon some front row building that looks like the old house or something. And Heather came in and asked us, do we really want this much self-storage? Is this what we want this area to become? And this board, I believe I voted against it, but I may have voted for it. I don't remember. It was 3 years ago. Voted in favor of it and put more self-storage there, creating a self-storage corridor that clearly is attractive, otherwise you wouldn't need more. And if anybody on the planet, well, maybe Mark being the exception, is going to be thoughtful about where the water goes on their property, I promise you it's Heather, because other than Mark, I don't know if more people have messaged me about issues with neighboring properties having water runoff onto other properties than Heather, and I've had meaningful conversations with her and had people go out on that site. She understands the negative aspects of a neighbor being impacted by off water, by problems with their neighboring. I trust her. I trust the fact that they've had 2 properties out there and have never had any problems. And all the people even came up, talked about these properties being good properties and thoughtful properties. It's a reasonable request with reasonable exceptions in an area that already has conforming storage to it. So I am going to be in favor of this property because I trust that they're going to do it the right way. Thank you, Commissioner Siddiqui.
Thank you, Mr. Chair. Going to focus on something slightly different. I've heard a lot of folks from that area talk about community character, and this is a village overlay that goes back 25 years. I think my biggest problem with this county is there's a set and forget approach to incentives, overlays, opportunity zones, TIF districts. There's a department that used to exist, Rio, now it doesn't. And now we're trying to piece together what the heck actually the intent was. And that's kind of the problem with these districts and incentives that don't sunset or don't receive a review. So I'm glad to hear the district commissioners conducting that, because I've talked to past PCA presidents. I drive through that area every now and then. I have friends that live in that area. So I tend to agree. What you were sold, or what your predecessors agreed to work with the county on, is likely not what actually should be there, at least based on the intended vision. And it has become a bit of a warehouse district. So I think it's incumbent on us in the work of the community to figure out what went wrong and how can you adjust and reevaluate. I was reading an old news article, and it said that even when that district was established, the folks that wanted to build those concepts there were priced out and got bought out by folks that probably could build storage units because they just had more money. So there's some unintended consequences with government getting involved a little bit to incentivize something without having the right partner in play. So my contribution is, I think you have a fairly responsible developer. I'm not too concerned with some of the runoff considerations and questions that, and I think staff are bringing that up, because I did go in this area, grand tour, to look at the condition of stormwater facilities there. But I do think that this speaks to a broader issue. It's not just District 1, it's every district, every place that has these overlays, zones, what have you. There does need to be a review to see if they meet their intended criteria. As far as this project is concerned, I understand it's probably not ideal for some, but I think it's probably the best use of the property here, so I'm in favor of it.
I'm going to come out differently, and I'm going to come out for the people here, because, obviously, they're the major stakeholders that live there. Cape Coral had the same problem with this, so they put a moratorium on self-storage units, and they did that in 2023, and they carried it through 2024, and it was challenged by SB 250 and found to be not overly restrictive to have that type of moratorium on one thing. They were having the same problem. I didn't know we had, districts where we have a storage district or anything like that in Manatee County. So the thing is here, that down in Cape Coral, they actually said, they're building too many of these, they're building them too fast, they're building them too close together. So they put a moratorium on them so they could sit down and say, okay, what kind of stipulations do we need to make? What do we need to do? They just lifted that moratorium in October of 2024. They had it on since April of 2023. And, they said facilities must meet certain design aesthetics with perimeter barriers and landscaping. Parking areas and loading, unloading zones must be facing away from residential districts and right-of-ways. The amount of self-storage will be capped at 10 square feet per city resident. The thing is that this has been a sore spot with, and the same thing happened over in Volusia County. This has been a sore spot with a lot of people. This isn't a question of residential homes. This isn't a question of districts. This isn't a question of, does it fit into the area? Because if you do listen, it doesn't fit in the area. You're talking now about a special stormwater thing. You're talking about 5 exceptions. So really, does it fit in that site? I would say no. So in looking at this and looking at, what the people want in that area, as well as, what really fits in that area, and what our code development is, and our land development code, which we keep making exceptions to, and then bring out these mitigating factors that really don't mitigate, I think this is a problem. So, I'm going to vote against this. Thank you.
No one else is on the board. Commissioner Feltz, did you want final word before we go to a vote? And I'm at any point in time entertaining motions. We are done. I'm literally entertaining motions and ready to go.
I appreciate Dr. McCann bringing up comparison studies with that there are moratoriums that exist in other counties. It is a possibility. I cannot imagine, I think Tal said that he just took a drive through that area just recently. I can't imagine anybody going through that area in 301 and not seeing that it has become, there's really no legal reason why we just can't build a whole row of storage units all the way from Fort Hamer Road to 62 or beyond, right? Nothing wrong with that. But, and to tell you how things got to where they're at. We had a North Central overlay. It covered 71,000 acres at one time. 71,000. Do you know how we lost the North Central overlay? Just a little bit at a time. The nose the camel gets in the tent. And pretty soon, do you know why they took away our North Central overlay? Because we weren't paying attention to it. That was exactly the reason. Well, we're not paying any attention to it anyway. Seems we should take down speed limit signs. Nobody pays attention to a speed limit sign on a highway, so why not take that down too? This is how we got to where we're at. And there's a lot of things about this project that there used to be some, when you see in that roadway right now, the things that we could have saved had we had the forethought of it before. Maybe some of you aren't familiar enough with the area, but there was actually the Rutland home was on the corner of 675 and 301 that could have been incorporated into this overlay that and the village that they've envisioned here. We talk about not having sidewalks because, oh, we don't need them to go from storage unit to storage unit, but what about our intermodal transportation? We have people that are begging us for places to ride e-bikes and golf cart paths and things like that, but we're not considering, is something funny, sirs?
Yes.
Okay, fine. We'll share the joke after we've finished our serious deliberations. So we're not really thinking ahead, and we're not really looking at that vision. Here we go again. We're whittling away at the overlay, just a little piece at a time, just making an exception here, making an exception there. I'm very familiar with the area. I mean, right back up to it, very familiar with the neighbors in the area. But, you know, Bella Road was created, it used to be Doris Road that went all the way in. Again, that communication with your neighbors, you had an effective neighborhood meeting and assured them that there wasn't going to be an entranceway from Bella Road, but when the address is Bella Road, that leads people to believe that that's what's going to happen. I think this applicant has done the best they can maybe to, you know, I'm just going to expand what I've already got. And by the way, in addition to the storage units that were shown on the map, I think we have another one coming up on 675. So actually that's 2 more coming up on 675, okay? So would any of you want to live in an area that you're basically a corridor of storage units? And if you would, then is that what you want to use and here, listen, some people on the other hand are saying, hey, the traffic's going to be less with a storage unit. It's like living next door to a cemetery, right? But we've got to hold back on some things here. And the most that disturbs me about this is our stormwater retention on that. Sorry, but we don't even know what we're doing with the cement pond, frankly. We don't know how deep it's going to be. And even if you've already admitted you're going to have a stormwater issue on this, and you're coming up with some untested, we don't even have the facts on it, design with a chain link fence around it. And I know what the people in the area are fearful of. We just don't want any more storage units, or the parish village overlay is going to be the parish storage unit overlay. And even though they can be good or passive neighbors? Another thing, how many jobs does a storage unit provide? What is the benefit to the public? What is the benefit to the public of having 5 storage units within a, what, 2-mile radius? Really necessary? And I'll tell you, I worked for a mechanical engineer, mechanical, electrical, and plumbing engineer when storage units first started appearing on the scene. They're easy to build. You know what I mean? You just use the same plan, the same print. They're really cheap to build. But when you end up with an overrun on them, what do they become? What future use could they be once we run out of stuff and a place to put our stuff? So I appreciate Dr. McCann's insights on this that provided a lot more than I could. All I know is of the area. This is not compatible with the vision of the people who want to see Parish cleaned up a little bit. We've already given away too much by getting rid of the North Central overlay. We'll be having a meeting on Monday to bring up to our current situation what we could do. I think without sidewalks, we're speaking out of one side of our mouth that we want intermodal and we want trails and we want this and we want that. Oh, but if it's a storage unit, we're not going to worry about a sidewalk in front of it. We worry about our stormwater, but we're going to use an experimental basis of a cement pond. And let me tell you something, Parish does have really big mosquitoes. Really big mosquitoes. We're talking about Alaskan-sized ones. And so for those reasons, and because I am here to represent the people, and that's all the people, but we've got a great number of people out there that do not want this and would like for us, you always come back with another plan, you always do, but we don't have enough facts to do this, so my vote's going to be no.
All right, no one else is on the board? I'm entertaining motions.
I'll make a motion to deny.
I'll second.
I have a motion to deny.
Was I not gonna, was I not, oh, I thought my hand was up, so.
Oh, well, I don't think anyone saw your hand up. Go ahead.
No worries. I just want to make a quick statement. I'm gonna agree with Commissioner McCann and Commissioner Feltz, and I'm just gonna vote no on the storage unit application because our community's we're getting more and more of these types of facilities, and we're already giving away so much of the intent behind the overlay, which was meant to guide responsible balanced growth, and it's just being chipped away one approval at a time. So we just need to protect the vision of this area and that truly serves our residents, and I don't believe that's more storage units. So I'm just going to be a no on this as well. Thank you, Mr. Chair.
All right, and now no one's on the board. I have a motion to deny by Commissioner Feltz, seconded by Commissioner McCann. You can cast your votes now.
I'm sorry, is there a date? Or
Yes.
bring it back?
The denial.
Oh, it's a denial.
Yeah. So
It's not defer.
I'm just questioning what date we should put the
Correct.
motion.
August
August 7th.
7th,
Thank you.
2025.
Thank you.
Okay? The motion to deny fails 3-4 with myself, Commissioner Ballard, Commissioner Siddiq, and Commissioner Ron in opposition. There's no longer a motion on the floor. I'm entertaining motions.
Mr. Chair, motion to approve PDC-24-22 parish storage expansion.
I have a motion by Commissioner Siddiq. Seconded by Commissioner Ron. You can cast your votes now. Commissioner Beard, how do you vote?
No.
I didn't want to assume anything. And the motion to approve is approved 4-3 with Commissioners Feltz, McCann, and Bearden in opposition. It is now 3:05. We will take a 10-minute recess till 3:15 and come back for item number 14, Lorraine Corners.
You and I have
All
basically
right.
the same view.
We
Yeah,
are
it's awesome.
back. Commissioner Ron, we are back. Kids? We are up to item number 14, Lorraine Corners. Ms. Knapp.
Item number 14, PDMU 1612G Revision 2, Lorraine Corners. A revised general development plan to increase commercial and office entitlements from 50,000 to 100,000 square feet. Addition of warehousing as a permitted use on approximately 68 acres. Generally located north of State Road 70 East, south of 59th Avenue East, east of Lorraine Road, and west of Post Boulevard. Approving a schedule of permitted and prohibited uses voluntarily proffered by the applicant as Exhibit B, subject to stipulations and conditions of approval, and your staff presenter is CJ Mills.
Has there been any ex parte communication on this?
No ex parte communication, but I made a site visit this morning right after the thunderstorm.
All right. Scott, you're up.
All right, thank you, Mr. Chairman, Commissioners. Good afternoon. For the record, I'm Scott Rudisill, and I am here representing the applicant. This is a request to amend the existing general development plan for Lorraine Corners Northeast to add 50,000 square feet of commercial uses and to add warehouse as an approved use. So I want to start by kind of walking through the history of this project and kind of how we got to this point, and then I'm going to turn it over to Bob Schmidt to talk about our request. So this is an aerial of the site. As the name implies, it is the northeast corner of Lorraine Road and State Road 70, extends all the way to Post Boulevard. The parcel that we're actually talking about today is the one that's highlighted. Let me get you a little closer view here. So the project, you can see that's Publix there at the corner. Publix is actually not part of this GDP, but just to kind of orient you, the Oasis is there to the north of Publix. As you go to the east, you have big gyms, storage, pet resort, vet office, tire store, Taco Bell. And then the site that we're talking about today is the one that's highlighted. It's about 3.3 acres. I'm gonna flip through some of this stuff and get to our GDP. Okay, this is the original GDP that was approved for this project. You can see what they call the north parcel, the parcel to the north of Publix. It originally had an option for either 220 residential units or 251,000 square feet of commercial office. And then as you move to the east, you can see they show the mini warehouse site, which is where Big Jim's is now, the pet resort. And then there was an area that was the remainder commercial office that was approved for 121,000 square feet. That was the initial approval in 2016. And then this is the amended plan that was approved in 2019. So here are the changes. You can see that north parcel, which is now the Oasis. It was originally approved for 220 units. They added 34 units there. So it's 254 residential units. They eliminated the option of the 251,000 square feet of commercial office for that piece. And then at the same time that they did that, if you look over in the area that we're talking about today, they reduced that commercial office square footage from 121,000 down to 50,000. From what we've been told, they just thought that was what they would need, and so that's why they reduced it. Unfortunately, based on what they have assigned in terms of square footage to those parcels that are either already built or under construction, there's essentially nothing left for this parcel. So this is a 3.3 acre site that I think has about maybe 3,500 square feet of commercial office entitlements left. And so that's why we are before you today. What the applicant wants to do is a warehouse flex space. This could be used for, vendors out in Lakewood Ranch, contractors, things like that, which I think is a needed use. Is also a very low traffic generator, so we think it makes sense for this site. And with that, I'm going to turn it over to Bob.
Good afternoon, Mr. Chair, Commissioners. For the record, my name is Bob Schmidt with Land Planning Associates, and I have been sworn. Scott laid out the reasons that we're here in asking for this square footage, and I will try to, thank you. Try to simplify things just a little bit. Just in the way, when he did the explanation, all that's left is about 3,500 square feet, and this site can accommodate about 50,000 square feet of what Scott mentioned with the office or warehouse flex space. It's generally a small office in the front with warehouse in the back, often used by contractors and people like that. So since the entitlements are essentially gone, we would like to get the entitlements on this piece, which as you can see is really an infill piece. And without the amendment to this GDP, really nothing can go on it. And so that's why we're here asking for this approval. The lot's about 3.3 acres, as Scott said, and with 50,000 square feet, that would only take our FAR to about 0.35, which is well below what's allowed in PDMU and the MU future land use category of 1.0. As I mentioned, this is an internal vacant lot. The entire Lakewood Ranch, or Lorraine Corners Northeast, has a master stormwater system, and all the infrastructure is in place. Water, sewer, all the roads. Now, we know State Road 70 is under construction to the south, but the perimeter of the project with 59th on the north, Post on the east, Lorraine on the west, and State Road 70 on the south, all the internal infrastructure is completely completed in that area. The trip generation rate for a office flex type, warehouse flex type space such as this is only 17 p.m. peak hour trips, which is substantially less than what could have been built if they were going to use commercial and office. That's like 260. So it's substantially less, and this is also in an area, as we know, where there's a lot of existing development, 10,000 homes in the general area. I was mentioning to my client that I recently did a renovation looking for contractors, and there is industrial space out here, but it's not real close, and I used a contractor from West Bradenton to come out to my house. So this would reduce trip lengths for people who would work out of these office warehouse flex space uses. On the south, as you know, State Road 70 is under construction right now, and according to FDOT's website, the segment between Lorraine and Bourneside is scheduled to be complete in early 2027. That's probably before we would even be, we may be under construction, but we would not need a CO until probably that road is complete. So the other thing that I'd like to address is just compatibility. As I mentioned, there's no use like this near us. But if you're familiar with the area, the post office is a pretty large facility, a distribution facility. And you also have, Peace River has a maintenance yard there, and so does Schroeder Manatee Ranch. They've got an operations facility there. There's a fire station, and then there's the church at the corner. But I just bring that up because there is a market for this type of use here, and we are committed to that use as opposed to 50,000 square feet of commercial or office. And I did read the staff report, worked with CJ on this project. I think he wrote a fine staff report. I concur with his findings, and as a planning expert, we find the project consistent with the area, and we would ask for your approval being consistent with the Land Development Code and the comprehensive plan. And with that, I'll be happy to answer any questions, or Scott can help me if you need that help.
Sure. I have a question for you. You had a plan here, and you were going to build a certain number of residential units. You determined that the value creation and profitability and success of your project for 34 more residential units was more valuable than 50,000 or whatever it was, 71,000, whatever square feet of commercial, and you traded it in 2019. We have these DRIs with equivalency matrix. We hear it all the time. It's like, oh, let me get rid of a couple of this, and then you give me a couple of that, and it breaks even in terms of traffic counts and all this. 2019, before any of us came on the board, someone made a concerted effort to come here and talk to a board, and a board of this governing body decided, if you give up this, I'll let you have that. And then you took that, and you built that, and you leased that, and now you're coming back going, but can I have that back now? Did we borrow 50,000 square feet? I mean, what's the request here? It seems like you made a fair trade, now you want the trade back.
No, first of all, I just want to be clear. The people making all those requests were SMR, which.
Whomever it was, you're still bound by the chain of title of whoever made the request.
Yes, agreed. As far as we know, and just from trip generation statistics generally, there's no evidence looking back at the approval that that was a trade, that they had to trade trips, because 34 multifamily units to 71,000 square feet of commercial is not going to be anywhere close to.
If you're building warehouse flex that you just said is a low traffic count, it's probably pretty close.
That was already in there. So it wasn't a trade-off for the trips. We don't know exactly why they did it. What they told us was they didn't think they were going to need it. And remember, this is part of their northeast quadrant. So they have 6,500 acres that have limitations under the comp plan for what they can do. So it might have been that they were pulling from this site because they thought they were going to use it somewhere else, but it didn't have anything to do with we needed to trade it for trips. At least from what I can see.
Okay, that's fine. For the interest of time, we'll just say that the same day you got additional residential units, you simultaneously got less commercial, purely coincidental. And that was not a trade, it was just same day, by chance.
They voluntarily reduced it on the other site. That's what I'm saying.
Fair enough. And your intent of this site, if it's approved, is to build warehouse flex space.
That's correct.
Why?
Our client thinks there's a need for this in Lakewood Ranch. I mean, I think the board heard a little bit of this at the last meeting. There was an application on Lena Road that had a similar type of use proposed, and they talked about how they're servicing Lakewood Ranch and they have to come from Sarasota. Our client sees the same type of need.
So you're pretty stuck on that. That's what you're building with this.
Yes, that is the intent, yes.
All right. I'm not going to get into deliberation because I make everyone else try to follow the rules, so I can have that conversation later. Commissioner McCann.
That area this morning, was pretty flooded. Can you tell me what flood zone it's in?
Yeah, it's in the staff report, Commissioner McCann, I believe. I don't have it in front of me, but I don't believe we're in a flood zone here.
Oh, I've got you in flood zone A. Project area is located within a 100-mile floodplain pursuant to Braden River watershed. Area of known flooding, yes. Rainfall. It flooded from last night. The power was out on Lorraine Road. The development is required to reduce the pre-development allowable discharge rate by 25%, but it is a known flood zone. FEMA flood zone A. Communities have a higher chance of flood due to their proximity to ponds, lakes, and other large bodies of water, and there's a 1% annual risk of a major flood, on a yearly basis there.
Stormwater has already been handled. There's a master stormwater system for the entire area. So I'm not a stormwater engineer, so I can't answer your question directly, but I live very close to here too, and I have never seen any flooding in this area.
Well, it flooded this morning from last night's thunderstorm.
I didn't go out there, but in any event, my experience has not seen any flooding in this area, and there's no residential in this area except for the apartment complex, the Oasis. So I don't know how to answer your question. I wish I did, but I'm not aware of any flooding.
And you also said that 70 is going to be done in 2027?
Early, that's what yeah, if I have the document here from FDOT from their website if you'd like to see it.
Okay, I don't need to see it, but, you know, I have the documents from this morning that were on the site here that say that your access is on 59th Avenue East and on Lorraine Road.
59th Avenue East and Lorraine is the perimeter, 59th. The only place that this particular site takes access from is Garnett Trail.
Okay,
And Garnett Trail is it's the internal road south of the post office that connects over to State Road 70.
okay, thank you.
Thank you.
All right, I have no one else on the board. I will go, who is this? CJ.
All right, good afternoon, CJ Mills with staff, and I've been sworn. Again, this is for Lorraine Corners revision to the approved GDP. I think we know the site location at this point. I do want to, I think it's probably a good opportunity to point out, so the flood zone is a mixture of A and X within this plan development mixed use. Per the FEMA flood maps, it looks like the flood zone areas are contained to some of the wetland areas and the lakes, not the actual parcel that they are requesting to build on. Again, this is a general development plan for 50,000 square feet of additional entitlements, warehouse use. You have the 1.0 FAR in the MUC AC1 future land use category, as Mr. Schmidt said, it'll be coming in on the property itself at right around 0.35, but overall the entire PDMU would be around 0.10. And as he also stated, the access is going to be from Garnet Trail that leads off into State Road 70 and Post Boulevard. Again, this is just the specific area right in the center that is a vacant parcel where they'll be requesting to construct. A little bit of history on it. It was part of the Northeast Quadrant comp plan amendment, comp plan map amendment, approximately 49.7 acres, 76 acres. In 2016, it was rezoned to PDMU. With 573,500 square feet of commercial and office entitlements and 220 permitted dwelling units. And in 2019, it was reduced from 121 to 50,000 square feet, and increased from 220 to 254 dwelling units. You have the future land use category MUC AC1 that does intend to have these commercial uses there. We are in the PDMU that does have the complementary groupings of the residential, commercial, office uses there. This is a transportation link capacity analysis. You see State Road 70 adopted level of service as C, and with the project approval, it would still be operating as C. Lorraine Road is adopted level of service as D, and it would stay that way because of low trip generators for those warehouse uses. Some of the positive aspects of the project is the increase in buildable square footage allows for the complete utilization of an area previously approved for mixed use. Warehouse uses are among the lowest trip generators, and the project is not expected to generate additional PM peak hour trips as there are no significant changes to the previously approved entitlements. Negative aspects, the project area has no access to Manatee County transit routes. But again, these are warehouse uses, so I don't foresee a lot of people needing different modes of transportation to get there. From a land use perspective, staff's not found any negative aspects regarding the request. And in conclusion, the request can be found to be consistent with the policies of the comprehensive plan and compliant with the applicable reviewed standards of the Land Development Code.
Thank you. Commissioner Ballard.
So just to be clear, so in 2019, there was an increase from 220 residential dwelling units to 254.
Yes.
Is there a proposal to reduce the residential dwelling units right now, or just to double the commercial entitlement back to what it was in 2019?
The request is just to, for the additional square footage, the 50,000 square feet, the residential component of the GDP has been completed.
Okay, thank you.
Commissioner McCann.
The 50,000 square feet that we just gave them, what date was that?
The 121,000 square feet reduction to 50,000 was in 2019.
Okay, didn't we just have a land use meeting where we granted this 50,000 feet for commercial use?
Different parcel. That was a parcel.
Oh, I think that was across the street. That was not on this project.
Okay.
Any others? And Commissioner Bearden, just so you know, if you're on, I can't see the Zoom right now while the slides are up, so you'll just have to chime in if there's anything.
I'm good for right now,
All right.
Chair.
I will open this up to public comment. Nobody signed up for, Tal, did you want to speak before? Oh, okay. There is no public comment. I will close public comment, and you were just here 5 seconds ago. Anything new, CJ? No? Applicant?
Thank you, Mr. Chairman. As Bob mentioned, this is a development pad right now. This is a platted commercial lot in a commercial subdivision with stormwater system, roads, buffering, everything in place that is just going to sit there if there are not additional entitlements granted for this project. I am concerned that the board thinks that this was a bargained for exchange that occurred in 2019. And if that is the case, I would ask for the opportunity for us to be able to go back and provide evidence that that is not the case. I mean, I can tell you that that trip generation is not close, but if the board really thinks that that is what happened and that this property owner is essentially going back on something that they traded for before, if that is a concern in this case, then I would ask that the board give us the opportunity to go get a traffic consultant engaged, go back through the historical records and show that that was not the case.
I mean, that's not my deciding factor, honestly, but I can't speak for everyone on this board. So, I mean, again, you can do what you want to do. I'm moving on to deliberation.
All right, I appreciate that, Commissioner.
Sure.
Again, I think we are in agreement with the staff report. I think it's clear that it meets all the requirements of your code, and we're asking for your approval.
All right.
Thank you.
Thank you, sir. Commissioner McCann, this is your district. Would you like to say something first, last? Where do you want to fall? Okay. Commissioner Siddiq.
Thank you, Mr. Chair. Like some of you, I find it a little bit sus that this is somehow on the same day. We're seeing a trade of
Stick with our generation,
entitlements.
dude.
I did that on
Let's
purpose.
talk about the riz of the project.
Cap. But look, joking aside, because we all need to wake up a little bit too. I am concerned, but perhaps it's not the same property owner, but irrespective of that, there's a conscious effort by prior boards to, I'm just going to call a spade, do a trade for density. So an increase in 30 plus units, and he traded away, what was it, the report says, 250,000 square feet of commercial entitlement. This is the kind of thing we get hit for all the time. We just see developments approved, they come back later, and they want to go back, or maybe another property owner, but in general, the area reverts back to the original entitlement, and then now we're dealing with concerns from residents about this. This is also, to me, it's just one of those cases where it's not just about trip generation. You got a Taco Bell to the south, you have Premier East, Northeast. Perhaps there are better uses that are more compatible for this area. It seems to me this project just looked at an empty parcel on a side street and said, let's just throw in something that, will generate fewer trips and maybe an approval from the board, rather than thinking comprehensively about the rest of that community. So I just share some concerns around that, and I'll leave it at that.
I just have a statement to make.
All right, go ahead. I've been trying to put myself on the board.
You can't see me, Mr. Chair.
No, go ahead. I can see you now that we're back on, so go ahead.
Okay. My main thing is, I mean, if we continuously to do this, like what precedent are we setting by repeatedly amending this GDP, particularly to add entitlements beyond what was originally approved? So we continue to do this over and over again. And so if we continue to do this, right, what type of precedent are we setting by just allowing people to continue to do this over and over again? I mean, there's going to have to be a time where we say, okay, this is it. You guys come back like 4 or 5 times, like, you know, I don't know. That's just me putting my 2 cents into this. So that's all I have. Thank you, Mr. Chair.
Thank you. And I want to talk about precedent a little bit, but the opposite, I guess, if that's a way of doing it. Applicants listen to this board, and they try to get guidance, because we never give clear guidance, because every other day it's a different tune to a lot of things, but they try to catch some sort of common theme. And right now, this common theme on this board is we want less traffic. Traffic count's lower, LOS is higher. Doesn't matter what you're putting on there, just make sure no put graveyards and self-storage facilities and warehouses everywhere, because that lowers traffic count. We don't care if it lowers quality of life, because there's nothing to do here. Just make sure the traffic count's low. That's our #1 priority. It doesn't matter. Well, then you get warehouses and you get self-storage. You don't get thoughtful developments. You don't get thoughtful growth patterns. You know, people want to vote no on public shopping centers, even though that inherently lowers traffic count, because you put the groceries and the shopping closer to people's houses, but people don't want that. Here's the problem with this parcel I have. It's not you building on it. It's that you're trying to build on it based upon a variable of lowest traffic count for the least usable thing you can put on there. This entire parcel, no offense to your client, this entire parcel is terrible for the sake of the community. Like, we've got our no pun intended, premier sports facility next year. We're building a massive swimming facility here, and pickleball courts, and we have tournaments every weekend over there. My daughter plays there every weekend, apparently. And every time we want to go to lunch, because we're between games, everyone has to get in a car and pile out endlessly into these roads that just fill up all over, because everyone has to drive someplace unless you want to go to Taco Bell, which is overloaded with people because it's the only thing you can walk to. There's no hotels there. There's no restaurants there. There's no entertainment there. There's no nothing there. This place was almost intentionally built for the least usable things for our most usable tournament facility. You've got self-storage, you've got a tire place, you've got a pet resort. I mean, you might as well put a funeral home. What else can you put in here? Like, it serves no purpose for something like that. And now we've got a potential, I thought it was supposed to be on this agenda, a potential of changing up some of our Premier to start putting some of the amenities that we need in the area onto our own property, which I have a problem with. Not to jump the gun on that later conversation. So it's like, you're not afforded a right to do anything. And the question always becomes, and we've had these conversations up here, what's the community good? I do think there's a potential community good for this parcel. I do think there's a benefit to the overall community, and we got a high school going in, we've got soccer fields going in. If I thought someone was building something that was a community benefit for the good of Premier, good of the high school, good of the area, I would be open to listening to it. Do I think you're afforded a right to build anything? No. The argument that this is just going to stay vacant, that's okay. Some things can just stay vacant. That's how it works sometimes if you use up all of your space. If you bought a huge parcel of land, decided to just happen to build one building taller, but you said, but I have more footprint available, well, that doesn't mean I just let you build something else because you chose not to build it in a different way. You chose what you built, and you used up all your development rights. So my problem here is I don't think what you're proposing has any benefit to this community whatsoever. You don't have an inherent right to do it. And it's part of an otherwise lazy plan that has had a negative impact on a community amenity that we've spent a lot of time on. So if you wanted to come back with something more thoughtful that I believe is a community benefit, I'm not adverse to the development. I'm adverse to development as you're planning to do it, and I do not believe you have the right to do it. So I believe I have a right to say no as a result of that. So I will, in fact, be voting no on this based upon the current plan. Commissioner Feltz.
That was a very nice pontification. I wish that you'd applied some of that to our previous discussion, because it's pretty much the same thing. You asked a question: what benefit was this to the public? But I guess it's different because it's Lakewood Ranch, and maybe you're just not as familiar with District 1 and what the people in District 1 have had to deal with for the last 8 years. But I'll give you one on this. I'll have to say, and again, I was talking, I will have to say that this is really a cluster when it gets to traffic over here. If you're out there, you've seen it during the soccer games, be happy with your 50,000 square feet because your little Garnet Trail is going to become a racetrack between it. Again, I agree, unbelievably, with Commissioner Cruz, even though I wish he would have expressed those same things about stuff in my district, which seems to be a free-for-all. But the traffic on getting out of those areas, getting into Taco Bell or out of Taco Bell, because we got a Taco Bell, it's horrendous. Getting into Lorraine Road, I don't know who designed the traffic flow, and we didn't have a traffic study on this. It was waived. Let's just, I think with a little ingenuity, you could do something with that property that is really going to be more of a benefit, but now, again, is not the time. And speaking of the, we did have a bad rainstorm. Lorraine Road is totally unprepared for anything going onto it. It's still a 2-lane road, and we keep adding more and more. You're a little bit off of it, but I'll tell you, Post Road is insane during the soccer games. Absolutely insane. 70 is insane after the soccer games. There's probably some potential. I'd like to know what you're going to put in the space that you have, and I think that it has a lot of potential for it, but asking for more, as usual, the camel gets the nose in the tent, and then it's always more and more. But it's just not the right time right now, but there's a lot of potential if y'all want to come back with something that would truly be a benefit. I think there's some good over there, but the traffic over there is horrendous right now. You can't turn on to 70. You can't come out of those establishments on that side of 70 and make a left turn. You should look at the statistics on the number of accidents that have happened in that area from Lorraine and on into District 1. We got a little bit of a rough spot there, so my vote on this is going to be no.
Commissioner McCann, and I'm also accepting motions at any point in time.
I think we talked about this already, so, I'd like to make a motion to deny PDMU 1612 GR2 Lorraine Corners Northeast Revised GDP, Lakewood Ranch Commerce Park LLC, PLN 2407-0035- quasi judicial.
And the date's August 7th, before I get asked. All right. I have a motion to deny by Commissioner McCann, seconded by Commissioner Feltz. You can bring it up on the board. No one's on the board. Cast your votes now. Commissioner Bearden?
Aye.
And it is denied unanimously, 7-0. Moving on to item number 15, which we're all curious about where we stand on this thing. Ms. Knapp.
Item number 15 is PDR 2415 ZG Pope Ranch. It's a rezone of approximately 217 acres containing 2 parcels. Parcel A is approximately 188 acres and an approximate 29.1 acre portion of Parcel B. From general agricultural, coastal evacuation area, coastal planning area to planned development residential zoning district retaining the overlays. Generally located along County Road 675, which is Rutland Road, with 1 parcel commonly known as 16525 County Road 675, and approving a general development plan for 440 single-family residential units. And your staff presenter is James McDevitt.
Ms. Schenk, I'm asking, we had this discussion during the briefings. I mean, I've never seen a thing where somebody just asks for a continuance because of a full board and then comes back with the exact same plan. I mean, usually a continuance means we're just continuing where we left off, so where do we stand on here?
Well, I asked the case planner, Mr. McDermott, and he indicated he hadn't received any new information. You could ask for the record of the applicant if they have new information to submit, because they did ask the continuance. Not that I'm expecting anything, but
Understood, but there's a
just
difference between the word
record.
continuance and the word do-over. I mean, that's why I'm asking where this stands from your legal perspective. If we're going to listen to the exact same presentation, word for word, on the exact same cases, and then go through the exact same staff report and list the exact same public comment, to something that got as far as deliberation being over and a motion on the screen and 4 votes having already been cast, I'm asking your legal opinion about where do I go from here? I'm directing this meeting. Where do you expect me to start directing this meeting?
Well, for the record, I would recommend you ask the applicant, do you have any new information? They'll probably say no.
Applicant, do you have any new information?
No, Mr. Chairman, it's not particularly complicated. We asked for a continuance so there'd be a full board, so that you'd vote as a full board. You have a full board, and we ask that you vote.
Okay. Commissioner Bearden, you're on the phone, right?
Yes, I have not
All
dropped
right.
off.
Do not go anywhere near any like nursery schools or wherever there's bad cell set.
I promise you, I will not do that. I will vote on this project.
Okay, so where do we stand then, Ms. Schenk, now that I've answered your first question?
Mr.
Do I
Chairman,
just
No,
open this up for motion?
Deliberation vote.
We're
Mr.
already in
Chairman,
deliberation.
I'd like to put my my motion back on the board to deny.
Okay.
I'll second.
We have a motion to deny by Commissioner McCann, seconded by Commissioner Sadiq.
And for the record, the findings for denial brought back at the August 7th board meeting?
Yes.
Okay, move to deny.
Commissioner Bearden, how do you vote?
Aye.
And the motion to deny is approved 7-0. We have one more item, and then I got a commissioner comment, quick thing. Commissioner Ballard, is this you?
Yes, this is my item.
All right.
All right. So, first, I do apologize for putting this on without any accompanying documentation. I was under the impression until last week that it was going to be handled as a general code cleanup, the majority of it, and that it would be coming forward after the break, and that I would only be bringing forward a small portion of it after the break. But I think that staff wanted to get direction on it and wanted it to come forward hopefully before the break so that they could work on it during the break. So what I'm trying to deal with is 2 discrete issues. And the first are the definitions of recovery home and residential treatment facility. Our definitions and regulations don't match up with the state definitions.
And inclusive of the new bill that was?
Yes,
Okay.
yes. So it creates some loopholes, potential unsafe situations for people in neighborhoods as well as people in the actual treatment facilities. And so my biggest concern is with 531.46, residential treatment facilities. In 531.45, which includes all residential care homes except residential treatment facilities, our code states that the proposed development shall meet NFPA 101 Life Safety Code as required by the AHCA and all regulations specified by state law and county regulation. However, when you look at 531.46, which regulates residential treatment facilities, our code has no requirement that a residential treatment facility meet NFPA Life Safety Code or that the residential treatment facility meet state and local regulations. So at the state level, residential treatment is a licensed service component which requires licensure through the AHCA. So we have.
What are you asking for?
hold on.
Okay.
We have a residential treatment facility, which at the state level requires licensure through AHCA, but at the county level, there's no requirement to follow state law. So basically, what I'm saying is that 531.46 needs to be amended to add that the proposed development shall meet NFPA 101 Life Safety Code as required by the Agency for Healthcare Administration and all regulations specified by state law and county regulations. So I think that we need to do that. I also think that our definitions of each of the residential care facilities needs to be matched to state law. So it needs to conform with state law because they're highly regulated areas. They're managed by different regulating entities at the state level. And when we have definitions that don't match the state definitions, it creates confusion and it creates potential loopholes. So that's the first issue. That's the code cleanup issue. The second issue is certification of recovery homes. And so that would be done through the Florida Association of Recovery Residences. If recovery residences aren't certified, they can't utilize buprenorphine or medication-assisted treatment. They're not legally allowed to take in patients from licensed residential treatment facilities. Judges are encouraged not to refer to non-certified recovery homes. So, and the reason that this is important is that significant abuses have occurred in unregulated Florida recovery homes. The Recovery Coast, which is on the East Coast, has seen a whole host of problems in that realm. If you look up the Florida Shuffle, you'll see a whole lot of patient kickbacks, people who are sexually abused, forced into prostitution, patient brokering, all kinds of issues. Whereas if you go with certification, there's some oversight. You don't have those situations. You don't have people overdosing in a place where they're supposed to be getting treatment and getting into a safe situation. So at the state level, certification is voluntary. However, at the county level, we do have the ability to require certification. There's a strong incentive for certification because, again, if they're not certified, they can't take in patients from licensed facilities. They can't provide medication-assisted treatment, and judges are strongly encouraged not to refer to them. So what I'm asking is for a motion to direct staff, two motions, to direct staff to bring forward an ordinance making the changes to definitions as well as 530, as the change to 531.46. And then I guess the second motion would be to research recovery home certification and bring options for that back to us based on what some other counties and municipalities have done.
Well, those two, you can make a motion, you don't have to ask to make a motion.
Well, I will, yes, so those are my two motions.
Full-fledged commissioner,
Well,
so,
motion number one.
okay. I don't know if they caught motion, everyone. Did you guys memorize that?
Hey, George, I'm on the board.
No, I know, there's people on the board, but, I mean, we can always make motions. We can still dialogue about the motion. And I have
I just have a quick question.
I have Commissioner Sadiq. Well, the motion's coming up for discussion, and we had a second by, who?
Commissioner Sadiq.
And Commissioner Sadiq seconded the motion once you get it up, but Commissioner. Yeah, motion, the first motion. And Commissioner Sadiq, you're on the
Which
board.
I'll refer to as the code cleanup motion.
There we go. Oh, you're up.
Thank you. Appreciate you bringing this forward, Commissioner. I think it was similar concerns, especially looking back at some recent projects. Two quick questions. Any cross, any codes or any fire district overlap? Because they have codes that can tend to cover not I don't know about residential treatment facilities, but assisted living facilities.
That,
Any overlap is the question there.
is there overlap with fire district issues?
With the Florida Fire Code, any regulations, because I found that out with vacation rentals, that they tend to rope in there's quite a bit of Florida Fire Code that can overlap with
I think there,
potentially this.
I am
suspect there
certain
will.
that there is. I am certain that there is, because there is a local provider who struggles with Florida Fire Code issues. So
Okay.
my guess is yes, absolutely.
Okay, second one, I suspect this would be something that falls under code enforcement, so they would have a certification program, or is this some other department that typically deals with this?
So my thought is that the certification would be through the Florida Association of Recovery Residences.
Oh, okay.
Actually checking to make sure that these organizations are in compliance. I'm not sure if that would go through public safety or through code enforcement. Again, that's why it requires staff research and collaboration.
Okay.
So I think it would kind of be a couple of different departments who would be part of it.
Well, I certainly share a concern over the mismatch between state and local codes, so happy to support this. Thank you.
Thank you, Mr. Chair. I got just a quick question. I appreciate you bringing forward the different definitions because I'm trying to figure out which one I'll be in shortly. But with regards to community residential home, sometimes we see that people bring like 4 or 5 people into a home and manage that. Are they requiring licensure too to be, I mean, the community resident home, which we deal with, which is 7 to 14.
Sure.
Unrelated residents. And we know we have some fire issues with our fire districts on that.
That would not fall under recovery home.
Okay.
Unless they are providing that kind of drug treatment
Okay,
aspect.
so like the group that does that, there's some of those folks are in recovery. So it
Just
would
because
not,
they're in recovery doesn't make it a recovery home. Do you see
Okay.
the kind of distinction?
okay, all right, cool. No, I was just trying to find out what dictates someone having to have a license through the state of Florida to operate a care facility, and what threshold is there?
Sure. So
Because
I
you could have
think,
somebody bring in 5 people in their house, they're not licensed, and next thing you know, we got the issues we have.
sure. So I would say, an ALF, that's going to be required to be licensed.
Yep.
A residential treatment facility is absolutely required to be licensed. A recovery home is a voluntary licensure, but if they're not licensed, they're restricted in some significant ways by the state.
Okay, cool, thank you.
And then the community care home, I'm not sure that requires any kind of state
Yeah.
licensure.
All right, Commissioner,
have
thank
a
you very much.
statement.
Thank you, Mr. Chair.
Whenever I have an opportunity.
Oh, I got Commissioner McCann on first, and then I'll call you. Commissioner, go ahead.
I just want a clarification. I want to ask the county attorney to make sure that the motion to approve is actually sufficient in its language.
I think it's perfectly fine.
Commissioner Bearden.
Okay.
Yeah.
I'll say, so my question would be, all right, if we over-regulate private recovery homes, would that violate the rights of individuals seeking faith-based or alternative paths to recovery that may not fit the state's medical model?
I think
That's
that,
one of my questions. And then the other one would be, I mean, obviously recovery looks different for all different people. It's not a one-size-fits-all mandate. And I think that this might stifle innovation and faith-based approaches that operate independently from the medical industry complex. So that's why this is kind of like we got to kind of figure this thing out to make sure that it's not going to punish those that may be faith-based recovery centers.
and I would agree with that. I would strongly agree with that, actually, Commissioner Bearden. And I think that faith-based programs have an absolutely integral place in the recovery world. I'd say, most of the best, most established recovery methods do include a faith component. My understanding is that there is absolutely room in the FAR certification for faith-based programs, and that is not at all a portion of the certification. But again, as this comes back forward and staff is able to provide us the information, we can ensure that that's the case.
Okay.
Are you good?
Yes, I'm good.
All right. Well, I have a motion on the floor by Commissioner Ballard, seconded by Commissioner Sadiq. No one is on the board. I'll open this up to public comment. Seeing none, I will close public comment. Commissioner Bearden, how do you vote?
Yes.
That is approved 7-0. Motion number 2.
Okay, and so motion number 2 is to bring back information and a proposed ordinance on FAR certification for recovery homes in Manatee County. Is that? Yes, Florida Association of Recovery Residences, FARR.
I would just modify your motion to say direct staff to research and bring back.
Yes, what Ms. D'Agostino said.
Do you agree with that?
Yes.
So we have a motion by Commissioner Ballard, seconded by Commissioner Sadiq. Nobody's on the board. You can cast your votes now.
Can I jump in real
Commissioner
quick?
Bearden, how do you vote?
So it says, just a
Wait,
quick,
we're in the middle of voting. You can't talk during.
well, clarification on the motion.
We already voted.
Not yet.
Everyone's voted except for Commissioner Bearden. Commissioner Bearden?
Yes.
It was just two parts of the same thing. I did public comment the first one. That was
Okay.
approved 7-0. Commissioner Sadiq.
No, I just noticed it says to research recovery home certification and bring options back and a proposed ordinance. It just seems a little bit unclear with and bring options back. I think the intent was just to bring a proposal for an ordinance, so. She did?
Yeah.
Bring back was the first time and ordinance was the second time. So.
As long as you're getting an
So,
ordinance back, I don't
Yeah,
care.
I'd like to have a proposed ordinance. That is the motion.
Yeah, okay.
Okay. Are you done with your item?
I'm done, thank you all.
Okay. My thing, I was just going to bring up during commissioner comment, but we might as well just get it done so we can finish up vote stuff, then I'll reopen public comment. This isn't on here because it literally just came in yesterday. It actually went through Commissioner Rom because they didn't realize he's not chair this year. Every year, LECOM gets money from the state as an appropriation, and every year they ask us to write a letter just supporting their appropriation that they received so that the governor doesn't veto it. So we sign this letter every year. I did not want to sign it as chair without the approval of the board because I'm not signing it individually. If you want me to, I can read it. It just says, "Dear Governor DeSantis, on behalf of the Manatee County Commission, this letter is to respectfully request your continued support for funding provided to the Lake Erie College of Osteopathic Medicine in Bradenton. The legislature provided funding for LECOM, the amount of $350,000 in specific appropriations. 436, this funding will be used to provide reduced fee and charitable care services to populations including low-income, uninsured, and homeless in LECOM's network of clinics and provider organizations. Through the creation of its College of Osteopathic Medicine, School of Pharmacy, and School of Dental Medicine, LECOM has invested in excess of $75 million in Florida to date. LECOM is significantly increasing its investment in Florida through a planned $60 million partnership with Jacksonville University, creating the region's first four-year medical school located at JU's Arlington campus. LECOM plays a vital role in meeting Florida's need for physicians, pharmacists, and dentists, and has implemented an impressive clinical education program that partners with hospitals and healthcare providers across the state. As you know, statistics show that healthcare practitioners typically remain in the community where they complete their training. To that end, LECOM plays a vital role in meeting the need for skilled healthcare professionals. Last paragraph. LECOM is the nation's largest medical college and osteopathic academic health system. As a leader in student-centered and medical innovation, LECOM produces more primary care physicians than any other U.S. medical school, as recognized by U.S. News & World Report. LECOM offers the lowest tuition among private medical schools nationally and has the lowest private medical school tuition in Florida. We are proud of LECOM's investment in our community and respectfully request your continued support for their efforts. So I just need authorization from this board to allow me to sign this on behalf of the board.
Does that have to come in a form of a motion or just say, you can do it?
Pam would like a motion.
All right. Mr. Chair, I'll go ahead and make a motion. I'd like to make a motion to support to authorize you to sign the LECOM support letter that will go for their appropriations.
I'll second that.
All right, we have a motion by Commissioner Ron, seconded by Commissioner Sadiq. I'll open this up to public comment. Seeing none, I will close public comment. Commissioner Bearden, is your hand raised relative to this letter or because you have a comment for Commissioner Comment?
No, just, it's fine. I'm good.
Okay.
I'll go ahead and lower it. Had it lowered. Yeah, I'm a yes.
Okay. We have a motion by Commissioner Ron, seconded by Commissioner Sadiq. We'll do it verbally. All in favor, please say aye.
Aye.
All opposed? Is approved unanimously. Thank you very much. I will sign this.
Thank you,
once
Mr. Chair.
The date is corrected.
I didn't type it.
If I said no, I'm an osteopathic physician.
Yeah, that would have been awkward at your next osteopathic convention. All right, I am now going to reopen up public comment for future agenda items for anyone who did not speak this morning. Technically, no, but it's not worth the argument. Go ahead.
I kind of purposely waited, Dalton, Nelson, Manatee County, till the end because I wanted to see how today played out. And I'm glad I did because I think there was a lot of really good discussion that happened today. And I want to bring up something that you brought up actually today, sir, Mr. Chair. I have texted, well, not texted, but called, emailed, wrote letters, all sorts of stuff to all the different representatives, both in the House and the Senate. I've probably called Governor Ron DeSantis's office over 60 times in the last couple months, trying to both get, different parts of the state organizations involved with this issue that we have here in Manatee County, which is the flooding issue. As you point out, it is a very valid point that the state seems to consistently trample our right to have home rule and to make our own decisions, and they don't believe that we are big enough boys and girls to manage Manatee County as the prospective people that live there. And to be honest with you, I don't really think they care about what their constituents say or don't say, because the developers up there grease their pockets more than what we have to say. That's just my opinion, because the trends have been going more and more in the developers' favor and less in the people's favor. And we come up here and we say what we want to see happen. I've seen it time and time again. Look at the Terra vote. There were, a couple, 20, 30, 40 different Terra members that came in here in opposition to their deal. And, they got a fair shake out of it. But not all the time in this forum have we gotten that fair shake in regards to certain things. People get discouraged and they don't want to show up. And I want to say that you guys all deserve a pat on the back for making the right decision today. I think that you guys are doing a fabulous job, to be honest with you, and you deserve a gift basket or something. I'm going to try and make that happen. But
Don't send gifts, we can't take it.
I won't do that, but it was just a figure of speech kind of thing right now. But you guys are doing a really good job, and you're actually listening to what we have to say, and we really do appreciate it, even if other people come up here and yell at you for it. What you do does matter. We just want to make sure that you guys are following what we're saying, and you're paying attention to what we have to deal with every single day. Nobody knows their own community better than the people that live in it. So I appreciate it, and I appreciate the opportunity to speak today. Thank you, guys.
Thank you, Dalton.
I'll be quick. Chris Whitaker, Manatee County. I was sworn in this morning and I was on this more when I got to speak, and thank you again for letting me speak again real quick. For the record, I did go golfing in between presentations. I didn't know if my dishonesty on the scorecard when I went was going to affect me coming back, and I had to be sworn again or anything like that. But I didn't have to speak at the Pope one, so thank you so much for letting that go. But I would like to clarify one thing for you guys. If I had issues with the development around my property, just myself and everyone else supported the development, I'd not be here. That'd be selfish. And, I'm here because of my community brothers and sisters, which I feel we do come from a small community, so there's not many of us. Not all of us get letters just because our properties are so far apart. But the ones that do show up here, they've been here a long time, and they're very good people. And I thank you so much for just hearing us. And I'm here because of them, and we share the same concerns about the direction and safety for our community currently. And we're at a critical period and have been forced to educate ourselves and speak up so we have a chance at protecting our land, our families, and many of us have been here for a long time and just love living here. I was going to just bring up real quick for future agenda items. We've been getting some good denials on some developments, which I really appreciate. And it does boil down to infrastructure and just 675 in the road. I know it hasn't been in the budget, or it's not in the budget until quite a while, and I wanted to explore are there any other options we can do to get funding or just get it started or have answers to. Like, I was going to propose a toll booth at the, on 301 and then one on 64, so as soon as they get on the drag strip, they pay and then they go. Just little things like that. Are there any ways we can get funding? It comes down to the sidewalks, widening the road, or just making that road better. Because a lot of these developments, if they fit the community, they would be a big benefit if we had the infrastructure and our stormwater was updated and just little things like that that we all know about. I would stand on the road and hold up a sign and collect money if you guys wanted me to. It's my neighborhood, it's my people coming through there. So I just wanted to present that, and just if there's any other ideas you guys could come up with, I would love to hear some other thoughts and stuff. So, thank you.
All right, I'll be first in line for your bake sale. I have one person on the phone, caller 445.
Glenn Giblina, for the record, I did not speak this morning because I had to work, so I have an opportunity to do that now, and I thank you. A couple of things I want to bring up is one, I didn't get home in time to address the licensing of facilities. So I guess my question and concern is, we have a lot of halfway houses in Manatee and Sarasota counties, and if a homeowner wants to turn his home into a halfway house for recovery alcoholics or drug addicts, that's our choice, and if they're under the care of a doctor and they got to go get prescriptions, that's on them. I don't want to be burdened with regulations because I'm renting my room out to an alcoholic that's trying to straighten his life out, and he may have some medication, but that should not fall under my preview. I certainly hope you're talking about larger facilities and certainly not the one-off halfway houses that are in our community. I think it would be a big disservice because there is that niche for that missing middle from Centerstone to the halfway house to the large institution on a 28 or 28-day program. So there's a difference. So I hope you're not targeting halfway houses. My second comment is, again, on the agenda items. Now, I understand your concern. You can throw some last-minute stuff on there that's kind of like an emergency, but the serious stuff, like hiring this guy yesterday, is unconscionable that was not on the agenda 7 days in advance. Anything that's major should be on the agenda and the appropriate documentation for that subject matter, and you haven't done it. And I suggested, come back in a couple of weeks, right? And give the public an opportunity to vet this guy and see what he's about, right? George, you were laughing about it, but guess what? You just made a special meeting for tomorrow, so I guess that's okay. But when I make a suggestion, say come back in a few weeks to give the public, I guess that's not okay. That's very disrespectful. I don't appreciate it. And you have to straighten that agenda out. But I'm not kidding. You must put the important stuff 7 days in advance. Otherwise, do it to the next agenda, right? So I want you to think about that while you're taking your 6 weeks off and collecting your $10,000 in commissioner pay of why we can't get it straight. For the record, Glenn Gatsby, Gibellina. Have a great day.
We'll miss you, Glenn, for 5 weeks. It's 5 week break. There's no. I have a motion on the floor to extend recess by an additional 1 week per Glenn's request. No. Okay, that is all. I will close public comment. Ms. Knapp, do you have any comments?
No, Mr. Chair.
County Attorney. Commissioner Bearden.
Nope.
Commissioner Ballard.
Nothing.
Commissioner McCann.
None.
Commissioner Siddiq. Commissioner Ron.
Nothing other than everybody enjoy their time off.
Commissioner Feltz.
Of course I do. First off, just want to give a shout out to my peeps in District 1. Showing up is half the job, right? And getting her done, and getting the word out there. I'd also like to remind you that Commissioner Cruz will be in District 1 tonight at Rocky Bluff Library. I hope you'll have a robust discussion on our garbage issues. I've kind of got it covered out that way, but I'm sure you'll hear a lot about garbage issues tonight. And ending on a good note today. I really appreciate you handling that part because I've got enough problems over there. But if you would address that with the public, there have been some issues on that coming from District 1 that if you could assuage their concerns, that would be something to be addressed.
Make sure I have the video of you in the garbage can. Then.
Oh, yes, you may use it.
I'll put it up on the
joke
AV
was,
screen.
how many commissioners can you fit in a 96-gallon garbage can?
It's literally in her office.
And I literally crawled inside the garbage can, which I'll... Was it clean? Yes, it was clean.
We don't start using them until October.
Could be. And our work on the mandatory meetings, really the process is, I appreciate that, we were able to discuss it. We've got some work to do on it. We're going to come back after recess with something that I think we've gotten a lot of good feedback. I wanted the opportunity of our applicants to have a say-so in this because you do represent everybody up here. And this was the only way we could get that venue out. So I appreciate everybody's thoughts on the board. I appreciate the public weighing in. I appreciate our applicants weighing in. And I think we're going to come up with, nothing's going to be perfect, but it's going to be better than what we've had before. So I appreciate that. And last but not least, y'all probably aren't out in our area, but we've been getting some really bad rainstorms out there, out east. It seems like just a few months ago, I was worried about a drought because I have animals to feed that depend on rain. This is Florida, either too little or too much. So drive safely out there because it was in torrents and it's very spotty. We seem to have gotten the worst of it out east. We've got water over the road in some places just from our rains this morning. So it may be a little bit different in your neighborhoods, but where we're at, we have clogged ditches. We've got invasive grass growing in our ditches that's clogging it up. And we've been getting a lot of dumps of rain that are really testing our stormwater issues out there, which is a great opportunity. It's an opportunity to look at how things are functioning now before we get into hurricane season. So thank you very much, and have a great time tonight, George.
Yeah, and two things. One, yes, the town hall was listed as tentative because I wasn't sure how long this land use meeting was going to go, but fortunately with a couple of continuances and we are done in time, so I just posted up on Facebook that it is a go, so 6 p.m., Rocky Bluff Library. I will be there for the last town hall before summer recess. And as was also mentioned, tomorrow morning, 9 a.m., don't forget, we've got a special meeting, not one I just called today, it's one I confirmed attendance today. It's strictly to vote on moving to the next step of our block grant funding. So it should be a very quick meeting, but a very important meeting, because it's $250 million that's heavily going towards stormwater and other issues associated with our hurricane. So we'll get everyone in here, we'll get that voted, and we'll start that process so we can start fixing things here in Manatee County. With that, if there are no other comments, I will see most of you tomorrow morning, and if I don't see you, have a great recess, and I will see you end of July.